a senior individual at the hospital. You've got, perhaps you've got it late, but you've got the documents. I'm assuming that your experts now seen them.
Mm-hmm. Can we just, is that a ruling or is that a?
No, I'm just asking a question.
Sure.
Can't we just, do you have enough so we can just go and finish this trial?
If forced to, yes, but we don't think that's adequate. And the reason is this case has had risk management central to it since before the court came on as a presiding judge. It's been up to the Second District Court of Appeal on this issue as to whether risk managers are sufficiently managerial to have the authority to bind the hospital and a punitive damages award be appropriate or upheld. So for us to attempt to unring the bell, unwind the clock over the course of 72 hours over the weekend, we think is severely prejudicial. So we have laid out a menu of options for the court in our request for relief. We believe that this was manipulated, intentional, contumacious by a clear and convincing standard because, as the court noted on Wednesday afternoon, defense counsel in this courtroom serves as primary outside counsel for Johns Hopkins Children's Hospital. Under questioning of the court, defense counsel admitted that he had an entire set of closed files on his computer. In essence, there's no way that as we were proceeding through this case, defense counsel was unaware or forgot about all of these systemic, cultural, and retaliation issues that were at the forefront in 2018 and 2019. We believe that conduct is severe enough to warrant the striking of defendant's answer and proceeding this morning on damages. If the court thinks that's too severe, we think that given the history of this case, having been up to the Second District Court of Appeal, that the court should direct a verdict on punitive damages if the jury, after deliberation, believes that we have proven battery or false imprisonment, the counts that are subject to punitive damages. We have been unable to develop the evidence on that over the course of the past 5 years, given the withholding of information. Third, if the court believes that is not appropriate, we have suggested, and it sounds like the court may have weighed into these. So I heard something about potentially a directed verdict on negligent training. We think that could be an appropriate sanction. Third, and in combination with others, striking the testimony of Mark Anderson and giving the jury an instruction to that effect that his testimony was unreliable and misleading because even from him, material and relevant evidence was apparently withheld. Fourth is what the court suggested a moment ago, that we proceed this morning. We cobbled together, and we have prepared an exhibit list, if that's how we do this today, with some of the more critical documents that we received on Friday evening. And we put Dr. Corcoran back on the stand, and he has the ability to talk about these issues and how they affected the hospital in 2016 and 2017, the time of my submission. And fifth, regardless of what the court finds appropriate from what we've presented here, sanctions against the hospital, attorney's fees for all these efforts, taking the deposition. I don't know how far back that we need to talk about that, but those are our suggestions to the court.
Okay, thank you. Sure. Mr. Hunter.
Please, court. I'd like to address first Your Honor's question regarding how we proceed this morning and what's necessary to proceed this morning. And in order to do that, I need to make clear to the court most of the information that was set forth in our filing on Friday of Angela Green's affidavit as well as the disclosures that we filed. If you go back and you look at Dr. Corcoran's testimony.
Can I ask a question though?
Yes, sir.
So you file Ms. Green's affidavit and you file a motion for clarification, and in none of those did you attach the immediate jeopardy finding of what brought us here. Why did we omit the actual immediate jeopardy finding from your affidavit and from the motion?
Well, the point of the affidavit, well, first of all, the immediate jeopardy finding was in a letter dated 1/31/19, and that has been provided. But
It was not sent to the court as part of the affidavit. It wasn't part of your motion for clarification.
it was not,
I mean, you attached a whole bunch of other things saying how wonderful everything is, but you didn't attach that.
yet, yes, sir, because the point of the filing was that the immediate jeopardy finding was immaterial and did not relate to the period of time that Maya was in the hospital.
So
And if I-
when I said to turn it over, you didn't immediately turn it over to the plaintiffs. You didn't even attach it and send it to the court. I mean, what am I missing here?
I think you're missing, Judge, what we're trying to get across in terms of what brings us here and what the real point of Your Honor's order was and what the real point of the testimony at issue here is.
So when I say
And
to turn over the immediate jeopardy finding, you're going to interpret that not to turn over the immediate jeopardy finding?
No, sir, Your Honor, we turned over the immediate jeopardy
When?
finding. By Friday morning, I have a list here of about 30 or 40 different documents that we had turned over to the plaintiff in less than 48 hours after this all occurred. I've also got, since then, a list of about 170 others. We've provided nearly 1,500 pages of documents that include the immediate jeopardy finding. Counsel interrogated Ms. Green in her deposition regarding the immediate jeopardy finding. And the immediate jeopardy finding, as she explained, was based on a site visit that the CMS did in January of 2019. If you read the report of that, which she testified about, you will find that all of the information that they gathered and all of the conditions that they addressed were set forth in that letter and related to that time frame. There was
I mean, when I went to look to actually read the immediate jeopardy finding, you didn't attach it. So how am I supposed to read it if you didn't attach it?
Judge, my apologies for not attaching it, but again, the point of the affidavit and the point of our filing was to attempt to clarify the basis on which there was any suggestion that the immediate jeopardy finding was relevant to the hospitalization here at issue. What I was trying to get across to Your Honor, and obviously unsuccessfully, is the fact that the premise of Dr. Corcoran's testimony is based on two things. One is that the immediate jeopardy survey took place in September of 2018 and was a quote, look back, unquote. First of all, there was no survey in September 2018. And secondly, the surveys don't look back, they look forward. And that's the second point of the filing. It was to establish the fact that at the time of Maya Kowalski's hospitalization, what Dr. Anderson, or Mr. Anderson testified to, witness Anderson testified to, was that we were in good standing with JCO and CMS. The point of the filing was that we documented that that was in fact the case, that certificates had been issued in 2015 and in August of 2018, indicating that we had been reaccredited and that accreditation, barring any other activity and barring any other violation, was good for 3 years. The period of time that was covered by Mr. Anderson's testimony, Ms. Kowalski's hospitalization, was in the fall of 2016. During that period of time, we had been accredited by the Joint Commission, and we've got copies of the certificates we've provided. They're attached to the motion. The point is that the entire premise of this, that the immediate jeopardy finding was somehow related to the status of the hospital at the time of Maya Kowalski's hospitalization, is simply not true. There was not, the immediate jeopardy did not relate to any of that. The immediate jeopardy did not base its findings on anything that took place during Maya Kowalski's hospitalization or that was even reviewed at that time. The point we were trying to make, simply put, is that Mr. Anderson's testimony, however brief and however summary, was simply correct to the extent that we were in fact accredited at that time, and that there was nothing untruthful or misleading presented otherwise to this jury. That was the point we were trying to make.
Was there a culture? Did any governmental agency or the Joint Commission talk about a systemic failure of the culture at the hospital?
There was a discussion of that finding. There was a discussion of failings of plans that took place in January of 2019 that did not relate to anything that was occurring in the fall of 2016, 2.5 years earlier.
How
There
do you
was
say
not-
that? I mean, am I just to take your word for it? I mean, how do I know that when the plaintiffs just told me they got evidence of systemic problems, which apparently Ms. Green talked about in her deposition?
Your Honor, with respect, Ms. Green talked about in her deposition findings that were made at the IJ in January of 2019. If you look at the report that resulted in the IJ, it's a report from CMS that has been provided that actually indicates what the basis of the IJ was. And it talks about interviews and it talks about evidence that was gathered in January of 2019 during a site visit between January 7th and January 11th of that year. And then it relates some of those failings to its interpretation of policies that were adopted in September of 2018. None of that reaches back the preceding 2 years to when Maya Kowalski was a patient. The whole point of this is the whole premise of Dr. Corcoran's assumptions, and it was an assumption. He looked at that report. He saw the date of September 20th, 2018, and he assumed from that there was a Joint Commission survey at that time that resulted in an IJ. That's been proven to be incorrect. And also it's been proven that was not a look back situation. So the whole premise of this, the whole point of this is not what was going on at the time of the IJ and the findings that were made regarding the IJ in January of 2019. The point of this case and the things we're trying to litigate here took place in the fall of 2016, 2.5 years before. And there is not anything that has been produced that I'm aware of that relates the IJ or its findings or its basis to what was actually happening on 7 South or 7 North where Maya Kowalski was a patient in 2016. The proof that we put forward in Angela Green's deposition, and she's here to testify if need be today, Judge. The proof that we put forward, simply put, was that the IJ related to the self-report of the Heart Institute and the Heart Institute alone. If you look at the report, if you read the report itself, you see talk of governance, you see talk of infection control, you see talk about contractual duties, but when you look at when the interviews were in each item of that report, it talks about interviews that were conducted in January of 2019 and the findings that were made in looking at documents over at that period of time or over the preceding 4 to 6 months. It says nothing about looking back 3 years or 2.5 years to this period of time because it simply didn't.
Did Ms. Crane lose her job because of this issue?
Ms. Crane lost her job because of the Heart Institute issue and the failure to report deaths and the failure of oversight regarding those issues. If you look at this, Judge, I apologize, Judge, but I didn't mean to cut you off. And I want your questions. I really do. The point of this is, however, that if you look at the sequence of events here, there was in fact a self-report to the Joint Commission. It was oral, and then it was supplemented with a written report. The other two reports.
The self-report occurred because there was a media report out there already. Is that correct?
That is true, but there had been reports and there had been discussions beforehand.
Well,
There,
wait,
if you,
wait a second. Did the hospital report to whether it's the Joint Commission or any governmental agency prior to the media outing the hospital on the issue?
there was a report and a review that took place in the spring of 2018.
A
When-
report, a report. Who's reporting what to whom?
There was a media report then regarding a heart case that was reported by the hospital to the Joint Commission. I believe, I don't have it right in front of me, I believe there was also a report to ACA and or CMS. There was a site survey that took place at that time. There was a review done and there was a follow-up and the deficiencies were cleared. There was, in addition to that, the entire triennial survey, which took place in August of 2018. Those documents were attached to the motion. There was none of these deficiencies found or identified at that time. So what happened here was there was concern regarding the heart program. There was an effort to address that. The regulatory authorities came in, they did a survey, they found the deficiencies addressed. There was a subsequent triennial review in August of 2018 that resulted in a reaccreditation that renewed the accreditation that was in effect at the time Ms. Kowalski was in the hospital in from September of 2015. So at the time of her hospitalization, the hospital was in fact accredited by the Joint Commission. It was in fact accredited and in good standing with CMS. There was no indication otherwise. Those facts were reaffirmed in August when there was another triennial review. When this hit the fan, so to speak, with the media report, that was self-reported. That was self-reported that day. And 2 weeks, 3 weeks, nearly a month later,
The same day.
CMS came in with an unannounced survey and made
The
their
same
report.
day.
They left.
As the media
They
report.
did not
Bullshit.
find an IJ at that time. They issued the IJ on January 31st, 2019. We had 10 calendar days in which to respond. We responded. There's all this correspondence has been provided. That the issues that were raised in the IJ, according to what we sent to them at the time, correspondence from one of our senior officials, said basically, here's the plan we had already put in place by the time of the report. Changes were already underway. Here's the plan we had already implemented. Then, in addition to that, there was a proposed plan of action to address the IJ and address the deficiencies. That document was provided. Then there was another on-site visit that took place in February 20th and 23rd, I believe, of 2019. That resulted in the IJ being lifted with a plan in place that we had to abide by. We abided by it. There were subsequent follow-ups and it was cleared. But the IJ was lifted, Judge, in February of 2019 by CMS. And obscured in all this is the fact that at or about the same time that CMS was conducting its follow-up survey regarding the IJ, the Joint Commission was also in to do a follow-up review, and that was cleared. There were no deficiencies found. And so what I'm trying to get to is this, and the point we can show you what happened with the IJ, we can demonstrate all that, But what I don't want to get lost in all of this is this central bottom line fact. The issue that brings us together into this conversation today is the question of whether Mr. Anderson's testimony about the standing of the hospital regarding JCO or CMS, whether his testimony was incorrect or misleading. And the answer to that question is that it was not. And
Yes.
there's no basis, there's no indication in the record otherwise. All you've got to suggest otherwise is testimony that is based admittedly on supposition. Okay, when Dr. Corcoran testified, he indicated that he had never seen a Joint Commission document regarding an IJ. He had
said
never
saw it in the
seen
newspaper.
any indication that there was in fact some survey in September of 2018, and that's for good reason. There wasn't one. And the point that I'm trying to get across to Your Honor is that at the time of this hospitalization, there was in fact a certificate issued that had been issued that had never been revoked and never been abrogated, that Johns Hopkins All Children's Hospital was accredited by the Joint Commission, and there was no indication from CMS otherwise.
So what is your suggestion, your game plan for today?
My suggestion, Your Honor, that if this issue is that problematic, that the jury be instructed to disregard Mr. Anderson's testimony with reference to JCO,
Oh, sure.
and
Just forget all
CMS,
about it.
and that
Just
we proceed.
we want them to forget all
We
about
would
it.
like to go ahead and
Disregard.
proceed with the case. If
No way,
at the
man.
most, if we believe that putting this entire issue before the jury, first of all, is going to result in more misleading and more confusion than anything we could possibly do otherwise. We've been trying over all this weekend
He
to
just sat
conduct
up.
discovery
For all the
and
birds, okay.
conduct what amounts to a reopening of discovery with reference to matters that are fundamentally immaterial and that are fundamentally prejudicial in the sense that any prejudice far outweighs the probative value. We've been litigating and investigating a purely collateral matter. And Judge, I think we're at a point where the best and most conservative management of this situation is to proceed. And if there is some clarification, limited clarification that counsel feels the need to address in rebuttal, then let's do that. But I would implore the court to look at the circumstances and look back de novo at what Mr. Anderson actually said and what Dr. Corcoran actually said, and see that there isn't any indication that this jury was misled. There is a brief reference to this entire matter. And we're going off into a collateral matter that is going to be fundamentally confusing and highly prejudicial. And if we go down this road, we're going to have more problems than we could possibly imagine.
So when witness Mr. Anderson is asked the following question, let me talk to you about your overall view based on what you've reviewed.
Oh,
Did
Judge.
it appear to you, based on the materials you reviewed, the records, the policies, that all Children's Hospital had an appropriate safety plan in place for patient care? Answer: yes, they did. So,
Your Honor?
so I mean, that is something that the hospital adduced in front of this jury.
Yes, sir. And at the
And
time,
now you're telling me the door was not open.
Judge
I
doesn't
mean, that's
buy
what
it.
you're telling me?
what I'm telling you, Judge, is two things.
He's not
Number
buying it though,
one,
Hunter.
If he were to be called back, if we can get him back, if he were to be called back, the proof would be that at the time that he referenced that statement, as of the fall of 2016 and 2017, the Joint Commission on the Accreditation of Hospitals had reviewed the safety plan in effect in 2015 and issued an accreditation based on that. And there's a
Let me ask
certificate to
you
prove it.
this.
And then,
Let me cut you off. Did you even provide witness Mr. Anderson with any of this information that we've been discussing since Wednesday afternoon? Was he provided any of it?
Yes, sir. We sent,
He was provided the information?
I,
Because we had an issue
No,
with
no, no.
what was produced
Oh.
to Mr. Anderson, witness Mr. Anderson. So I want you to be very clear as to what was
Burn, covering
specifically
his mouth.
produced to witness Mr. Anderson.
Oh my God.
Very, very specifically.
since Wednesday,
Judge is pissed.
he was sent the certificates.
I don't care what happened since Wednesday.
Oh,
At
God.
the time
Oh,
he
my God,
testified
Hunter.
to this jury, had the
Oh,
defense
no.
even provided
Oh my God.
any of the information that we've been discussing since Wednesday?
No.
May I ask Mr. Shapiro to address that, Your Honor?
Mr. Shapiro, do you
I'm
want to
just
step
like,
into
I
the
don't
breach
wanna-
here?
Well,
Step
only
into
to
the
extent
brief.
that he was provided hospital policies and procedures yesterday.
That doesn't answer my question.
I did not provide him joint commission surveys, no.
Oh.
So I don't know if he looked at anything online, but to my knowledge, no. My understanding of his just to explain, my understanding of his testimony, Your Honor, is that the fact that the hospital was able to operate at that time meant that they had gone through joint accreditation surveys. That was the simple basis of his statement that he volunteered.
Didn't even provide the information. Okay, what's
Oh my
next,
God.
Mr. Hunter?
Oh my God.
I just point out to the court that we have been
Yes.
scrambling very hard to try to
Yes.
provide as much information as quickly as we can. And I believe that this issue can be addressed either with an instruction, a curative instruction, or some summary disposition. I think if we go full scale into it, we're opening a whole nother trial.
Let it in.
Well,
They did this.
plaintiffs are telling me that if I don't go into it, I'm getting another entire trial anyway.
Oh yeah.
Okay, we are where we're at. Anything else, Mr. Hunter, that you would like to say before I let Mr. Whitney have a very brief rebuttal, and then we'll talk about what we're going to do.
I don't believe so, Your Honor.
Mr. Whitney, very brief, please.
I need to dispel a couple of notions.
Oh yeah.
First,
Do it.
that these issues were limited to 2019. And what was produced to us Friday evening during the deposition, we have an ACA statement of deficiencies dated February 23rd, 2017, specifically for risk management deficiencies. The specific violations relate directly to patient rights, coordination of care, and patient family education. That was less than 1 month after Maya Kowalski was discharged. We provided that the first time from ACA on Friday afternoon. The statement of deficiencies and the corrective action that we were provided. Mr. Hunter just represented this court that surveys don't look back, they look forward. That's absurd. They have to look back. And in the corrective action plan at page, I don't know what page, I can pull it for the court if we need to. The Patient Safety Committee reported 12 retrospective Code 15s and additional Code 15 reported during the required time frame. They're not talking about the future. They're talking about the past. Ms. Green confirmed that in her deposition. In the corrective action plan provided Friday afternoon, the risk management department was not included on the organizational chart, included in the quality and safety plan. There was a failure to have them report to the medical executive committee, the president, the board, or the integration of risk management into the hospital organization structure and quality assurance program. There was found to be retrospectively no evidence of risk management reports or data collection in the past 15 months and no historical data related to objective indicators of quality, all retrospective. The failure in the plan of correction, the governing body failed to ensure management of the organization. That's how that begins. The interim president accepted the resignations effective immediately from the president, vice dean, the VP Chief of Staff functioning as lead executive of risk management, the Chief Patient Safety Officer, and the VP of Marketing and Communications and Culture. The Director of Risk Management was replaced by someone in the role of Vice President of Medical Affairs. Mr. Anderson's testimony, you know what, the court already spotted the issue, that exchange about patient care. This goes directly to patient care. The last thing I'll say, Your Honor, is that we've been at this for just under an hour, and we admit that this is a lot to put before the jury on the final day of what's supposed to be the final day of this case. For that reason, we think directed verdicts are the most appropriate way to deal with this. Rather than bringing in Dr. Corcoran, introducing 15 documents, bringing in Mr. Anderson back, they want to bring in Angela Green now and have a mini trial on this issue. We think directed verdicts are the appropriate remedy.
Cannot unring it. That's right. I heard Anderson. You cannot unring this bell. You cannot unring it. It's been
The
rung.
court has before it the question of sanctions filed by the plaintiffs against the defense. Ultimately, I'm going to be reserving on the question of sanctions. That's a bigger issue than what we have time to address today. And there's a lot of concerning issues that we'll ultimately have to work through. I need to address where we are right now, what we should do and what we should not do. I've got a situation where the defense knowingly and intentionally presented evidence to this jury that everything was fine about at the hospital at the time of Ms. Kowalski's admission. There is evidence out there that can be viewed that there is a systemic culture of problems, especially centered in the risk management department.
Mm-hmm.
Now, absolutely, without a doubt, it does seem that the driving force was this Heart Institute issue, but there is a view of the evidence that plainly and without interpretation could be seen as being more persuasive or pervasive than just isolated to the Heart Institute, that there's a view of this evidence that it is systemic, and systemic means systemic. And when we talk about culture, and I hear what the defense, they want to view, well, look, this happened in 2018/2019, so you can't look back. Culture, however, is not something that you just turn on and turn off. It's not like a
Exactly.
light switch or
Nope.
buttons on this wall that I can't figure out how to turn on and turn off lights. But it goes to the essence of what an organization is. And that takes time. And a 3-year look back from a time that we know that it was spotted by regulators, both governmental regulators and otherwise, suggest, or at least there's a view of the evidence that a jury could find that this pervasive culture existed at the time of Maya Kowalski's stay at Johns Hopkins All Children's Hospital. You know, this culture might even go all the way back to the time of Johns Hopkins purchase and acquiring of the hospital, which was, I think, 2011 or 2012.
Mm-hmm.
So I now have a situation where the defense presented everything is fine. And I think it's appropriate and required for the plaintiffs to rebut the evidence that the defense presented.
Wow, we're going to try it.
This jury.
We're going to try it.
Now, that being said,
I think
this is not a deep dive into what happened in the Heart Institute, what happened.
Bring on
but
Dr.
it goes
Corcoran.
more broadly and more high level as to what the culture was and the problems that existed, what appears to be admitted by Johns Hopkins All Children's Hospital. And I think if the jury hears that at the high level, that is an appropriate response for the plaintiffs to rebut what the defendants presented. And then we'll let the jury make the decision as to whether it's relevant or not relevant.
Oh boy.
I don't think we need to get into a situation where we have, 14 days of testimony as to what happened in the lead up to, okay, you can call them self-reports, but if they happen because the media outed you, I'm not sure it's a self-report, but be that as it may, we'll call it a self-report. So I do think that there is a way we can proceed. So this is what I would suggest. Apparently there's 2 more boxes of materials. I see the plaintiff has his expert here that you spend this morning going through the documents and let the expert come on the stand and testify at about 1:30 today. Hopefully we can finish the evidence. And then I can give jury instructions this afternoon and the parties can do closing arguments first thing tomorrow morning. So, Mr. Whitney.
I was only going to,
Thoughts?
yes, I was only going to say, I think there's a lot of those boxes, but we're not going to be able to have time to explore all of that. And I think we have an hour and 20 minutes left in our rebuttal. I think our preference would be to, with what we have here, there's enough to put in front of him to discuss this at a high level now.
Strike his testimony, though.
And well,
as counsel said.
And the other remedy, of course, striking the Sharon's testimony. But in terms of timing, that's what I'm speaking to right now, is we prepared an exhibit list with 5 or 6 of these critical documents.
Anderson wants to strike his testimony?
This morning and hopefully wrap this thing up.
May I be heard for just one moment, since I'm the one delivering the closing? Judge, we can't unring that bell unless we strike the testimony of Mark Anderson. If the court recalls, juror number 1 asked a question which reaffirmed their point about whether the government had passed judgment or had accepted, or whatever you want to call it, approved of the actions of Johns Hopkins, that there were no problems there. You can't unring that bell unless we do something to let the jury know that that was highly questionable testimony. Because even if we come back here with some rebuttal, it's still in the jury's mind that the other guy said, well, but the government overall, they found that they were okay. And I know juror 1, at least, who's asked the most questions, has been, it was a concern to him. So we move the court to strike all or the significant portion of expert
That's the
Anderson's
juror that
testimony.
they
or
want to
else
get rid of on
we
the other
have
side.
an incredibly uphill battle to get around that.
Well, I hear Mr. Hunter, he's making a full-throated argument that what happened in 2018 has no bearing going back. And, if that's the argument he wants to make to the jury, then why should I preclude him from making that argument and presenting evidence to that effect?
I don't say that he can't make some sort of argument. I'm saying that the particular phrase that there was the government passed, approved, and I forget the exact quote, it's in our memo. Johns Hopkins, during this period, be stricken. And then however he wants to argue the rest of the testimony from there, fine.
Camera
But
out of her
the key
face.
point is, for those
These
jurors,
people.
that the federal government had passed on the conduct and the management of Johns Hopkins. And that is at the core of our case, particularly punitive damages. So if we cannot get that out of the jury's mind, because let's face it, it was procured through lack of production to us and some highly questionable representations. If at the time we had had that stuff, we could have attacked it and we could have done something about it. We did not have that option. The testimony needs to be stricken for us to have a level playing field. I don't know any other way around
Well,
it as trial
if
counsel.
I strike the testimony, then why
Then you
would I
don't
allow
take-
you to present any information to
Right.
the jury?
Right.
Well, that's an interesting question, whether we even need to go that far. If we strike his testimony, the jury is to disregard it.
Well, you want to know what's even more interesting in my mind is how does this impact your punitive damage claim if the risk management department wasn't reporting up? But I mean, that's another question, but
Anderson should not be
Regardless.
fighting for striking the testimony. Open the door.
I don't know.
Let the
That's-
jury
I've had nothing
know.
else going on this weekend to think, so.
This is just as awful to have this at the last minute. We spent the weekend, instead of me spending 100% of my time on the closing, dealing with this issue because we were so worried about the impact it would make over on.
I hear what you've said. I'd let you speak when it really was Mr. Whitney. So, Mr. Whitney, was there anything else you wanted to say before I let Mr.
Don't-
Hunter have an opportunity to comment on my
You're
game
gonna
plan?
let him comment again?
Judge, you made the point I was going to make. If you're going to permit rebuttal, then an instruction would make that pointless. Obviously, we've made the record.
Listen. There's going to be an appeal any way you look at this. No matter what happens, this case is getting appealed. The appeal, I don't know why anybody's worried about an appeal at this point. It's going to happen.
You know how we feel, but Your Honor's game plan, I would suggest that if you issue an instruction, there's nothing for them to rebut. So I think that the two things there are mutually exclusive.
But
I
how can I
agree.
strike his testimony, the
You
witness's
can't.
testimony at this point, when you've just made a full-throated argument as to why it doesn't matter and why the information you presented to the jury was legally correct? I mean, I feel like I'm in between a rock and a hard place here.
I can identify with that feeling, Judge. But my point simply is, I think going further, my point was and is going further with this is ultimately going to do more harm than good. And it's going to create more confusion and prejudice than otherwise would be the case potentially to both sides. Now, if he puts on a rebuttal, you've heard what I've said. I don't have any choice but to approach it that way. But I would just suggest to the court and to all concerned that if Your Honor feels between Scylla and Charybdis on this, that the simplest and most direct approach may be an instruction. And I'll just leave it at that.
Plans move the court for 5 minutes to discuss the matter with appellate counsel. This is a big deal, and the court presents a very cogent argument about which one and how.
Well, I'll give you the 5 minutes, and then I've got a jury on ice right this second, and I've
Yes,
got to
sir.
do something with the jury. But unless I hear something fundamentally different when you come back after having discussions with your various appellate counsels, it seems like the options that exist at this moment are, one, me striking the testimony of witness Mr. Anderson with some type of instruction to the jury that they're to disregard it, and then no rebuttal on this issue. Or two, you get some ability to present rebuttal today, hopefully maybe right
That's
after
the other
lunch,
option.
and then we
Present
will
it.
do closing arguments tomorrow morning. I'll try to instruct the jury this afternoon so that we can do closings in the morning, and then they can start deliberating at lunchtime. So, or maybe a little bit after lunch. So that seems to me to be the two paths that I can walk at this moment without
I don't know why plaintiff would want
I think those are
striking
probably the
test-
two best options I've got in the situation we find ourselves in. So
The court's disqualified on that.
take 5 minutes, and I'll be back. Let the jury know it's still going to be a few more minutes before I can get to them. Thank you.
All rise, close and recess.
I have no idea why they would want to why would they want to strike? Why would the plaintiff want to strike that testimony? The testimony is super good for the plaintiff because it opened the door to saying, look at these people. They had an immediate jeopardy finding, and they represented to you, they lied to you that everything was good and hunky dory. At the okay, I'm taking this moment to refresh my StreamYard because my camera's doing the bad thing again. So hang tight. I'll be right back. You will be thrilled to know that I am looking into new computer systems. I'm trying to figure out what the heck I need to do to make this situation better. I, over the weekend, spent all this time deleting and freeing up memory on my computer. I freed up like over 80 gigs and it did nothing. It did nothing. It did not help at all. So it's not a memory problem. It's not a hardware problem because it also happened while I was not connected to any of my hardware while I was doing the local stream. So I don't know. I think I'm going to have to get a new system. So that's where I'm at right now. And thanks for the compliments on the hair. I hate my hair today, actually. It's not all the way dry, and I don't like what my curls are doing at all. There's some pieces over here that I don't like the way it feels. I may have to do a rewash. It's not dry all the way, and I don't know. It's looking a little limp and weird to me, but no, the camera's not built in. It's brand new. It's an external. How old is my computer? Not old enough. It's not old enough to be doing this, but I just think that it's a MacBook Pro. It's a laptop. It wasn't built for this. It wasn't built for this kind of streaming. Um, my dad, my dad. Stop talking about your hair, Nick Campbell. There is too much joy here. I can't even think straight to meme. The Schadenfreude is overwhelming me. The ADHD overstimulation is real. And by the way, locals chat is open and the memes are plentiful. Get over there. The meme farmers are hard at work. MeganFox.locals.com. You got to get over there. It's so much fun. All right. Rafe, if you're having problems on locals with the tip function, just go to support at locals.com, send them an email, show them the screen grab, and they'll fix it for you. Okay, promise, because normally it works just fine. Billy Marie, thanks for the super chat, says this has to be the most exciting trial yet. So glad we get to watch it with you, Megan, and I'm so glad that you're all here watching it with me as well. Jason J, thanks for the $2 super chat, says, can the judge rule the case unappealable? No. All the cases are appealable. All cases are appealable. That's just the way the system works. And absolutely, this case is going to be appealed either way. If the defense wins, the plaintiff is going to appeal. And if the plaintiff wins, the defense is going to appeal. Unhung Hero, thanks for the super chat, says, some pennies for the new computer fund. Thank you. You cleared storage, not memory doesn't help. Well, wait. I did, though. I freed up a bunch of storage. Isn't that the point? Like, what are you saying? Memory and storage are different? I don't know. They're still out. Court's still out. And my camera is still laggy. And I'm not even sharing now. As soon as I share the screen, it's going to get worse. Yeah. Yeah, Nick, you're right. The striking is appealable no matter what is decided, it's appealable. I do not understand why the plaintiffs would want to strike the testimony. That testimony of witness Anderson opened the door. It opened the door to all of this stuff about the IJ and about the culture of intimidation and retaliation, which was in the report. And like the judge said, culture does not turn on and off with like a light switch. It's not something that just happens it's suddenly in 2017 there was a culture of intimidation. No, it's been going on for a long time. She was there in 2016 and they want to tell you that the culture of fear and intimidation and retaliation started in 2017. Bullshit, bullshit, bullshit. Hey, by the way, I didn't even get to say good morning to you guys because we had to come right in here and I was still blow drying my hair, which is still not done. I really need to get that fixed. If I don't blow dry it all the way, it's just gonna get ugh. But we had to get in here and get started. And so I did that and I didn't even say hello to you. So hello, it's been a long weekend. I know that you've all been waiting for this. Monday is spicy day in court. And by the way, I found my rosary. This is my one that I made. I'm keeping it handy in case the seventh floor coven. So I made this out of my daughter's. So my daughter had this clay phase that she went through, and she had a lot of where she was making miniatures. She had a lot of leftover colors, and so I decided to make beads out of them. And it's like all this swirly, pretty beads. And I made a 10 bead decade that you can repeat 5 times. That a rosary would be 5 times over. So it's not like a full one, but it's one that I use. Uh, and I love it. I made all of this. I used my cross. I have a necklace that I made a mold out of, and then I pressed the clay into it and I made the crucifix. And yeah, it's a really cool thing. I made a bunch of them and we gave them away. And yeah, it's a chaplet, right? There's a difference between a rosary and a chaplet. You can pray the same prayers, and it's just a reminder. If those of you who don't understand prayer beads, they started with monks, and they would tie knots in the ropes, like tie a bunch of knots in ropes, so that when they were walking or doing whatever they were doing, they would have their hand on the rope and to remind them where they were, to remind them were in their prayers, just to remind them to keep praying all day, pray without ceasing. And so that became um, popular because it was a good way to continue your prayers and remember where you were. And and so then it became a thing. Can I put them in my shop? No, this is one of a kind. I may make some more though, if you guys would like some. Maybe I'll make some more. It was a really fun uh it was a fun thing to do. We spent a lot of time, me and the girls, doing this. So maybe I'll do some more. All right, looks like court is still not back. They are still on their 5-minute break or whatever. But you guys have been really great over on Locals. If you're not on Locals, you're missing out on some fun stuff. Over the weekend, we watched The Verdict together, meganfox.locals.com. We watch movies together. We do all sorts of stuff. And we do cooking streams sometimes. I should make one with mini Shopkins. I have enough of them around here. My kids were captured by the Shopkins craze. John Shopkins All Prisoners Hospital. Yes, that's Maya Kowalski versus John Shopkins All Prisoners Hospital. And we know what these people are, right? We know, right? They're kidnappers. That's what they are. The only thing that would make this better if it said John Shopkins All Prisoners Hospital. Mm, you guys are so funny. You guys have been making so many great memes. And by the way, let's not forget that Court TV is seriously a twat waffle this morning for not putting the camera on Hunter so we could see his face. And I wish somebody could figure out how to make this for me to cover up the law or Court TV or the law and crime, law and cuck, what do you call it? Logo. But I'm technologically challenged. I can't figure that out the way other people do. So someone has to do it for me. But that would be fun to put the twat waffle right there, right over the logo. Yeah, that's a problem. No, I have hardly any tabs open right now because of the camera issue. Yeah. I know I need to make an overlay, but I've not been able to do it. I've tried and tried and tried, and it doesn't work. Mhm. Are you seriously trying to tell me how to do this in the chat comments? Do you know how long I've looked up YouTube tutorials on how to do it? I have I have tried and I have failed. You mean without the yeah, without the like I want okay, so look here. Look. So if I share the screen, hold on. Now the camera's going to go haywire. So I share the screen. See this law and crime logo right here? We need the twat waffle here instead. And that works with a StreamYard has this thing you can do with an overlay. But the problem is you have to make the overlay perfect to fit this entire screen you're looking at and be here on the logo right here. You know what I mean? Do you think it's StreamYard and Mac that just doesn't work well together? Have you tried a hammer? It's getting close. I'm getting close. Oh, the whole thing is it's just terrible. I know, like Nick does it, yes, but Nick has people who do those things for him. I want a stream overlay, but I can't get it. I can't get it.
Hey, please be seated, everybody. Starting with the plaintiffs, what are our thoughts at this point?
Our thoughts, Your Honor, are if it's an either or, we would, between an instruction to the jury striking the stranger's testimony or putting in some limited evidence and rebuttal testimony of Joseph Corcoran, we would take the latter. We would like to proceed in rebuttal.
Good.
We would prefer, even then, a brief instruction, but if it's either or, that's our preference.
And what's your view of doing it, let's say like at 1 o'clock today, give your folks time to
Whitney's shaking his head.
get prepared, your expert, if they need to look at the other documents, and then doing closing arguments tomorrow. Because remember, I still have to deal with jury instruction issues.
Understand. We prefer, Dr. Corcoran was here on hot standby this morning for a reason. He has a doctor's appointment this afternoon. We would prefer to proceed immediately into that. He has seen the documents we were provided. He was at the deposition. So he's, well, not fully prepared, he's adequately prepared, and we'd like to do it sooner rather than later.
We'll have some exhibits to add, I think.
And we have, I've narrowed down the exhibits that we would put in ahead of this.
Let's say the plaintiff, or the defense.
Judge, we would, if that's our choice and the Hobson's choice at that, we would
They want to
suggest
strike.
that it is simpler and more straightforward to do an instruction with reference to Dr. Anderson's testimony regarding JACO and CMS. We have one drafted that we can, hurriedly drafted, that we can show you. The other question that I would have, I don't know, we haven't discussed parameters of the rebuttal testimony proposed. And I would like to hear that, and I'd also like to hear whether or not we would be accorded some rebuttal on a very brief basis regarding this.
Why would I give Sir rebuttal when it was the defense that opened this door?
I don't know what the rebuttal is going to be, Judge.
Well, ultimately, like I said, I've reserved on the question of sanctions. I think the question of striking pleadings is probably not something that I ultimately would physically do, given the nature of this case. But I do want to give the plaintiffs an opportunity to cure or present evidence in rebuttal to the evidence that the defense presented. So, you know, I'm willing
It's coming
to
in.
do that this morning.
It's happening.
I do think Mr. Hunter has a point. We need to talk a little bit about the parameters. So what if we do the following? Over the next 30 minutes, we can discuss the parameters. We tell the jury to come back at, or to stand down and be ready to go at 10:15 this morning. We'll do the rebuttal case. I'll send them to lunch. We can work on jury instructions, issues, hopefully instruct the jury this afternoon on court instructions, and then closing arguments tomorrow morning. Does that,
Acceptable, the timing is acceptable, plaintiffs. As far as sanctions, we would ask the court to reserve on DVs.
on directed verdicts, reserve on directed verdicts? Okay. Mr. Hunter, anything further on that game plan?
No, sir.
What I'm going to do is I'm going to bring the jury in. I'm going to tell them we're going to take a recess until 10:15. So maybe they can go outside and stretch their legs or whatever, so they're not sitting cramped in their room. So let's bring them in.
Is he going to rule on the jury? He didn't rule on jury disqualification yet, though. What about that? When's he going to rule on that? Has he just decided to ignore it? I want to know. He needs to do the juror disqualification motion.
All rise. Jurors entering.
Maybe we missed it early this morning because, by the way, Law and Crime did not go live until it was already started. So we may have missed that ruling.
Okay, please
Yeah.
be seated, everybody.
All the lawyers who looked at it said he wasn't going to.
Okay, members of the jury, I want to confirm while you're away over the weekend, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct?
Correct.
And that no one approached you about this case. Is that correct?
Correct.
Now, have any of you seen any media accounts about this case, including any media accounts over the weekend or since you last were with us? Okay. Don't pull out everything right this second. I'm going to need a few more minutes to get us to the position where we can have the rest of our case presented to you. So it's going to take me, probably another 45 minutes or so. I didn't want you to have to sit there in that room for another 45 minutes. So I'm going to let you kind of go out, maybe go outside and walk around, whatever you all want to do. I am going to ask that you be back at 10:15, and so we can proceed. It's all on me. I'm the one that is slow and not getting us to where you want to be this morning, but it's all on me. So
He's
don't
lying
blame
about
any
that.
of the lawyers. It's all on me.
Certainly
So-
not him.
Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. And I'll see you back in about 45 minutes.
All rise. Jurors exiting.
Well, we all know that that was not true. It is absolutely Hunter's fault for arguing for like a month. Like, I don't know. What did he argue for, an entire hour about this?
Okay, the jury's out of our presence. Everyone, please be seated. Now let's talk about parameters. Mr. Whitney, do you have an outline, a plan, a thought process on this issue?
Your Honor, we have 7 exhibits that we would intend to use.
Okay, and what numbers are they? So we're
2811, 2815, 2817, 2818, 2819, 2821, and 2822. And so the rebuttal would consist of me asking some contextual questions of Dr. Corcoran and then proceeding to further contextualize that by showing him these series of exhibits. When we talk about parameters, I heard the court earlier that this is not going to be a deep dive into the Heart Institute. And I'm willing to abide by that. I think the challenge that the court faces is I would expect that the cross-examination of Dr. Corcoran would center around, this was all the Heart Institute, wasn't it? So I don't know how we deal with that issue.
Well, I mean, I think, well,
Judge, looking quickly at the exhibits they've listed, the Agency for Healthcare Administration complaint investigation, 2811. I don't, I'm at a loss to understand the relevancy of that to what Mr. Anderson said or how it relates to this. I should say witness Anderson. The emails from the 2017 was actually a forwarding of an email to me. It was an email that was sent to Ms. Green in real time that she then forwarded to me, and that was what was produced to the plaintiff. So, in other words, her email forwarded to me. So I'd like for counsel to come off of that.
Just wanted.
If-
Just wanted.
I mean, redacting out your name or reference to you.
Right.
I mean, I think that's what we've been doing with others that went to you.
Right. And then otherwise, that's an after the fact matter that we respectfully object to.
Well, I'm going to need to see these documents if you're objecting to them. So tell me which ones you're objecting to so I can make a ruling on them.
Shelby, I love homemade crocheted Christmas presents. What a
Object
great
28
idea.
2811.
Let's pull that up, please.
Your Honor, 2811 is what I referenced in my response to Mr. Hunter's argument. This is an ACA deficiency report dated February 23rd, 2017, approximately 1 month after Maya was discharged. The two specific citations. Well, first of all, specifically a risk management survey. If you look at the third paragraph in the left column. And the two specific deficiencies are patient rights and care, coordination of care. And the other is on page 8 of 14 at 2811-008. It's patient rights and care, patient and family education, both relevant issues.
Well, is there anything in this document that references out the Heart Institute or did you say 13 or 18 deaths that occurred in the Heart Institute?
Nothing in this document deals with the Heart Institute.
Okay, so can you go to just the next page just quickly and then
It's been redacted for patient identification information.
next page, please. Next page.
Judge, while you're looking at that, I'd like to call attention to the fact that it concerns itself with discharge arrangements and discharge planning.
Next page.
He's ignoring you, Hunter. Don't interrupt a judge or anybody else when they're reading, by the way. You can't read and listen at the same time.
Next page.
I wish I could read this. It's just too
Next.
fuzzy.
Next. Now, what on page 8 did you want to
I
highlight?
was just pointing the court to, if you see the far left column, at the bottom of the page is H023, and then it cites the specific Florida Administrative Code section for patient rights and care, patient family education. So there's two kind of overarching administrative code deficiencies in this document.
And this is a February 2017 document.
Yes, Your Honor.
Okay, next page. Next page.
You all are making me want to crochet. Maybe I should do some granny squares while I sit here. That would at least be productive. I have so much yarn in the basement. I should get some out and start a winter project.
Next.
Pale Rogue, they're going over the evidence that the plaintiff wants to bring in when it comes to
Next.
the IJ. The 20% has no clue what crochet is. Here's
Besides
to the
relevance,
20%.
Mr. Hunter, any other objections?
We love the 20%.
Yes.
Court's going to overrule the relevance objection and receive into evidence 2811. What's the next document? That Mr. Hunter, that you have an objection to.
Late for something, it's only productive if you do squats while you're doing it, while you're stress eating.
2817,
squat.
Your Honor.
Okay, so there's no objection to 2815, is that correct?
That's the immediate jeopardy notice.
Okay, so the court will receive into evidence 2815. Is there anything that needs to be redacted on 2815? Or has it already been appropriately redacted?
2815, Your Honor, is the CMS letter that was sent to the hospital on January 31st, 2019. Mr. Anderson gave you a copy last Wednesday. It's a matter of public record. I don't think it needs to be redacted.
I don't know of anything that needs redaction on that, Judge. It is public record. And that is the IJ notice.
So we're at 2817. This is the forwarding to Mr. Hunter. So can we pull that
I
up?
like this idea, testicular trauma. Stitch and bitch night, crafting night where we just drink tequila and pretend to make things. That sounds like a locals
So
event.
we would redact the top block, everything above halfway down the page where it begins with Angela Green to Susan Franklin.
So we can cover up the Howard
Yes, I have
Hunter all
3
the
of
way
those.
through external email, exercise caution.
Yes, Your Honor. That was just forwarded to him on Friday evening during the deposition.
Ooh, what's this?
Is there anything besides removing your reference in your name, Mr. Hunter?
Hold on. Howard Hunter from Angela Green to Howard Hunter. Subject. When was this sent? Wait, Friday, November 3rd, 2023. I told you getting the emails right after this happened was going to be huge. How about this for Kevin's talking points to board on CMS? Attachment. Kevin report based on CMS something. External something. I don't know what that says. Angela Green sent to somebody Franklin. What does it say? What does that say, you guys? I can't read it. Confessing that this is something deal. What does this say? Can you guys read it? Confirming that this is draft, something draft.
Is there anything else?
The only, it's just relevance, Judge. I mean, these are talking points for a board presentation, and I don't see the relevance of them.
Can I see the next page, please?
So if I could orient the court.
Sure.
The email you see there, Kim, addressed to Kim, CMS 2567 is the form number for a CMS statement of deficiencies, or what we're calling the immediate jeopardy notice. This is internal emails between the patient safety risk management teams at the hospital. If we go to the next page, They're developing talking points. Kevin referenced here is Kevin Sowers. This is the interim CEO brought in. And it discusses in a high level what they need to address based on different citations that were noted in that January 31st letter. Can we go to the next page, please?
Hey,
Next
Vices,
page.
get on in
Here
here.
governing body, this is an organizational level issue. And so it talks about the leadership transition, the resignations of 8 leaders. It talks about restructuring risk management. And it talks about the very bottom bullet point there is the massive education campaign, which talks to the fear of retribution present in the hospital during the time. Ms. Green testified that of these bullet points here, 5 of them were related to risk management issues. I'll stop there.
And is there anything on this document specifically referencing the Heart Institute or those 13 or was it 13 or 18 patient deaths?
There may be, in fact, maybe the previous section there, I see at the top it says something about institute. Can you go back up a page for me?
Don't ban chaos coordinator, Jeff. If you're gonna sleep
Yeah,
mod,
I mean, so
keep
number
the
1
phone
here,
away
half
from
of that
you.
page says halted all congenital open heart surgeries, meeting with families of children. This is the 13 deaths they discovered. Some of these are more general. Suppose we could print this out and suggest some revisions to eliminate Heart Institute issues.
This to me, the rebuttal is not going to go into the question of the Heart Institute and those specific patients' death. I don't want to talk about patient deaths
Okay, understood.
in rebuttal.
Understood.
So that type of information has got to be redacted. So anything else about this document, Mr. Hunter? I know we're going to take out your name from it.
Right. The only other thing I would point out to the court is that beyond the relevance of it, this is essentially a recitation of subsequent remedial changes, and we objected on that basis.
Mr. Whitney.
I see the court's brain working, mine as well.
Very slowly.
Me too. Can you go to back to the advance the page to risk management again, please? Page number 5 or 6, I'm not sure. There we go.
Judge, my point is the entire document is basically talking points on a report to the board about a response to these entire matters. So that's what this is.
So I suppose it's baked in here that these are measures that they are taking in response to the immediate jeopardy notice. However, they're also acknowledgements of the conditions that existed. For example, without fear of retribution is not a remedial measure. It's an acknowledgement of the culture of the hospital.
I agree with Mr. Whitney that this identifies the problems that existed and goes to rebut the evidence that the defense presented to the jury. So anything else, Mr. Hunter? Okay, so we're going to remove the Mr. Hunter information. We're going to remove the Heart Institute information. Otherwise, the court will receive as redacted 2817. Do I need to make that an A?
Probably.
Okay, so let's call it 2817A, and I'll need the plaintiffs to print out and give the clerk the redacted version.
We could have a copy just to compare, because I think I saw another Hart reference.
Excellent work, Wheezy Bob.
That, please do, yes.
We will work with counsel on that. The next is 2818. I don't know if there's an objection.
Can you pull it up? Obviously, we need to take out Mr. Hunter's name there at the top.
Understood.
Can't let the jury know Mr. Hunter was involved
was
in
this
all of
sent to
this
Mr.
now,
Hunter?
can we?
On Friday. Wait,
No, but did any of these emails,
this one, he was just, Mr. Hunter was the one printing out
It's
these emails
maddening,
on Friday.
Jeff.
right, I get it. But within this email chain was in 2019, was he on?
I have not seen his name. You can correct me if I'm wrong.
No, sir.
So we're taking his name off. Anything else in this document?
Is this the only data? sorry?
Next page.
Oh, it's been like this all morning, Jeff. All morning. They refuse to show us whoever is speaking, and it's really frustrating. As far as I know, they do not have a Twitter.
What are we using this
I
document
looked
for-
for them
this
because I was
document
going to
for,
blast
Mr.
them, but I
Whitney?
couldn't find them.
One moment. We're using this document because, Your Honor, this is attaching the draft corrective action plan, which if you advance to page. Not right? You advance to page 7.
You know, from now on, every
So,
time they do
what you
that,
have
I'm
here,
gonna
Your Honor,
I'm gonna put up
in
the
left
top
column,
awful
the
meme.
large left column, you
But
have
now I
the
need
statement
one
of
that
deficiencies
says
from CMS.
law and
And in the
crime.
right column, you
I have
have
this one, but I need
the
law and crime now.
negotiation between CMS and Johns Hopkins All Children's Hospital as to what will need to be done to correct the issues and acknowledgement of the issues throughout. And this is what I was referencing in my argument earlier with respect to certain pages that speak to 8 key executives leaving and risk management not being properly integrated, et cetera. So I would reference certain pages here.
Well, is there, again, going back to the Heart Institute / deaths, anything like that will have to come out if this document comes in?
I understand it's a long document.
How many pages is this?
121 pages. And that's the survey and corrective action. It's 128 if you include the email.
The way these things are set up, Your Honor, is you're sent this form 2567, whatever it is, and then the suggested plan to address it, the subsequent changes to address it, are put in a column that relates or correlates to the alleged deficiencies. So that's why the length is because of the format, if you will. But we point out to the court again that this is
They're
the
still on her face.
statement of deficiencies, and then it's a plan that is outlined in the
Locals, help
right-hand
me out.
column
I need this meme
to
with
address
law and
alleged
crime on it.
deficiencies that are the subject of this witness's testimony. So this is a document that outlines proposed subsequent remedial changes.
Well, let me just ask this. Is this a document that you actually need, or is it duplicative of the talking points? I mean, isn't your expert going to talk about it, and then does this document physically need to come into evidence if there's a lot of Heart Institute related things that would have to be redacted?
I don't think it's duplicative, Your Honor. I think the jury, given the impression they were given, needs to understand what the actual situation with the federal regulators was, and this is the best document to do that. And I can simplify this process by A309 is if you look back, it references failures at the governing body level. So those discussions begin at page 57 of this document and continue through page 79. And we could relatively quickly review those 22 pages plus the email to redact out Heart Institute issues
And then just redact the other pages that
and
are,
just leave out the other pages.
Judge, it is a chronicle of subsequent remedial changes. B, it is going considerably beyond the testimony that counsel is intending to rebut. This is going deep into details of multiple matters that have nothing to do with the very simple, straightforward statement that we're rebutting. And I'm looking at this is page 57. There's a discussion of a plethora of details of Heart Institute issues and indications, starting with ventricular shunts and hand hygiene and working its way down.
I suspect this is actually page 51 of the report, and it just happens because of the email is identified as page 57.
Oh,
So
yes, I'm sorry. Yeah, we need to
right.
move forward 6 pages. Next, there. That begins, you see in the middle column, A309. That's the governing body failure.
Can you make that a little larger, please?
Keep going, please.
Not wall watcher, thank you.
Well, again, this goes into, the top of it goes into the heart and diaphragmatic hernia program. Yeah, I think Your Honor may have hit the nail on the head as far as this thing being duplicative and unnecessarily detailed if you've got the other exhibits in.
this is what we're going to do with this document. The 20 or so pages that are, is it code A309 having to do, is that the one with the risk management component?
Yes, Your Honor.
Fine, okay. So you're going to just either redact out everything else or not include the pages. I don't care, but you know, it might seem better to leave the pages in and just redact it because the jury has been very curious about documents, but I don't care. And then for those 20 or so pages, we need to redact out references to the Heart Institute or those specific patient deaths.
By 10:15.
The art of the possible at this time. Miss Lawrence is working in overtime right now.
Understood.
What's the next? But once we do that, I will overrule the relevance objection and subsequent remedial measure objection and admit it.
And that, I'm sorry, Your Honor, just clarification. Court's letting in, starting on exhibit number 63, page 63.
Whatever the first page is with respect to when it starts talking about the risk management department issues. What's next? And that probably needs to be an A.
Understood. 2819 is next. This is internal. We will redact the top block with Howard Hunter receiving it on Friday evening. And then what follows is the management presentation. Next, please. There, we would just need this slide here. Talks about governance and culture.
Fear of retribution with speaking up. Holy shit.
And then the fifth page, 1005, talks about
Inconsistent practice and
failure
documentation.
to document adverse
Yep.
events,
Failure to
including
document.
disclosing our errors.
Holy shit.
That's
You're
what
so
we would ask
screwed,
for
J.
from that
Hatch.
document.
And then you're planning on redacting the balance.
We could redact the balance.
Same objections, Judge.
Same ruling as redacted. I will allow that 2819 into evidence.
2821, please.
Is this going to be just the letter or the letter and the attachments?
Right. The attachment, again, is the statement of deficiency, so we can forego that. However, the letter, addresses beginning on page 3, risk management issues. There would need to be some redactions here because the first one is the deaths from the Heart Institute.
Well, Mr. Hunter.
Same objections, Judge.
Okay, so obviously that B1A
That has to be
needs
redacted.
redacted out. And then the previous couple of pages that talked about the Heart Institute needs to come out.
Yes.
Is there anything past this
And then,
in the letter, not the attachment, but in the letter itself?
yes, Your Honor, if you go to section D, we get to governance leadership. And it discusses the ethics committee, which has been subject to some testimony here.
Welcome
else,
to the
Mr.
Fox
Hunter?
Den, Night Owl. Thanks for
Same
the
objections,
membership.
Judge. This is a chronicle of remedial change.
I overruled the subsequent remedial measure issue. This goes to the actual problems and goes to rebut the evidence that the defense adduced in its case in chief. So as redacted, the court will receive 2821.
There's one more page I want to show Your Honor on that, which is page 6. And there, number 4 picks up a governing body. And again, these are related to governing body issues. And then closing with 7, which would be the signature page.
Right, but number 3, let me see what number 3 was. Infection control, that's out, right?
All that above that would
Yeah.
be above 4 would be out.
And we would add
I
the
think
objection,
infection
Judge,
control
to-
should be in, considering they didn't
With
flush
the
her port.
Um,
Her mother
overruled
had to
that,
tell them to do it.
Anything else on this document, Mr.?
They
Whitney?
let that port go
No.
for a month.
Okay, as redacted, the court will receive it.
Right, and that takes us to 2822. And it's an internal email involving the interim CEO. We would redact the top portion here with Mr. Hunter's name. And what's really critical is beginning at page 4. And we only need the top box on page 4, which again goes to governing body issues and talks about at the bottom of that box, speaking up for safety and long-term just culture.
And then you're going to redact out that second bullet, managing heart surgery programs,
Yes, Your Honor.
and then everything else is being redacted.
And we'll redact the balance beginning at 1B in those bottom 2 boxes.
Anything in addition, Mr. Hunter?
No, Your Honor, same objections.
Okay, as redacted, the court will receive 2822.
The only thing we need to do exhibit-wise, Your Honor, is admit the mortality tables, which are the first exhibit listed. We've provided an opposing counsel. And so for the record, those are 2060-002, and then continuing at 47 to 50.
Any objection from?
No.
Court receives 2060 pages 2, and then pages 47 through 50. Did I read that properly?
Yes, sir.
Anything else as far as exhibits?
Right. 1 second, Your Honor.
Because we have a couple of exhibit issues, but not related to their rebuttal.
And is it something that we can all agree to just do after we send the jury home today? Is it possible, or do we have
Yeah,
to?
there's just, the only, well, we need, after the jury goes home, you're saying? Jerry? Yeah, we just want to, we're asking to admit an exhibit we forgot. It has nothing to do with these issues.
So long as we can do it after I send the jury home?
Yes, I don't see why we could not.
We are done.
Okay. Let's shift gears for a moment. We have the question of juror disqualification. Do you want, because we've got time issues with the expert, do we want to postpone that discussion until, a little bit later on today?
That's fine, the defense.
Yes, from my perspective.
Okay, and then before we take our lunch, we need to have a final discussion and nail down the jury instructions. So what I would propose is we do this testimony, and then I guess you're going to rest after you present your evidence. I'll send the jury to lunch, and then we'll work on jury instructions, deal with the DQ issue, and then take our lunch, then come back, and the court will read the instructions so that first thing tomorrow morning you can do closing arguments. Does that game plan work for everybody?
Yes, sir.
It does, Judge. I just don't know when they're gonna be able to get us the redacted documents.
Well, my hope, should I just give you 10 or 15 minutes right now to work on that and then come back, let's say at 10:20, and hopefully we're large way there?
We'll be most of the way through it, and if there's one that we can't get redacted in that time, we won't present it at this time. We'll just move it into evidence once that gets worked out.
So should I come back at 10:20 or 10:30?
10:30 would be appreciated.
Does that give your, okay. He's got enough time. So I will be back at 10:30. Let the jury know that we'll be starting just about 10:30.
All right.
All rise, closing recess.
Okay, hilariously, my daughter just discovered that Twitter is no longer Twitter and it's X, and she's panicking right now, sending me texts saying, "It looks so tacky and I hate it." And she hates it. It's so funny. I'm like, we all had this conversation months ago. Where have you been? Where have you been? Because this is an old thing. It's just funny. She's sending me texts like, "I hate it so much. It's so tacky." Yeah, we know. It will always be Twitter to me. You're not going to catch me saying X. Okay, so the judge is going to be gone for a while. And so this actually gives me time to read through the plaintiff's motion in response to the jury disqualification. Over the weekend, we did read the motion to disqualify the juror. But I did not get a chance to read the response from the plaintiff. So why don't we do that? Let me go and pull it up. It is in my email here somewhere. Night Owl wants them to bring back MySpace. What? No. Okay, so yeah, I thought that the judge would probably just kick off the juror because, who needs the extra fight? But the lawyers, according to the law tube, they think he will not. They think it's a really bad motion. And I mean, we did laugh at it quite a bit. But I didn't get to read the plaintiff's response. So let's do that. See if I can find here. No, that's not it. Sorry, guys. I have to keep looking. It's in my email here somewhere. I have too many emails. Aha. Here we go. Plaintiff's response to motion to disqualify. Let's see if I can share this. It's probably going to make my camera go wonky again. Oh no, spinny wheel of death. Spinny wheel. This is bad. All right. I have to shut down. Sorry. But at least nothing's happening. You guys know what to do. Entertain yourselves. I'll be back. This fucking computer. And I'm back. All right, we didn't lose anybody. Amazing. This is amazing. My hair's starting to look a little better now that it's getting drier. I was not appreciating how it was looking. Okay, let's see. You just never can tell with curls or waves. You just can't. Some days are good days, and other days are like, hard to tell. All right, we were going to read. Curly hair is like a box of chocolates. You never know what you're going to get on a daily basis. All right. Here we go. Share screen. All right, here we go. Let us embiggen this a little bit so we can all see. Plaintiffs oppose defendant John Shopkins All Prisoners Hospital's motion to disqualify juror number 1 based on some of this juror's questions that defendant asserts reveal his bias in favor of plaintiffs and show this juror violated the court's instruction not to prejudge the case. Defendant is factually and legally wrong. I like that sentence. Probing questions do not show bias, and defendant ignores the juror asked probing questions of both sides. Defendant's tactic, if successful, would promote gamesmanship for parties who wanted to eliminate a juror during trial and undermine the confidence in the judicial system. Plaintiffs note that the parties have been provided copies of the jurors' questions through last Thursday. Nevertheless, defendant chose not to quote the actual questions, opting instead to describe the questions or quote small phrases out of context. Well, that tracks. For the Dick defense, that's what they do. Plaintiffs take issue with these characterizations and with the defendant's assertion that these questions show a bias in plaintiff's favor. For example, defendant describes the question in 2E as showing juror number 1 question defense witnesses in an adversarial manner by prefacing his question by asking if the witness could beyond doubt affirm that or was able to attest to something in the witness testimony. Far from demonstrating juror number 1 was being adversarial towards these witnesses, it more than likely shows he was only mimicking the lawyers for both parties that he had been listening to for many weeks. That's a good point. Another notable example is in 2.I, in which defendant complains about juror number 1 prefacing a question by saying Maya was more mature than a usual 10-year-old and handled her pain differently. Dr. James Lewis, who conducted Maya's psychological evaluation while she was at JHatch and being investigated by the CPT team, described Maya in these terms. That's funny. So their own witness described her that way. Legal Vices says, do they take notes on a dictaphone? Most definitely. Oh, Jason, thank you so much for the for the super chat for get that new computer. And you guys, if you don't want to send super chats and you would prefer, because they take 30% off the top, if you want to send it straight to me, rolling across the bottom of the screen is my Cash App, Venmo, and PayPal addresses, and 100% of it goes to the computer fund. Night Owl, thank you so much for computer fund funds. I appreciate that. All right. Juror number 1, using the same description of Maya, shows no bias for or against either party. The parties do not yet have the exact words of Juror 1's comments and question to Nurse Sylvia Ballwag, in which he stated that she was a breath of fresh air. Defendant's first example, motion paragraph 2, paragraph 2A, while plaintiffs agree that Juror number 1 described this witness as a breath of fresh air, they disagree with defendant's characterization of what juror number 1 meant by this. To the best of plaintiff's recollection, juror number 1 did not explain his comment, and he certainly did not say that he thought the witness was the first person from defendant who appeared to have cared about Maya Kowalski. One possible interpretation is that juror number 1 thought plaintiff's counsel had questioned her too aggressively, and that he was simply being encouraging to her. That reasonable people could interpret this statement differently, however, demonstrates that the comment does not show bias in favor of the plaintiffs. Defendant's motion also omits other questions asked by juror number 1 that were either completely neutral or could be viewed as revealing bias in favor of the defense and against the plaintiffs. For example, juror number 1 asked defendant's witness Jennifer McCain regarding the complexity of medical issues without any indicia of bias. Dr. McCain, in your testimony, you've used the phrase similar to psychological component. Should I interpret that to mean there is a mental component, but there is also a physical component, or does your phrase psychological component mean there is no physical component? Letter B, juror number 1 asked defendant's witness, Nurse Alside, regarding issues of fact for his determination. Nurse, what color was Maya's court attire that you helped her change into? C, juror number 1 pointed out Nurse Reck's kindness. Nurse Miss Reck, it was very kind of you to tend to Maya's laundry. Oh, Our Lady of the Laundry. Here we go. My question would be, why didn't the parents of Maya tend to their daughter's laundry? Was the need for you to tend Maya's laundry because Maya's parents were negligent to their daughter's cleanliness or needs? Or was there something restricting their visitation? Oh, I missed one. Juror number 1 asked defendant's witness, Nurse Alside, about the timeline of events. Nurse, is this timeline and clothing correct? Helped Maya get down to shorts and white bra? Yes. Photos taken? You helped Maya into dress with same white bra, or you changed her bra? Juror number 1 asked an unbiased question to the defendant's witness, Doctor, if during this time Dr. Smith, per Mr. Shapiro, was acting as a DCF employee, then is it proper for Dr. Smith to act as a contributing staff member of JHatch? Juror number 1 continued to ask unbiased questions to defendant's witnesses regarding the timeline of events. Dr. Teppa, or Dr. Peppa as we call her here, how long did Maya spend in the ER before being transferred to the PICU unit? When Maya was transferred to the PICU, was the mood of Maya and parents on a more even, calmer level, or was there still a flurry of confusion? Juror number 1 tried to limit the plaintiff's expert witness, Dr. Kirkpatrick, to a simple answer by asking Dr. K in simplest terms, is it safe to say? And a simple yes or no will do. That's funny. Even the jury was getting annoyed by the long answers. Juror number 1 sought information related to Maya's alleged CRPS diagnosis, indicating that he had not determined whether she has CRPS or not. All Maya was discharged with three to four diagnoses by JHatch, and none were CRPS, correct? When, if at all, was Maya ever examined and given a diagnosis of CRPS, date and doctor name? Juror number 1 sought guidance on issues related to Detective Graham's interview of Jack Kowalski. His question indicated that he wanted to know the law behind Detective Graham's intentions in her interview and maintain an open mind. Dear Judge, clarification, please. Cameras and reasonable expectation of privacy. What is the law? And in a hospital setting, in a private single occupancy room, is that an expectation of privacy area? I'd think yes, but please educate me. Juror number 1 continuously questioned Maya's CRPS diagnosis. After being released from JHatch in January 2016, has Maya ever been re-diagnosed with CRPS, or are those 3 or 4 from JHatch are the last? Defendant correctly states that a party seeking to remove a juror for improper conduct during a trial must show that the juror's action amounted to misconduct. Defendant cites 3 cases standing for this proposition without providing any factual description of the cases. Well, that's convenient, or their holdings. The first 2 cases are factually very different from the situation before the court here. The third case, however, Washington v. State 955, is remarkably similar. Washington held that the trial court abused its discretion by removing a juror based on purportedly biased questions the juror asked during trial. And although defendant cannot be criticized for failing to cite this case, it only did so by burying it in a string cite. In Washington, the trial court instructed jurors at the beginning of the trial that they could submit written questions aimed at clarifying the evidence and encouraged them not to ask a large number of questions. During trial, juror McCoy asked a great many questions. After all the testimony was presented, the trial court announced that it was replacing juror McCoy with an alternate because Ms. McCoy was the only juror that asked any questions. A large majority of the questions asked by her were contrary to my instructions, showed a total lack of understanding of the testimony that had been presented, were generally argumentative and hostile questions. The reconstituted jury ultimately returned a guilty verdict and the defendant appealed. The first district reversed the judgment based on the trial court's removal of juror McCoy. In an opinion authored by Judge Padovano, the court rejected the state's argument that juror McCoy's questions demonstrated misconduct. By revealing bias in favor of the defendant, the court stated, Juror McCoy appears to have been skeptical of the state's witnesses, but that does not mean she could not be fair. Jurors are told that the defendant is presumed to be innocent and that the state has the burden of proving the guilt beyond a reasonable doubt. It should come as no surprise that some of them will have critical questions about the state's evidence. Surely a juror does not demonstrate unfairness merely by asking sharp questions. Wow, this is very relevant. The court went on to observe, jurors are told they must not form any definite or fixed opinion about the merits of a case until they've heard all the evidence, the arguments of the attorneys, and the instruction of the law. There is nothing in the record to suggest that juror McCoy violated this instruction. She may have been forming impressions as she was hearing the evidence, but we do not know what she may have thought after hearing the entire case and discussing it with the other jurors. It would be unrealistic to assume that jurors do not form impressions as they are hearing evidence. That is not improper, so long as the juror does not decide the case before it's concluded. Okay, hold on. I missed a couple super chats, so let me get to those real quick. Duncan, Idaho, thanks for the super chat. Says been waiting for today all weekend. What's your 0 to 10 review of the verdict, Megan? Now I have nothing to bug you about. Oh well, I give it like an 8 because I did not like the ending that leaves you wanting the verdict. I think the movie is called The Verdict. You better give me the verdict at the end of it. I got very annoyed by that. I do not like that. But I liked the movie. It was a great movie. Duncan, Idaho also said, also it was very heartwarming to hear 3 different lawyers basically laugh at the DQ motion and predict that nothing would come of it. Here's hoping. Yeah, so Law and Lumber laughed at it, and so did Uncivil Law. And I too felt the same way, but I feel like, the judge still might just give it to him. I don't know. Now, the lawyer, kind of felt like I do. He said he thinks the judge might just disqualify the juror just to get it off his desk so that that's one less issue. However, I think it was Uncivil Law who said this is being appealed anyway, regardless of what happens with this juror thing. And they didn't present any evidence that this juror has done any misconduct at all. And I think it would be really terrible. I think jurors ought to have some rights. And if, this guy gave up a month of his life. And yeah, Uncivil Law's reading of the jury disqualification motion is a must-see. It's absolutely hilarious. I watched it with one of my daughters and we were just dying. Fairy Fox and I were laughing and laughing. We just loved it. Every minute of it. It was funny. Yeah. Legal Vice says, this is it, the TLDR version. Defendant's motion to disqualify jury number 1. Let it be known that yep. It was just like that. It was a wine fest. And I hate to think that the judge will give it to him, but I don't know. We don't know what's going to happen. We'll find out. I'm a little worried about it, but then again, I don't think the rest of the jury is going their way either. So I don't think it's going to do Sean Shopkins any good. All right. The Washington court recognized that a juror may only be removed for misconduct if there is evidence that the juror violated an order or instruction by the court. It concluded that, unlike a juror who visits a crime scene, reads news accounts of the crime, or speaks to witnesses, Juror McCoy's conduct was not clearly shown to be a violation of any order or instruction. Whether her questions were too numerous or too suggestive are very subjective issues. To say that she was guilty of misconduct would require a characterization that is a matter of opinion. The same is true here of jury number one's questions, particularly when viewed in their entirety. Wait. Washington also criticized the trial court for failing to question Juror McCoy to determine whether she thought her questions violated the questioning procedure, stating that many potential juror misconduct issues can be diffused that way. What time did the judge say he was coming back? Shoot, I wasn't monitoring court because I forgot. Hold on. Let me make sure we don't miss out. I forgot to monitor court. Sorry. It's because I had to reboot the computer. No, we're still on break. We're still on break. We're good. Okay, now I have it up so I can hear it. Blah, blah, blah. But the trial court simply assumed she had prejudged the case and could no longer be fair. Based solely on her questions, the trial court's finding lacked record support. Here, defendant has requested not to interview juror number one, and there is no reason for one on this vacuous charge. Washington expressed concern about the precedent that would be, yeah, it's true. Shapiro was like, we don't need to interview him. We just need to get rid of him. We don't need to interview him. Let's just get rid of him. These people are shameless. The Dick defense are shameless. Washington expressed concern about the precedent that would be set if it were to approve the lower court's decision to remove Juror McCoy. The credibility of the process would be undermined if it appeared that a judge was deciding which jurors could serve based on the inclinations they may have shown by their questions. That is a risk not worth taking, particularly here with the public interest this case has generated across the country. Rather than discuss Washington, defendant relies heavily on Allberger v. Harvison. In Allberger, the trial court determined that a juror's questions and comments were not objective and unbiased and removed the juror without questioning him concerning his expressed views. The appellate court affirmed because the trial court held a superior advantage over this court in determining the full force and effect of said jurors' questions and comments. Because the opinion does not recite what those questions and comments were, unlike Washington, we cannot know if they were so flagrantly biased that no other interpretation was possible. That is clearly not the case with juror number one. Defendant claims Allberger supports the proposition that questioning a juror under these circumstances could reinforce. There's Mr. Whitney. I recognize those glasses. Speaking of the microphone, please. No, it's not muted. I can. How come? Wait.
Well, what's the game plan?
Why am I
Take up
hearing?
Should we take up something else?
Well, I thought the issue was your expert couldn't be here this afternoon.
Correct. I'm just thinking, well.
Are you
we're
hearing an
trying to get
echo?
all the exhibits together. I don't know what else we can do in that time, but
I can't deal with anything else right now.
did you bring a book? I don't know how long it's gonna take, Judge.
I only need 2 or 3 of them to do the rebuttal. I don't have my arms around right now what 2 or 3 are ready. We've got 4 people scrambling, working on it, printing in the hallway, getting into missed crawls. We're doing our best.
Tomorrow's Tuesday.
Let me ask our expert one question.
Bring it home, Dr. Corcoran.
We're just trying to figure out how late he can depart from Hague this afternoon in case this needs to be shifted to maybe even take an early lunch. I'm just throwing out options here. Bring him back.
To bring him back.
After an early lunch at 12:30 or something. He's confirming that
Dr.
now.
Cochran, what time do you need to leave?
Your Honor, I think I need to leave around 2 o'clock. I'm gonna call the office and see if maybe I can be a little bit late. Have a-
I don't really want to start later than that because
Start later than.
you're going to have questions, and then I'm sure Mr. Hunter's going to have questions.
Yes, and so if we,
I don't know, somebody from the defense side.
Sure. If we started at 12:30,
It sounds
I would
like,
not have
yes,
more
the
than 45
redaction
minutes
is
of
taking a long
questions.
time.
that gets us to 1:15. If they have the equal amount of cross examination, that takes us to 2 o'clock. Just an option.
I mean, I'm reluctant to ask this question, but what if we call him, let's say at 8 a.m. tomorrow morning, ask the jury to be here super early, and we do the rebuttal tomorrow morning. We then instruct the jury closing arguments, and
do
then
it today.
maybe even let them start deliberating. I mean, I don't know. They might have to start deliberating on Wednesday.
Tomorrow? Why tomorrow? Do it now.
I'll just ask him the question if he's available tomorrow. I'm gonna ask that question.
Judge, are you concerned
Tomorrow.
if we start at 12:30 that we won't be?
I want to give this jury as much time as we possibly can to deliberate. I would love for them to start deliberating tomorrow as opposed to Wednesday.
So
I agree, Judge.
what's the?
Why is
what's
the
reluctance, I
redaction
guess,
taking so
to
long?
start
Get a
meetings at
Sharpie.
12:30 so we can all leave units situated, or 12.
My preference is to get him on and off today.
Right, right,
Strong preference.
right.
That being said, we are so far down this road. I don't want to do, because of rushing, I don't want to do something that is problematic.
Dr. Corcoran can leave here as late as 2:30. So if we start at 1 o'clock,
Gotta be in my car, sir.
and he's not available tomorrow.
Oh, shit. It's got to be today.
Judge,
If we started at 12, will you be ready with your exhibits?
I can confidently say yes, we'll be ready by 12 o'clock.
Just get a Sharpie, dude. Let's just
I
go.
believe
Let's
so, Your
Sharpie
Honor.
the shit out of
sorry?
it. Let's
I said I
go.
believe so, Your Honor.
Okay. But I also have to deal with
Get some
the jury
scissors.
instruction
Cut it out.
issue, because I really want to try to instruct the jury this afternoon, unless you all say that's just, we're doing too much.
I think we would prefer that as well. To have him instructed this afternoon and get through as much as we can.
We would as well, Judge.
Now, let me hear from Mr. Altenburg, since this,
I don't think the disagreements and things that we have left on jury instructions are that time consuming. So,
Okay. so I'm going to bring the jury back in. I will tell them to get out of here until noon.
Sorry for the trouble.
No, it's,
Oh my God.
the
We're
art of
delayed until
possible.
noon.
Let's bring in the jury.
Oh, shit. We're delayed until noon now. I don't think they do. This is not about the defense. They have to make sure the redactions are correct. Whitney needs the time too. He just said that.
All rise. Jurors entering.
I think the problem is they haven't been able to get the redactions done yet in the small amount of time they had. So they need to do the redactions. Oh my God. But now all right. I have housework to do. So if they are breaking until noon,
Okay, please be seated, members of the jury.
then I am
I want to
breaking.
confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? No one approached you about this case. Is that correct? And you've not seen any media about this case. Is that correct? Okay. Let me tell you where we're at. And this is, again, that 5-minute issue my wife so much loves. I'm going to send you away to be back, go to lunch, and be back at noon. We're going to finish the evidence this afternoon, and I am going to do everything I can to also give you the jury instructions this afternoon, which means that the closing arguments will not be today, but will be first thing tomorrow morning. When you come back, I'm going to see if you might be able to come in a little bit earlier tomorrow. But I intend on getting the jury, the case tomorrow, deliberations to begin tomorrow. So what I'm asking is, when you come back from lunch, are you going to be able to be here at such a time so I can basically start having discussions at 8:30 with the jury? Okay. So basically seeing if we can be here 30 minutes. I don't know. Just let me know if that's going to be a problem. If it's a problem, then we'll do it at 9 o'clock. So just let me know when you come back. Other than that, we are going to keep working today, and we're going to have information to you at noon. So I'm going to send you out, let you go to lunch now, and be back ready to go at noon. Do not discuss this case amongst yourselves. Do not do any investigation, and receive no information.
All rise. Jurors exit.
Yeah, the jury has to know something is up. Because they're not being told anything, but they keep getting delayed. Oh. All right. So I just think the best thing to do here.
The jury's out of our presence.
Oh, are they going to fight some more?
Everyone, please be seated.
Oh, I guess.
Is
we're
there
not
anything
fighting.
else about the exhibits, or can we pivot at this point to Mrs. Cross?
There's just one, on that one exhibit that I went through, there's just one phrase that Mr. Whitney and I do not agree on redaction. The rest, I believe, I don't have my highlighted copy.
Can you just put it up?
Well, I knew I had it. Do you have that? Oh, it's okay.
Pivot.
So 2817.
Page 9, please.
And the phrase is in here on several pages, but I think whatever ruling you make will apply. At the top there, Judge, it says, the second paragraph, there are 4 major areas we're actively working to improve. My issue was the second line, having had knowledge of complaints that allege a lack of oversight and accountability. I just thought that was probably referencing the Hart Institute. It's vague, I get it in general, but that was the one issue.
I am fine, since there's not a specific reference to
Okay.
the Hart Institute. I would leave in oversight and a lack of oversight and accountability.
Okay, that was the only, I think, disagreement on that document. Okay. That's the only one we've been through, Judge, so I have no other comments on the exhibits.
Mr. Altenburg and Mr. Elliott, can I have you both come forward and let me spotlight you there, Mr. Elliott. I'm pulling up the...
Bad Weather Biker, thanks for the super chat. Hunter's entire defense has shifted to the dog ate our homework, or possibly it was a hurricane. Paper shuffling ASMR.
Who wants to start talking first?
What's this going to be about?
The biggest concern I think that I have at this point in time is confusion over count 14 and the motion that I filed this morning about whether or not
The negligent training.
the negligent training count.
And
Yes.
you have now seen my...
I've seen, if it were to be removed, what you did appears to me to be the way to do that, yes. But I was quite, I put that in there purposefully, but I also knew that you'd ruled against me on the motion to dismiss on those issues. And so I wasn't 100% sure whether you left it in on purpose or whether this was just an oversight, and I didn't want to get carried away on this. But I continue to believe, as I always have, that this tort requires like the person be outside the course and scope of employment, or that there be something exceptional. And all the cases that I showed you under the 766-110 statute were in that nature. The federal cases, because the federal government is not liable under a respondeat superior, always have to have something additional by the government, and frequently that's negligent training, which doesn't come into play here. And so, I mean, all that line of cases struck me as meaning that, in fact, the person, if the person is in the course and scope and we are vicariously liable for them, that this does not play in. And, you know, when we get then to the damages, I think we all agree that the negligent training in and of itself doesn't cause impact or damage. What it does is it integrates with an employee who does something that causes injury to Maya Kowalski, which is the false imprisonment, the battery, or the medical negligence. And for the life of me, I think at that point, the damages are 100% overlapped. I was concerned that the jury might not fully understand that, so I took the unusual step of actually asking for a nominal damages instruction on this so that they could give $1 or something if they couldn't figure out what else to do. But I just continue to believe that this count from its inception has been something poorly pled and not legally recognized in Florida. So I still believe that I should be entitled to a directed verdict on this count. But if not, then I'm not quite sure what we do with the instructions. If they insist on having it in, then it gets complicated with scope of employment. Or, I mean, as I've said at the end, push to shove, I'll just have to withdraw this because everybody wants this case to go to conclusion. And I would rather have it resolved first so that it doesn't create reversible error.
Okay, before I forget, let me, Madam Clerk, on the question of directed verdict on the claim of negligent infliction of emotional distress. This is the one that I dealt with on Saturday.
Correct.
The transcript and the court minutes need to reflect that based on the court's rulings with respect to the physical impact requirement and the fact that I've ruled that death by suicide cannot qualify as a physical impact for the negligent infliction of emotional distress. Based on that ruling, that means the court's going to have to grant a directed verdict on the negligent infliction of emotional distress, and I do so at this time. And the lawyers know that I've done that, and we've already oriented our jury instructions in verdict form. I just needed to do that here in open court so that the court minutes and the transcript will reflect that. Okay, going, Mr. Elegant, or actually Mr. Altman, was there anything else you wanted me to say as relates to the negligent infliction of emotional distress?
No, Your Honor, I guess I would point out that I had made these arguments in DIN 3396 was the last time I made them, which kind of ironically was entitled "The Motion to Resolve Critical Jury Instruction Issues Prior to Opening Statements."
I'm just pretty slow, Mr. Altman. Mr. Elegant, on the negligent infliction of emotional distress, anything else you need to say about the plaintiff's position before we move on to negligent training? You're on mute, Mr. Elegant.
No, Your Honor, I think you summarized it, and we exchanged some emails over the weekend that are, I think, Mr. Alderman and I have discussed filing a set of the, the various instructions with the comments in it at some point so that they're there. But I think, as you accurately recited, given the rulings, we understand the DV.
Now let's shift gears and talk about the claim of negligent training.
Yes, Your Honor. I think I heard Mr. Altman say that it integrates in with the other claims. It's not just medical malpractice, it's some of the others as well, and we don't dispute that. And it may be that there are not additional damages, it will be nominal damages. But we have briefed previously that we don't think this is limited to somebody being outside the scope. If again, and we've had this discussion before, if the defense either agrees or the court rules that we can still talk about training in the closing, then I think we're probably don't need it as a separate count. But if we're going to face opposition on that, we think it should stay in. If the court decides later on as a matter of law in terms of reviewing it after the fact, assuming the jury even does anything with it, you can always direct it out at that point, but at least we'll have gotten a ruling on it. So those are sort of two alternatives that we would suggest.
Mr. Altenberg.
I mean, the only thing I would suggest about their proposal on, can they talk about it? And the question becomes, well, I don't disagree. They can talk about evidence that's relevant to something that's left. From listening to the discussions this morning, there may be some element of this that relates to a punitive damages claim. I'm not exactly sure how that ties in, but it doesn't really have anything to do with whether someone commits one of the other torts that we're vicariously liable for, because they're intentional torts that if Miss Beatty made a contact that was offensive and not such under intentional tort law, then it doesn't really make much difference about whether she was perfectly trained or not perfectly trained. And the same is true for the false imprisonment. And the medical negligence stuff is a whole different can of worms, because that's supposed to be a professional standard of care. And we're going right now to the jury on negligent training on an ordinary standard of care for a medical facility that is itself deemed to be a healthcare provider is now under an ordinary standard of care to provide training to another healthcare provider. I don't think that's the law. And I think we're better off getting that count out of there. And again, if there are things that are relevant that are left from this testimony that can be used for the rest of it, I can't object to relevant testimony.
How does this ruling impact, if at all, what we're talking about rebuttal?
You know, Your Honor, I was not in the courtroom when this happened, so it gives me a slight disadvantage, but my impression is we were talking about this in significant part related to negligent training and trying to show that we had accreditation. But what I don't honestly know myself is whether that carried over to something that relates to the punitive claim. But the punitive claim really is whether or not the people at the high level, the officers, directors, or crew managers were so involved in something that they become liable, or whether they were in a posture where they fit into one of those other two categories. And as you point out, it's a kind of a two-edged sword for them, because it has to go up to management to be ratified or go up to management for them to make a decision on it. And their whole line of theory here is that nothing went up the chain. So I've always kind of listened to this with the same interest that you had, that I'm not sure how it ties into punitive as compared to training, but I'm not going to tell you that I'm 100% convinced that there's not, as you use the word, scintilla of evidence of this that somehow relates to punitive damages.
What
Your
about,
Honor,
hold on one second, Mr. Elliott. What about Mr. Elliott's, or maybe it was your initial idea of just putting a nominal?
I only did that truthfully as a last resort, because nominal damages are supposed to be for a tort for which damage is not an essential element, and damage is an essential element for the tort of negligence of any variety. So here, there's at least nothing new in the way of damages for this tort compared to the two intentional torts and the medical negligence claims that are the predicates for this. So I'm doing that only because it seemed to me to be the best way to protect the verdict from getting some, now that I know that how much money they want to be seeking, some large number for something that doesn't really have any damages.
Mr. Elliott, anything further?
yes, Your Honor, a couple brief things. Not correcting something, not training, not correcting is condoning. It is ratifying. So it is relevant to the punitive damages. And I heard a reference just saying, well, I think this is relevant here. Something about it, not being reported up. Well, wait a minute. Not reporting to the national headquarters is not the issue. They sound like they fired the CEO of this hospital for what was going on there. That's high enough up. That's punitive damage liability of the hospital. That's who we're talking about here. The fact that they're owned by somebody else or overseen at some level by somebody higher up, we don't have to get there. Firing the CEO because of how bad this was kind of makes is relevant to the punitive damage case.
I've been warming up to Mr. Altenberg's position on this. I wish I felt as confident as you seem to feel about this claim. And is there any way I can leave the claim in with shifting a question or two, so that if I felt like after the fact I need to DV it or JNOV it, I can. I mean, I want to make sure that the law is correct and the instruction's correct.
My concern, and it's kind of for both sides here, is that at the beginning of this trial, the understanding was that we weren't going to shift to somebody outside the scope and course of employment. So they didn't put on any evidence of that. And frankly, I didn't raise that anyone was outside the scope and course of their employment, because in good faith, I didn't see any evidence that I could use as the defendant to try to prove my employees were outside the scope and course of employment. So a shift to that has the questions that I put in the motion this morning, where we have to individually say, well, somebody outside scope and course. I don't think we need or should do that, because I don't really think there's any evidence of that in this case. If in fact there's no evidence of damage beyond the underlying torts, I don't see how it can possibly be harmful error to omit this, because the damages are going to be the same one way or the other. There's not going to be any harm to the plaintiff done by omission of that. And Mr. Ellicott's made a good point that some of this may still be relevant for punitive. I'm not saying that that's outside the zone here.
Your Honor, if we could, sorry.
Go ahead, Mr. Elliott.
I would say if we can have an understanding or agreement or a ruling that training can be discussed in closing, I think we're there. And having heard a preview of the closing, it's not a feature. I mean, if there's a reference or two, I actually missed it. And Ms. Ferrier heard it. I think she heard it. So it's not going to be a feature.
I haven't heard that. I didn't have a chance to hear the feature, but I guess my inquiry would be: is it relating to punitive damages, or is it relating to something else?
I couldn't tell you the context. I mean, it was
okay.
What about Mr. Ellicott's, if there's some sort of understanding? I made so many calls in this case, and I think this is pretty much my last call.
I'm essentially conceding to you that I think there's a level of this that could be talked about for punitive damages, and whether Mr. Anderson will go farther than that line, I don't know, but there certainly is a line there that he can go to. So.
I think I need to ask Mr. Anderson, make sure I'm not giving away something, if he's comfortable with what we've talked about.
This much I know for certain. There is a plan behind everything the defense does. And because of that, I would like for it to go to the jury and for the court to then consider these matters on JNOV. If we have to ask an additional question, we're not opposed to that. But as to the cause of action, we would prefer for it to go to the jury. And the court hasn't heard the conclusion yet of one of our witnesses.
My evil plan is simply not to have one more claim on the verdict form and to have to deal with it in closing arguments, Your Honor.
We don't believe you. We know you have lots of evil plans and stuff.
I mean, Mr. Anderson, I hear you want it to go, but like I said, I'm starting to really warm to Mr. Altenberg's position that it's might be legally incorrect to let it go to the jury. That the negligent training has to be outside the scope.
Isn't that an issue for the jury? Your Honor?
Well, we don't have a jury finding currently itemized on the verdict form, and based on how this has been developing over the last 9 weeks, it's not something that really we've been focused on.
I would remind Mr. Anderson that if they're outside the scope for count 14C, then they're outside the scope for false imprisonment and battery, and that impacts his punitive claim itself.
My concern is I do not want to hear from the defense after the court rules some argument that somehow our punitive damage claim is inadequate or we failed to preserve some issue. And sure as shooting, we're going to get that from them. And so that's why unless simply submitting it is reversible error. In other words, if the court afterwards determines on JNOV to take it out, I don't see the problem with submitting it and getting their view.
Except it allows for a chunk of argument on things that probably should never have come in. I mean, the problem with if there is, as he says, a strategy, but I've been worried about trying to sort out the negligent things that the jury has heard about compared to the things that were extreme and outrageous conduct with intent. And
I guess, and this is going to sound pretty callous, I don't really care what your all's arguments are.
good.
It's a question of what I legally have to do.
Right.
And that's, I just wish I was over the finish line on this issue where you seem to be, Mr. Altenberg. I'm just not quite there yet. I'm pretty close. I've warmed to the idea that you might be correct on it, but I'm just not over the finish line on it. And so that's my hesitation.
But your hesitation is on it as a legal issue as compared to the evidence that's going to the jury. So, I mean, it's not like the directed verdict is dependent upon whether there's evidence on this or not. It's whether this claim can be made by someone when there's absolutely no dispute that it's going to be 100% covered by the employer because the employer is vicariously liable. And that's, the cases that they've cited to us just don't fit that. And the little case law under 766110 doesn't seem to fit that.
Well, and I guess my concern is, let's say there's a finding of no liability on false imprisonment, battery, medical negligence, and then there's a finding of liability on negligent training.
So how could that be? Your
That-
current
that's-
your current instruction says that cannot be.
And that's, if your argument and your position is legally correct, then how can that be? I think
Right.
that's the appropriate
Right.
question.
And that's how you have it currently on the verdict form that you submitted to us last night. They can't answer the questions on negligent training unless they answered yes to one of those questions at least.
Mr. Elliott, I'll give you one last chance. I am, like I said, I'm more in Mr. Altenberg's camp on this issue than I am in your camp. So,
Your Honor, you've heard Mr. Anderson's concerns, and I don't really have anything to add. I mean, again, I think part of the problem could be addressed as long as, he's not going to be interrupted when he starts talking about training because it is relevant.
If it is wrapped at some point into the med-mal, which is what I thought we were going to do about 2 months ago with this. But as long as it's wrapped in so that my concern is not fulfilled, then I understand the need to streamline. And of course, the law.
And of course.
I'm not quite sure how it's wrapped in at this point to mid-Mal. We've got, those instructions are kind of what they are.
Is there any question, Mr. Altenburn, that we could ask that lets me basically punt on this issue?
Judge, it's a question of law. It's not a question we can ask the jury. I'm sorry. I wish it were.
No, you
Mr.
don't.
Elliott, any other question that I can punt on this issue?
No, I think if the concern, one of the concerns I heard earlier was, well, you'd have to have med mal to answer this question on the medical malpractice part. I think you could add a line that says that. You could say, well, let's put it this way. Yes, I think you could answer a question you could add a question that says, if you find that the training was inadequate for a healthcare provider, you would need to answer do the analysis you did above for the medical malpractice claim.
I mean, they're already going to be able to argue that whoever breaches the standard of care on diagnosis and treatment did so because they weren't adequately trained or because they fell below the standard of care. That all fits together in that package. I mean, but it's the standard question in this situation about these doctors and whether or not they deviated from the medical standard of care in treatment or diagnosis. And it doesn't create another spare question.
I think I just heard what we've been asking about, which is that we can talk about this may have happened because of lack of training. If I was wrong, I apologize. But if I heard that, I think that may satisfy Mr. Anderson.
And can we hear the end of Dr. Corcoran's testimony before we make any finals?
Well, I guess the answer is yes, but all this has to get printed. All this it's going to take a while to make that happen.
Well, suck it up. It's just going to take a while. Yep.
And so I'll be having the jury sitting, cooling their jets even more.
Talking about this afternoon with jury instructions.
Right. Because, I mean, I got to print them out. And it's, I've got 11 or 12 jurors, depending on how we deal with the juror disqualification issue, plus all of y'all, court reporter and me. And we're talking, close to 75, 80 pages per. All right.
It's wild.
Mr. Elliott, I guess I've always kind of, I won't say that this has been a throwaway count, but it just kind of seems duplicative of the other counts. And I think at this point, even though I'm not fully on board with Mr. Altenburn, I'm more on his side on this one. And it just seems like it's cleaner to not have the negligent training questions in there. I think from a percentage odd standpoint of me being wrong, I've got less of a chance of being wrong on that than if I leave the questions in.
I understand, Your Honor, and I think, again, our concern, including Mr. Anderson's, and I think we heard it would be okay, as long as you can talk about training, and again, it won't be a feature of the closing, but as long as you talk about training in the closing, and it is relevant to several issues, then I think,
I don't want to be foreclosed about arguments over management.
Now, Mr. Shapiro, was that shrug meaningful to this discussion, or?
Not particularly, Your Honor, honestly. It's, just to be honest, it's not a feature of my closing either.
this is where I'm at. I think I'm going to remove the negligent training questions. I've heard some discussions, and I do agree that the question of training does go to the other tort counts that are existing. So I think we're really talking a lot about something that's not going to become an issue or should be an issue. Certainly, it also goes to the punitive damages. So I think I've got a greater chance of being correct by not asking the negligent training questions and removing that from the verdict form. So I'm going to say, let's go with the version of the instructions and verdict form that I circulated this morning. And now, knowing that that's the version I'm going with, have you all had any chance to see if I've messed up the cross references any?
I'll confess that I've read this document so many times in the last 3 months that it's hard to proofread, but I didn't see anything that was a mess up on it. But the only other thing that I'm still a little concerned about, especially after I saw the calculations, which seem to be mathematically correct, is that they're lump sum for all non-economic damages, which when we get to non-duplication with the concept, the pain and suffering must be for this tort, it's going to make it even harder for the jury. So I know that you think your non-duplication instruction is adequate, but I think it's going to be tested by the closing argument.
Yeah, he wants more taken out. He wants it all
I
taken
proposed
out.
something, but you didn't get it. So.
There's so much that's been tested in this case, Mr. Oliver. What is one more issue?
It's a veritable fertile field, isn't it?
Okay.
We don't find it funny.
What I would ask is and I don't know if it's Miss Ferrier and somebody else in your office, Mr. Altenberg, to go back and fly spec
this,
especially the cross references. I'm going to start having printing of the verdict form and the jury instructions. And if we have to throw those away and change them, I've wasted some paper. But from a timing perspective, if I can not have the jury continue to wait on me, then.
And on that verdict form I guess all of the negligent training's out. So the one question we were uncertain about is gone. Okay, yes.
And I mean, I'm not saying that you and Mr. Elegant shouldn't look at it, but
No, fresh eyes would be a good idea.
Eyes. And honestly, I think I'm probably in the same
boat
that you are. That, I mean, if I had 4 days to put this aside and come back to it,
right,
I would do that. But since we don't even have 4 hours, I'm not sure I'm in that position.
Okay.
So. Okay. Anything else that we can do before noon, or I should let y'all
maybe get it right. If you need 4 days to get
take
it
your
right,
time,
maybe
finish
you
out
take
these
4 days.
exhibits, and be ready to go at noon.
Your Honor, what time did you want to talk about the juror issue?
Yeah, let's do that.
Can we just do that after we send the jury home today? Is that problematic for anybody?
No.
So defense, you're okay with just waiting until?
That's fine, Judge.
Okay, let's do that after. Let's take that one off the table until we get this rebuttal case, nailed down.
Can we come back at 10 till, just in case Ms. Crawls has any further requests for minor redactions?
That's fine. 10 till. Now, one other thing, and it probably doesn't matter since you have a lot of technology, but I was going to give the lawyers a copy. Sometimes the lawyers want them stapled, not stapled. Sometimes they want it 2-sided. Sometimes they want 1-sided. Is there any specific request on how you want your paper copy of the jury instructions and verdict form?
We like the stapler. 1-sided or 2-sided is up to the court.
I don't care about the stapler. It's just the TV, doing it right in front of the microphone.
I know. We appreciate it stapled.
Stapled, and if we could, just one side.
1 sec.
It's a thick document, one-sided, but it can be done.
Staple 2 for me.
You want yours both sides?
I'm a big pine tree saver.
Okay. So does that go for your entire team or just you?
I think Ms. Crowell is partial to one side.
And Madam Court Reporter, I'm going to get you a copy. Do you want yours one-sided or two-sided? One? Yep. Okay, and Mr. Elegant, your team there in Tampa?
Your Honor, we'll just pick it up from when they come out off the, we'll print one
Okay.
here. Thank you.
Okay. With that, let's be back here at 11:50, and then we're going to rock and roll.
All right. Well, I'm leaving up the Twat Waffle logo over Maya because I think it's ridiculous that they keep showing her face and only her face when other lawyers are speaking, and I think or the judge is talking. It's just crazy and ridiculous, and I'm going to keep doing that until they stop. All right, so they're not going to be back until 11:50, I guess. I've had my piece of pie, I have my tea. I got myself a cup of tea while we were listening to that. So by my understanding, and a lot of this is above my pay grade because I'm not an attorney and I'm having a hard time keeping up on these particular arguments about the specific charges because they're so complicated. But let's go over what Jeff said. Jeff said the damages for causing suicide are gone unless they have claims for intentional infliction of emotional distress. Now, I don't know if they do or not. I don't know if that's part of it, but I don't know how it could not be intentional, especially after one of the nurses admits she saw it coming. That really bothers me. Like that bothered me the most. Oh, I predicted this would happen. Oh, you did? Well, you're a mandated reporter, so why didn't you tell somebody? I don't know how that's not intentional. And then saying that the family, that Maya would be better off. I mean, they have it on text message. Jeff also said defense won the motion for directed verdict dismissing the claims for damages arising from negligent infliction of emotional distress. What I did not hear there, though, was whether it was for all of them or just Beata. Was that for all the plaintiffs or just Beata? Because I can't even believe that. Nick Campbell says this isn't personal or giving an inch. He's arguing the law correctly. You're talking about Altenburn and persuading the judge that his interpretation is correct. That is his job, which comes with some weight. Yeah, especially coming from a former appellate court judge. Yeah. Silent PS says there are aspects of the law that are unfortunate, but every time we change the law in haste, we end up regretting it. That is also true. Nick Campbell says the jury is the finder of fact, but the judge is the finder of law and interprets the law prior to facts being determined by the jury. This is true, but what concerns me about it is the judge admitting that he needs 4 days to figure this out, but he only has 4 hours. If that is true, I think it would be better to take the 4 days so that you don't get it wrong. I mean, they're already a month in. What's 4 more days if that's what you need to figure it out? Uncivil Law said the other day that the biggest hill plaintiffs will have on appeal is the intentional indication of distress for Beata, since this is a novel case, could set new standards. Yeah, this is what makes this case so complex, is that it hasn't been done before in civil court. So the suicide, going after somebody for someone else's suicide has been done in criminal court, but not in civil court. And that's what makes a lot of this really very difficult. Silent PS says, I suspect defense is acting like Congress has, waiting until the last minute to deal with the controversial, important stuff. So there's a time crunch and we're forced to accept imprudent compromises. Yeah, this is a really wise kind of observation here. I guess I have questions, and maybe it's because I'm not an attorney and I don't know how these things exactly work, but I really don't understand why they have argued the entire case on the charges that we had before getting them thrown out. So the entire case has been argued in front of the jury for these things. And now you're going to go and tell them that or 4 out of the 8 of these things are now no longer up to you. I just don't know how this works. I think that's really frustrating, and I think they should get the charges, sorted out before it goes to the jury. But of course, I guess the argument for that is, well, the judge has not seen the evidence until you put the evidence on. And so how can the judge rule for a directed verdict or not if he hasn't seen the evidence? So I guess that's part of the deal. But it does seem like last minute politicking, shall we say. It does seem like last minute shenanigans. All right, just catching up on your chats here. Let me check Rumble. I haven't been over to see you guys over on Rumble for a little while. What's going on over there? You guys are just as annoyed as everyone on YouTube is what it seems. Yeah, I don't know. This is something we need an attorney for. I did invite a bunch of attorneys, but I think Jeff went to sleep or he's in bed. He didn't get my notice until after he was in bed. Unfortunately, Twitter is not working very well, and I sent him an invite, but it didn't go through till after he was in bed. So he can't hang out. And it's just unfortunate that I don't have answers for you guys. I'm sorry. I don't. All right, let's see. I love watching Recovery Addict. It's just that you can't keep up with the chat because it flies so fast. It's like impossible. That's what it sucks about channels getting real popular, is that then the chat becomes totally unwieldy and it's not the same. I appreciate our smaller chat here so that I can keep up still and I can read what you guys are thinking and we can interact. It's hard when the chat gets so big that you just can't even read it. It's too bad. But Recovery Addict has a great channel and his coverage is really good and he finds out a lot of stuff. Yeah, Sally, right. I mean, they didn't prove the charges according to the law, so that's the way it goes, I guess. That's the way it goes. All right. Let's go back over to what we were reading. We'll finish reading that. That would be the plaintiff's motion against the disqualification of the juror, which I guess we aren't going to find out the judge's ruling on that until after court today. So, and I'm not sure if I will still be here by then because that's going to be like at what, 5 or 6 o'clock? You may have to watch that someplace else because I need to, when the kids get home and stuff, I've got mom stuff I have to do. I can't be here all freaking day. All right, where were we? Defendant claims Allberger supports the proposition that questioning a juror under these circumstances could reinforce his prejudice or bias without cause. Allberger says nothing of the sort. In fact, it is utterly silent on this point, except to say that the trial court was in the best position to make the determination. As Washington observed, many potential juror misconduct issues are diffused that way. Finally, plaintiffs note that cases cited in paragraph 4 of the motion all involve jury selection, not the disqualification of an impaneled juror. A potential juror may be excused if there is reasonable doubt as to his impartiality, but an impaneled juror may only be removed for misconduct. Washington's observation that a judge removing a juror for perceived harsh questions could undermine. Hey guys, those of you who are saying that there's a 300-page motion for sanctions, I can't go to the clerk site right now and get it. So if one of you wants to get it for me and then email it to me, that would be great. You can find my email at meganfox.writer@protonmail.com. If you want to email me that document, that would be great. And we can look it over. We're certainly not going to get over 300 pages, but we could certainly scan. But that's not something I can do while I'm streaming, and my computer will not handle it. I cannot open more windows. No, definitely not. I'm barely getting by with the windows I have open. All right. All right, let's see. If litigants are empowered to remove jurors they do not like based on claimed harsh questions, this will become a prevalent new tactic. That's a really good point, by the way. Really good point. Like, it's got to be, it really needs to rise to the level of misconduct. Otherwise, what's going to stop any lawyer from just moving to remove a juror the second they don't like a question? If there is ever a situation where a juror's questions might be deemed misconduct, that is not it, not even close. Because he really wrote that. Because defendant has failed to show any misconduct by juror number 1, the motion to qualify should be denied. I agree. It should be. All right, so that's the end of that. We got through that. Now, if any of you have the other document that was filed with the clerk, you can send it to me on my email address, which is up on the screen. Let me go check my email, see if anybody did that yet. Of course, a 300-page document is going to be hard to open, isn't it? Maybe it's somewhere online. Why is it 300 pages is the question. Marta says she emailed me. Okay, I'm looking. Hasn't come through yet. Oh, yep, there it is. Thank you, Marta. See, the chat is so good. Who needs a staff when I have the chat? Chat, I ask and I shall receive. All right. Kowalski's motion for sanctions. Here it is. Let's pull it up. Hello, StreamYard. StreamYard is running so slow. All right. Plaintiff Jack Kowalski's motion for sanctions. Wow, 327 pages. Hopefully there will be a summary in here, and we can look at the summary. Plaintiff Jack Kowalski individually and on parent and next friend of MK, a minor, and a personal representative of the estate of Beata Kowalski, deceased, and through the undersigned counsel, moves for sanctions against defendant John Shopkins, All Prisoners Hospital, on the following grounds. On October 11th, 2023, plaintiff, through his counsel, Gregory A. Anderson, presented the testimony of plaintiff expert witness Dr. Joseph Corcoran on direct examination. In response to Mr. Anderson's questions, Dr. Corcoran began to explain the guardrails for clinical teams and the standards of care for hospital management are set forth by the Centers for Medicare and Medicaid Services. Defense counsel immediately requested to approach at the mention of CMS. Thereafter, the following exchange occurred among the court and counsel. Oh, it's a sidebar. Oh, I need Jeff. I need you people so we can do a dramatic reading. Damn it. Mr. Hunter. CMS standards were not referenced that I can recall in this gentleman's report. They were never referenced in his deposition. They are not on the exhibit list. They are part of several regulations. They are not permitted to be used as evidence for cause of action in a medical malpractice case. This is the first I've heard about CMS regulations with this witness, Anderson. Yeah, let's give it a whirl. I need somebody. Chandler, where are you? Why aren't you here? I sent you a link. I need somebody to read this sidebar with me, damn it. CMS regulations and okay, this is Anderson. CMS regulations and his involvement simply goes to his background, training, and experience on the specific types of policies and procedures here. We're not going to be comparing them or doing anything like that. I just wanted him to be able to explain his involvement in developing standards because I think it's important in the overall background, training, and experience to review these standards and evaluate exactly what happened. MG Law, you're totally disappointing me. You need to just pop on. You have the link. Just get in here and read this. You're at work, close the door. It's not that important. And I want to make it clear where his testimony is going. We're not micromanaging here. We're looking at the big picture of how this hospital got where it was to be, as we determine, a rudderless ship. We are not going into rewriting all of the standards in this case. We are talking about the way the hospital was structured and how the accountability was set up. In these standards, he had some developments. The court, no comparing and contrasting CMS policies. Anderson, no, we're not going to compare and contrast. It's going to be based on his background, training, and experience, and his statement as to what is the standard of care under those circumstances. Hunter, it sounds to me like what he's saying is he's going to identify the standard of care based on CMS standards and based on his expertise in developing CMS standards, which is more like a teeny inch away from what we're talking about. Anderson, here's the problem. Anybody who would be qualified enough to talk about this is familiar with the CMS standards. So you can't get somebody who is going to talk about overall hospital management without them having some familiarity with these. It's just background, training, and experience. Judge Carroll. Mr. Anderson, give me your word you're not comparing and contrasting them, CMS, as some sort of bench post. Anderson. I understand. Court. At present, I don't see anything objectionable from this witness at present. Hunter. I've got a feeling we'll be back. Anderson. Well, that's probably a certainty. Mr. Anderson resumed his questioning, and Dr. Corcoran testified as follows. Insofar as the CMS standards, based on the court's ruling, I want to be sure we just stay involved with your knowledge of the development of them and any participation you had. Answer, witness, Corcoran, sure. And it's CMS, Centers for Medicare and Medicaid Services, which is the federal organization that oversees Medicare and Medicaid spending. So I had nothing to do with developing the CMS standards, but these really are, there's a book referred to as, well, titled CMS Conditions of Participation, and these are the standards that every hospital is held to. Mr. Hunter, Your Honor, the court sustained. We don't want to go into the operation of them, just your background, this is Anderson, just your background in terms of actually learning about them, using them, developing them. Understood, thank you. So the CMS standards were what I, as a practicing physician and a physician medical staff leader, was held accountable to. The standards were also what I was held accountable to as a chief medical officer to make sure the hospital was, Mr. Hunter, Your Honor, maybe we approach. Based on the position taken by defense counsel and the objection sustained by the court, Dr. Corcoran was precluded from testifying to CMS standards for the remainder of his testimony. On October 25th, defendant, through his counsel, Ethan R. Shapiro, presented the testimony of defense expert witness Mark Anderson on direct examination. In response to Mr. Shapiro's question, Mr. Anderson agreed he had been retained by defendant's counsel to look at the materials available to determine whether Johns Hopkins All Children's Hospital had appropriate organizational structures for patient safety. Later, in his testimony on direct examination, Mr. Anderson responded to Mr. Shapiro's questions regarding the overall process of review and indicating that All Children's is audited by federal agencies to ensure that they are in compliance with safety plans, and described the Joint Commission on Accreditation, the Joint Commission, and the role it plays in accrediting and evaluating hospitals for compliance with a series of standards of quality. In response to Mr. Shapiro's questions, the witness testified as follows. Shapiro, okay, so let's get back a little bit to the overall process of review by the hospital in terms of quality review. Does All Children's, are they required to have a quality review process? Yes, most organizations choose to go through a quality review process that is an accreditation and review process by the Joint Commission on Accreditation of Hospitals. Yeah, let me interrupt you there. I'll have you explain what the Joint Commissions are, but Is all children's audited by federal agencies to ensure that they are in compliance with safety plans? Yes. And who is that? It's the Joint Commission as one body, and there could be others as well. And explain to the jury, if you can, who the Joint Commission is and what their role is. The Joint Commission is an organization that was set up 70 or 80 years ago. It is the Accreditation and Evaluation Organization. Its purpose in being set up was to try standardize the very hospitals provide care, the way hospitals provide care across the country, and it identifies for each and every department of a hospital a series of standards and quality that are evaluated on a routine basis by surveyors from the Joint Commission. Typically, Joint Surveyor Commission, the Joint Surveyor Commissioners, reviewers come in every 3 years. However, they can come in and spot check on a randomized basis. Usually, a survey will consist of 4 to 5 days of going through every record of the hospital from a perspective of looking at documentation per department of how they are meeting quality goals, and it's an arduous process. Different surveyors, survey different things. There's a physician, there's an administrator, there's a hospital management, facilities management expert who will literally go through the hospital, poking up tiles, looking for breaches in the ceiling. Oh, did they check the oxygen tanks though? Yeah, I think they did, and they found that they were in danger of exploding. Interesting. It's a very arduous and extensive process. And in your review of the records and available data, did all Children's Shopkins Hospital meet those accreditations? Yes, they did. And was that true in 2016? Yes. Later in his direct examination, Mr. Anderson testified over objection in response to Mr. Shapiro's questions. Let me talk to you about your overall view of, based on what you've reviewed. Did it appear to you, based on the materials you've reviewed, the records, the policies, that all Children's Hospital had an appropriate safety plan in place for patient care? Yes, they did. And within a reasonable degree of hospital administration probability, did you believe that from an operational standpoint that all prisoners met accepted standards for care? I mean, all children's? Yes, I did. Prior to the beginning of the cross-examination, during a discussion with the court, plaintiff's counsel raised the issue that he had never received documents requested in discovery and apparently relied on by Mr. Anderson for his testimony that the defendant hospital had met the accreditation standards of the Joint Commission. Thereafter, the following exchange occurred among the court and counsel. Okay, this is the judge. Well, it sounds like there was a specific request for the documents that this expert relied on. So, from a discovery standpoint, you have until 6 p.m. today to get everything that this witness relied on to the plaintiffs. Shapiro, they have every single document that he relied on. And I can read them to the court again, but I can re-email them. Thank you. That's fine. Thank you. We can re-email them in the next 10 minutes. And again, this witness will remain, and if we need to call him back, we'll do that. So, but for now, are you ready to go? I know you don't have these documents, but you'll have them sometime today. And we're as ready as we can be, Whitney. And just to be very clear, he was never sent joint accreditation documents. He didn't rely on joint accreditation documents. So I don't know that there's anything they're going to expect to get other than what I read. Depositions of Dr. Perno, deposition transcripts, Fourth Amendment complaint, Eighth Amendment complaint, the hospital records, Sally Smith's medical evaluation, all children's policies. Mr. Shapiro, if the witness relied on documents, they need to go to the plaintiffs pursuant to the document request. That seems like a very fundamental issue. I totally agree. I'm just making the record for the court. They have every single document he relied on. He didn't rely on Joint Commission documents. What you're reading is what you've provided the witness, which is a little bit different than the document request. So I've said what I said. 6 p.m., if not before. Let's do that. The cross-examination then began. The following exchange took place between plaintiff's counsel and the witness. So, now, did you actually get any of the JCAHO Joint Commission reports on Johns Hopkins All Children's Hospital? By JCAHO referring to the Joint Commission? The Joint Commission, of course, yes. I did not see their full report, no. You saw excerpts of the report? I saw comments and material I received referencing Joint Commission, yes. So you offered an opinion to the jury without actually reading the entire reports, right? I gave an opinion based on what the findings of that report seemed to be, yes. What the report seemed to be was selected by the defense lawyers, was it not? Well, that was where the information came from. You yourself never went out and actually researched to figure out for yourself what was relevant, what was not, as to any of this material, did you? The information I saw was provided by the attorney, but it had comments. It was a medical record information and other types of information, depositions and the like. That's the material I received. Following the cross-examination, the following questions and answers were asked and given during the redirect examination by defendant's counsel. Okay, and finally, regarding just briefly on the Joint Commission, the accreditation body for the hospitals, in your experience as a hospital executive officer, is that a requirement for hospitals to participate in a federal funding program? The Joint Commission is a volunteer activity. If they chose to go through it and are accredited, then they are enabled to bill for federal funding. And from your review of the materials you have, either publicly available or otherwise, did it appear that all children had participated in the program? Yes. After the redirect examination, the court asked the questions from jurors, including the following question, which elicited the following response from Mr. Anderson. Why did you not review the Joint Commission reports? The Joint Commission, the entirety of the report or reports is what I was making my comments about was that the hospital was, had been surveyed and had been accredited. And I wasn't referencing having seen the report. I was acknowledging that they had gone through the process of evaluation by the surveyors and that they had received the accreditation for their performance and review. On November 1st, 2023, the plaintiff presented the testimony of Dr. Joseph Corcoran during the rebuttal case. During the direct examination of Dr. Corcoran by Mr. Whitney, the following took place. Understood. Let's talk about the Joint Commission and the role that the Joint Commission plays in reviewing the hospital's performance. Objection, Your Honor. May we approach? Sure. The following was heard outside the hearing of the jury. I need my crew. Where the hell is my crew? Damn it, people. I'm going over to the Twitter thread to see if anyone is awake. MG Law, I'm very disappointed that you're not playing hooky. I need you people. There are sidebars. I'm doing them all by myself. All right, let's see. Mr. Whitney, I don't know the clock, but is this time being allocated to us? Court, it depends on how long it goes. Mr. Hunter, the objection is basically relevance in 403, Your Honor. JCAHO is not involved in this. There's been no JCAHO standards introduced or provided to us. In addition, JCAHO is a medical review committee in this context, privileged under Section 766. How did I handle this in the defense's case? Because I remember we had some discussions about the Joint Commission. I don't recall any discussions on Joint Commission. I do, briefly. Yeah, it was covered in witness Anderson's testimony. He was precluded from commenting on it, and then they asked their witness open-ended questions about what the Joint Commission found. So this is pure rebuttal. Mr. Hunter, if I could clarify, Without going too far backwards, Mr. Anderson, witness Anderson's testimony was that the hospital is certified by the Joint Commission. That's it. We didn't get deep into. Well, this was the. Did you provide him the JCAHO reports? And he didn't review the JCAHO reports. He was just looking at a summary that was provided to him, but he did testify about the Joint Commission. I remember that. The only thing that he said, oh, it's pronounced Jaco? Okay, thank you. The only thing that he said is the hospital has to be certified by Joint Commission in order to receive. I never provided him summaries. I guess my question is, how deep is Mr. Whitney going? Oh, he's going deep. One might say balls deep. The court. How deep are you going? Phrasing. What do you plan on asking him? I'm going to what the actual findings of the Joint Commission were at the time. That's here's my view on this. The defense specifically adduced Joint Commission matters. The Joint Commission's allowed to be. It's an appropriate subject for rebuttal at this time. The court then asked Mr. Whitney what Dr. Corcoran would testify to regarding the Joint Commission. You guys. I'm just looking at the chat. How deep would you like me to go? We're so bad. We're all about 12 at heart here. Oh, man. You guys are killing me. The court then asked Mr. Whitney what Dr. Corcoran would testify to regarding the Joint Commission and was told the witness would say the defendant hospital had been issued a finding of immediate jeopardy by the Joint Commission. The court then excused the jury and the witness and had a further more detailed discussion with counsel about Dr. Corcoran's expected testimony, the meaning of immediate jeopardy, and how a finding that the defendant was in immediate jeopardy contradicted Mr. Anderson's testimony. After that, the following exchange took place between the court and Mr. Hunter. I remember this. We actually saw this one. Mr. Hunter, first off, can you help me understand? Was John Shopkins All Prisoners Hospital under some sort of immediate threat finding by the Joint Commission? I'm going to tell Your Honor what I know, and since I was not, I don't know what documents. Aren't you the general counsel of the hospital or outside counsel? I'm outside counsel, but I don't know all. I'm not general counsel. I apologize, but help me understand. Was there some sort of... Well, there was a finding of that sort. I don't know the specifics of it, or at least I don't have it off the top of my head. There was a finding of that sort that was made that was a direct and virtually exclusive result of the issue over the Heart Institute. And that was the driving force, both behind the inquiry and behind the findings that were made. And that was what the findings were based upon, as I understood them to be, Your Honor. And this was during the relevant time period? It was in part during the relevant time period. Let me make sure I understand. Did the defense adduce evidence to have your witness bless the hospital, make it appear to the jury that everything was hunky-dory with the Joint Commission? I don't believe so, Your Honor, but I was not in the room when Dr. Anderson testified. The court called a short recess, following which Dr. Corcoran was allowed to testify on proffer. During his testimony, Dr. Corcoran said that a finding of it... Hey, guys, wait a minute. Didn't Hunter just say today that it was not during the relevant period of time? He just made that full-throated argument just a few minutes ago that it was not during the relevant time period. And yet, in this transcript, he said, yes, it was in part. So which is it, Hunter? He just continues to change his story from moment to moment, as if there isn't a court reporter clickety-clacking his every word. Wow, Hunter. Wow. Wow. Yeah, he did. He did that. Let me see if I missed any super chats. Hold on. Oh, God, you guys, this is terrible. Rumble's acting up again. What's it doing? I can't do anything about Rumble acting up, unfortunately. I hope that it's working. Try refreshing your screen. Those of you on Rumble having a problem, or if you're watching on the app, close it out and reopen it. Sometimes that helps. All right. So wait, where were we? The court then called the short recess. Oh yes, Dr. Corcoran testified that it was widespread and egregious. He recounted a telephone conversation with Jackie Crane, defendant's senior counsel, in which Ms. Crane confirmed the findings of IJ and expressed optimism that their corrective action plan would be accepted. In the proffer cross-examination, defense counsel questioned the witness's knowledge about the subject matter scope of the IJ finding and whether it covered the period of time when Maya Kowalski was in defendant's hospital. Based on Dr. Corcoran's proffered testimony, the court directed defense counsel to turn over all this information to the defense today. And then you're going to have a corporate rep sit for this probably tomorrow or the next day. The court called for a further short recess and directed counsel for the parties to discuss how to deal with this right now. After the recess, defendant's counsel addressed the court as follows. Mr. Hunter, we're trying to gather details, Your Honor, all those details that are in my desk and in my brain, because I'm the one who worked on it. What I've been, so I'm going to tell you what I know so far and what I've been told, and we'll try to, I would like the court's indulgence to investigate this further, to piece it together. But what I've been, because I've got a bunch of details about this in my closed files that I don't have off the top of my head. The long and short of what I'm being told. Oh, they're back. Hold on. We're back. Court's back. Hang on, guys. I gotta refresh. I'll be right back. Hold on, I'll be right back.
Mr. Whitney, I think she would need to address it. I'm not familiar with what the issue is.
Your Honor, if we're, maybe to be efficient, Ms. Ferrier found a couple of things that need to be renumbered on the verdict form.
Can she email that around?
I will, yes, Your Honor. She sent it to me and I'll send it on, so yes.
It's just on the verdict form as opposed to the instructions.
Yes, I don't think the instructions route people to the instructions just go linear.
That's correct, except for in the wrongful death survivor claims, there's a couple of cross references
Okay, well, look
on claim numbers, but I hope I got those.
Oh, okay. Let me send this.
I know Ms. Cross is primary on this, but I really don't think this requires her to weigh in. It requires the court to tell us what to do.
What exhibit number and what page are we talking about?
2819A. I can hand it to the court. 2819A 003. The defensive issue with this, Your Honor, is that there's highlighting that's embedded in here. The reason being, I received it in paper on Friday evening, and as I was thinking through questions, I highlighted some things. We're not able to cure that at the moment. So either they go back to the jury like that, or perhaps the defense can send us these pages for Ms. Green this evening, and we can send back to the jury without the highlighting. Oh, you told us okay?
Yeah.
Oh, it's okay. Never mind.
All right. So the highlighter gates is over before it even began. And so Ms. Quarles is reviewing the last exhibit.
Yes, Your Honor.
Now, and I don't know, Mr. Shapiro, if you're able to, Ms. Quarles earlier today said that there was one defense exhibit she wanted. Are you able to pinch hit for her? Since we've got 6 minutes.
Not accurately, wherever, if you don't mind.
Well, I want her to finish whatever she's doing, so.
I can ask for this.
Your Honor, while we're in a lull, when we're done with this, the jury's gonna come back and there's gonna be a rebuttal case, right? So I guess I'm trying to figure out, I won't be needed till late today? Later in the day.
I mean, I'm going to be giving the jury instructions. I see you sent around two cross references that have to be changed. Hopefully,
In the verdict form, yes.
you know, I don't know if you are coming back later on this afternoon or not. I don't know. That's up to you and your team.
I can come whenever I'm needed. I'm just gonna, what I was gonna do, I don't think I need to be present for the rebuttal case. I was gonna go ahead and sign off now and then maybe Samantha or somebody can let me know when it's, or Nick, when it's time to come back.
I think they heard you.
Right. I'll text you.
Okay, thanks, Nick. All right, we'll see everybody later. Thank you.
Mr. Shapiro.
So there was two exhibits that were discussed with Ms. Dede during her direct and cross-examination. Clay, can you pull up 3217-0722? This is with regard to the birthday card that there's some dispute over whether it was delivered. You know what, it's fine, it's part of the group from 718 through 722. If you want to start at 718, just scroll through the courts. Bases 718 through 722.
$718 through what?
722. This is all about the delivery of the birthday card.
Didn't we already have something like this?
I thought it was admitted into evidence without objection. Ms. Quarles tells me it wasn't.
Madam Clerk, is exhibit 3217 pages, was it 718 through 722 in?
Not that question.
I had the same recollection as Your Honor. Ms. Quarles told me it wasn't formally admitted.
Well, the clerk's telling me it's not in, so.
Did she testify to this?
Yeah, we would have an objection to Ms. Beatty's email to Wendy Kowalski claiming that, well, whatever she claims,
Hearsay.
it'd be hearsay.
I believe she testified to this. It also goes to her action plan,
Yeah.
not to the truth of the matter. So
Still hearsay.
Well, it would be used for the truth of the matter because they're trying to put this on DCF. So we object to that page. As for the email with the birthday card on 721, we don't have,
This one?
we don't have objection to that.
Oh, yeah. Yeah, the one, yeah.
Anything else?
no, Your Honor, this was discussed. I thought we had moved into evidence. We had verified all of this with Ms. Beatty. We would ask this to be admitted.
What is the first page that we're seeking to admit?
722 is the last email. They're in sequence between 718 through 722, and 722 is the email.
So what you're asking for starting with 718?
Yes, I don't think they have an objection for 718 through 721, correct, Mr. Whitney?
If I could see 1920 again.
They're just the scans of the birthday cards.
Yeah, no, yes, right. We have no objection to 18 through 21. We object to 22.
Okay, the court's going to receive Exhibit 3217, pages 718 through 721. I'm going to exclude 722 on hearsay grounds.
Well, do we want to withdraw?
Anything else?
Okay, that's fine. Nothing wrong. Thank you.
And did we get that last exhibit that you were working on, Ms. Crowell's, with the plaintiff's team?
We've discussed the redactions. I can proceed without it. If it happens to be handed to me in the middle, I'll address it, but we can move forward.
Judge, the only issue with the exhibits, and it can be corrected before it goes back to the jury, it doesn't need to be corrected before it's shown to the jury, is they have highlighting.
I think your colleague just,
Oh, you already talked about it?
Hi-
I am
highlighting
behind the
dates over.
times, Judge.
There apparently is no highlighting gate going on, so.
I defer.
Anything else before we bring in this jury?
Not the plaintiff's owner.
Defense, anything else before we bring in the jury?
don't wish so, Your Honor.
Let's bring in the jury.
Yes, sir.
All right, I do believe that Spicy Dr. Corcoran is coming back to the stand. We are going to finally have the rebuttal and then possibly get to closing arguments sometime today, although I don't know. We'll see. Spicy Dr. Joe Corcoran. Let's bring it. Bring it in for the win.
Okay, please be seated, everybody. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? Didn't see any media accounts. Is that correct? And no one approached you. Is that correct?
Correct.
Okay, Mr. Whitney, your next witness, please.
Plaintiff's call, Dr. Joseph Corcoran.
I do. Be allowed in right now. He's going to test it. Yes, they're allowing some of it in. I don't know how much of it, but this is what we've been waiting for. Let's bring it, Dr. Corcoran. Dr. Goodhair takes the stand.
Afternoon, Dr. Corcoran.
Good afternoon, Mr. Whitney.
I promise this will be the last time. Let's talk.
Promises.
Let's talk about how Johns Hopkins All Children's Hospital was managed during the time of Maya Kowalski's admission.
Very poorly.
And specifically, I want to touch on how risk management was integrated into the hospital's organizational structure. Let's start at a high level. And the jury has heard some discussion of the Joint Commission. Would you reaffirm for the jury the role that the Joint Commission plays in hospital accreditation, and governance.
Yes, so the Joint Commission is a nonprofit organization that evaluates hospitals and other
This is
healthcare
fine.
entities
We are live.
on a recurring basis to make sure that they are in compliance with the regulations, conditions of participation that are really the owner's manual to how to run a healthcare facility like a hospital.
And you just mentioned conditions of participation. Are those derived from federal regulatory guidance?
Yes, they are. So conditions of participation are actually published by CMS, the Center for Medicare and Medicaid Services, and they really form the foundation or the backbone of the accreditation process.
So we have the Joint Commission, it's a private entity. We have CMS, it's a federal entity. And then in Florida, is there also a state regulator that looks at these issues?
There is. The Agency for Healthcare Administration, also known as ACA, is based in Tallahassee. They oversee licensure and regulatory compliance for the state.
Now, with respect to the governing body of Johns Hopkins All Children's Hospital, have you come to learn about self-reports of deficiencies at the governing body level to these three entities?
Yes, I have.
What have you learned in terms of self-reports to let's start with ACA in December of 2018?
I understand that the hospital leadership, sometime around the Christmas holiday, but probably just prior to, actually went to Tallahassee to address in person issues that had been identified within the hospital that put them at odds with the conditions of participation.
Was there also a self-report to CMS?
Yes, in the week prior to Christmas 2018, ACA was also in December of 2018, but in the full week prior to Christmas of 2018, a leadership group also traveled to Atlanta, which is the regional office for CMS, and had a similar conversation with the federal regulators about shortfalls that they had been identified inside the program.
And then, given these issues and these self-reports, did the Joint Commission also become involved?
They did. And that was done through a self-report that I believe was done either electronically or in writing on or about the 28th of November, 2018.
And so you had then both the federal and the state entity and the private nonprofit Joint Commission looking at and scrutinizing the hospital's management structure at that point?
Well, yes, they were looking at it from that point, but there also had been some visits earlier in the year as well.
All right. Did these issues manifest for the first time in December of 2018?
No. My understanding is that the issues were first identified at the end of 2015.
Oh boy.
So they were not new issues.
Let's walk through the timeline with some documents. So if we could please display 2811A, page 1.
God damn it, law and crime. Keep the camera on the witness.
Dr. Corcoran, at the top of 2811, I see a header that says Agency for Healthcare Administration. Is that the Florida agency you talked about?
Yes, that's ACA.
Judge, I'm sorry, this doesn't say A, so I just want to make sure we're looking at the right document.
2811 was not redacted.
I thought you said A.
I'm sorry. My apologies. 2811. All right, we're looking at 2811,
Let's not forget Court TV.
Agency for Healthcare Administration. And below the Agency for Healthcare Administration, right there, if you could keep that where it was, what is this document? It says in the top left box.
Correct. This is a statement of deficiencies and a plan of correction.
And if you could note the date on the right side there for me.
February 23rd, 2017.
And so what's the relationship to the date of discharge of Maya Kowalski is at approximately a month and a half.
Yes, sir. About 6 weeks.
And this is a good view, so just keep it like this,
Ooh,
please.
the jury gets
And then
to see it.
the last two paragraphs we can see there on the left side, where were the deficiencies identified within the hospital?
In the risk management department as part of a risk management survey.
All right. If we could now display Exhibit 2815. I see CMS at the top right. Is this the federal agency you were referencing?
Yes, sir. Centers for Medicare and Medicaid Services. That's the federal regulatory agency.
And this letter or notice is dated January 31st, 2019. And who's it addressed to?
It's addressed to the interim CEO of the hospital, Dr. Kevin Sowers.
Have you come to learn when Mr. Sowers took on the position of interim CEO at Johns Hopkins Children's Hospital?
He became interim CEO in December of 2018. I'm not sure of the specific day, but it was in December following the departure of the previous CEO.
And who did he replace?
Dr. Jonathan Ellen.
And how long had Dr. Jonathan Ellen been the CEO of Johns Hopkins Children's Hospital?
Gosh, 6 or 7 years, if memory serves.
So Dr. Ellen would have been the president and CEO of Johns Hopkins Children's Hospital during the time of Maya's admission.
That's correct.
And if you could zoom out a bit for me, and that's a fine view there. In the second paragraph in the letter, it references a determination of immediate jeopardy. Do you see that?
I do.
Would you please explain to the jury what immediate jeopardy is?
So when deficiencies or non-compliance with the conditions of participation, the rule book, when those deficiencies are considered egregious, widespread, actually it's defined further down as, could you scrap that please? It's defined as an immediate or serious threat to patient health and safety. So an immediate jeopardy is as severe a finding and it carries an equally severe threat if an immediate jeopardy is not remedied quickly in a timely manner. You're given with an immediate jeopardy, you are typically required to provide an immediate mitigation plan before the survey team leaves. You then have to send a corrective action plan within 10 days and have that largely executed within 23 days.
Nope,
If you
not
fail
today,
to meet that
Stevie.
23 days, you potentially lose access to all funding from Medicare and Medicaid.
Is it more or less a death threat to a hospital?
It is a financial death threat to a hospital. Yes, sir.
I'm sorry, what's the legal base leading, Your Honor? Overruled.
Overruled.
Is there any classification under CMS evaluation and survey more severe than immediate jeopardy?
None that doesn't involve literally taking over the hospital.
All right. If you could drop that and then pull up the bold text there that are the 42 CFR sections for me. Now, a few moments ago, you referenced conditions of participation.
Yes, sir.
And we see here reference to the federal code of regulations. Are these the conditions of participation you were referencing?
Those are 4 of them.
All right. And why are these 4 on this document?
Okay, so the immediate jeopardy was centered on 4 specific shortfalls in their
Here it comes.
exercise of meeting the conditions of participation. Governing body is the interaction of the board, which has ultimate responsibility for the entire facility, and the 2 primary parties, the medical staff, represented by the medical executive committee, and the administration or management of the hospital, which starts with the CEO. quality assurance and performance improvement. That is making sure that we're staying between the guardrails and delivering good care.
I'm going to stop you there if you're.
Thank you.
All right. So if you look at these 4 things, these are the specific deficiencies that Johns Hopkins All Children's Hospital was found to have exhibited or demonstrated at this time.
These were the areas where their deficiencies were so egregious and widespread that they contributed to this immediate jeopardy. Correct.
All right. And have you had an opportunity to hear the VP of Patient Safety and Quality discuss these issues?
I did.
Who was that?
Ms. Green.
What was her first name?
Virginia.
Okay.
Is this a quiz?
Does Angela sound right?
Angela, sure. I'm sorry.
That's okay.
I apologize to Ms. Green.
In terms of having been issued a finding of immediate jeopardy, did Ms. Green conduct a retrospective review of hospital records to see where these deficiencies should be placed in the responsibility place?
Yes, she did.
And how far in retrospect did she look back to determine where the hospital had fallen short?
She said that one team in the hospital went back 3 years, and I believe that she took her response back 5 years.
Judge objection, hearsay.
Party admission.
Overruled.
And so whether it was 5 years, so they're conducting this retrospective review in January 2019, receiving this letter.
That's correct.
It would take us back on the 5-year basis to January of 2014,
That's correct.
or on the 3-year basis to January of 2016.
That's correct.
In their review, without getting specific, were specific deficiencies noted in that retrospective review?
There were.
And generally, did those have to do with adverse patient outcomes?
They,
Objection, Your Honor. I think we're going beyond scope.
Sustained on that one.
All right, I'll move on. Let's put up 2817, please. Now we're going to get into some of the internal communications at Johns Hopkins that surrounded
Should be 2817A.
2817A.
Sorry to interrupt.
No, thank you. Okay. So here it's 2817A. We have an email from Ms. Green dated February 25th, 2019. So this would have been just following the notification of immediate jeopardy. Is that correct?
about a month after. Yes.
And then,
3
and then we
weeks.
can see there her position at the time. What is the role within a hospital of the Senior Director for Patient Safety and Quality?
Well,
Objection, Your Honor. Foundation.
Overruled.
as the title suggests, they lead a team whose primary objective is to make sure that the care as it's delivered is delivered in a safe manner. Above all else, do no harm.
they
And
failed
so
that really
they are responsible for making sure that the care is safe and the quality of the outcomes are optimized.
If we could advance to
need
page
to
3
do
of 2817A, please. And if you could get a whole page view for page 3. All right. So I want to focus for a moment first on the subject line at the top of this email. It says, how about this for Kevin's talking points to the board on CMS 2567? Now, here, who is Kevin?
She's referring to Kevin Sowers, who was the interim CEO that replaced Dr. Ellen.
And the CMS 2567, is that the finding of immediate jeopardy?
CMS 2567 actually refers to the form number. Government issue forms always have an ID number on the base, and CMS 2567 is the page, the report that the findings are actually published on and made available to the hospitals.
All right. And so in the middle of the page, there's a paragraph that's short. It says there are 4 major areas we are actively working to improve. Would those map back to the 4 conditions of participation we saw a moment ago?
They do.
All right. Let us advance to page 5 of this exhibit, please. And we're going to talk specifically about the governing body and what types of issues were noted within the hospital during this retrospective review. The first bullet point under governing body, if you'll read that to yourself, and my question for you is, what have you learned about what was lacking between the message and the elevation of information between the president and the board in the previous 3 years?
So again, the board has the ultimate responsibility to make sure that everything is running as expected. It was demonstrated through this process that there was poor communication where problems were not shared appropriately. They weren't shared between, remember we talked about divisions, they weren't shared laterally, they weren't shared up. And they were certainly not getting shared to the board. So the board really was not able to do its job of overseeing the quality of care.
And then if we move down to the third primary bullet point, there's a smaller one in between. That's why I said primary. But it begins with structuring of risk management to report directly to the health system. When Ms. Green or Ms. Franklin references reporting directly to the health system, what is she referencing there?
She's talking about having a direct link of communication to Johns Hopkins Health System in Baltimore. Prior to all of this, Johns Hopkins All Children's Hospital was the only one of the Hopkins affiliated hospitals that didn't have that link. In other words, at Johns Hopkins, everything was by design kept locally and was supposed to be managed locally. This gave them an opportunity and access to the expertise that is, that candidly is one of the things that Johns Hopkins is really known for around quality and patient safety. So it was giving them access to that expertise.
So just so I make sure I understand, there are several Johns Hopkins hospitals within the Johns Hopkins Health System.
Correct.
Johns Hopkins All Children's Hospital is one of them.
That's correct.
And it was discovered during this process that Johns Hopkins All Children's Hospital was the only Johns Hopkins Health System hospital where risk management at the hospital level was not reporting to the system. Is that right?
That's correct.
Then if we move down 3 from the bottom, it says the revision of the complaint and grievance process. There's been some discussion in this courtroom about the complaints made by the Kowalski family. What is the proper operation of the complaint and grievance process as it relates to risk and patient safety within a hospital?
Check your eyes down scope.
So a grievance actually is recognized as having specific responsibilities. As a hospital operator, if my team received a grievance, we were required to answer that grievance within 10 calendar days. And there were, again, communication issues where grievances and complaints, like the Kowalskis shared with members of the staff at All Children's, were just not addressed at all, let alone in 10 days.
And then the last I'd like to focus to on this page is the last bullet point. It says massive education campaign on speaking up and speaking out. Have you had an opportunity to hear Ms. Green discuss this campaign?
I did.
What was the genesis of this massive education campaign?
So she described that members of the care team in a variety of positions, if they raised awareness of something not working, whether it's an outcome or whether it's a glitch, there was, number one, it was difficult to get an audience. And when you did open your mouth, she cited examples of where there was retribution against a whistleblower, a complainant. This speaking up and speaking out was a program that they put in place, kind of like see something, say something. And it was to change that. It was to encourage people to speak up when they see something wrong.
Was this because there was a culture of retaliation and retribution previously?
Yes, sir.
Your Honor, leading calls for conclusion.
Vote on both instances.
If you could repeat your answers in case.
Yes, there was she spoke of a culture of retaliation and retribution.
Against internal employees.
That's correct. Anyone who spoke up did so at significant risk.
If we could advance to the next page on page 6, please.
That's huge.
Here, Ms. Green, or Ms. Franklin references multiple town hall meetings. Do you see that reference in the last bullet point?
I do.
Have you had the opportunity to review some video of those town hall meetings?
Yes.
What were acknowledged as several of the hospital's failures in those town hall meetings?
So the town hall meetings were hosted by Dr. Sowers, Kevin Sowers, who was the interim CEO that followed Dr. John Allen's departure. And he was very candid about where they were falling short and basically promising to do better. He acknowledged that their shortfalls in governance were, I believe the term was substantially contributed to prior lapses in care. He talked about why they got the IJ, what was involved, and how they needed to turn things around. He characterized at one point that Hopkins let us down. And I think he was speaking for the Johns Hopkins All Children's Hospital community when he made that statement.
You threw in the middle of that IJ.
Yes, sir.
Define what that acronym is, just in case.
Again, I'm sorry, immediate jeopardy. That's the financial death threat that I referenced earlier.
All right, if we could advance to 2818A, beginning at page 069, please. Yeah, first one, first page. If you'll just zoom out so we can see the whole page, please. All right. Now, am I correct that this is the form 2567 that was discussed earlier?
You can see on the bottom left, it says Form CMS 2567. Yes.
So this would be the document that CMS speaks to the hospital through about where the deficiencies were noted.
That's correct.
And am I correct that in the left column, on some pages, you'll have more description of the deficiencies, but in the right column, you'll have the hospital's efforts to correct their deficiencies?
That's correct. So the left side is where they cite in the first column, they cite the specific standard or condition of participation where the hospital is not in compliance. In the wide column to the right is where they will describe, this is the standard, this is what we saw, this is where you're not meeting expectations. And it tends to be fairly specific. To the right of that, the broad column is where the hospital writes in their plan, their corrective action plan to address that specific element of the shortfall.
And Mr. Reyes, if you would, there's two bullet points there on the right, in the right column, if bold text. If you could just pull out the bold text for each of those so we can focus on those. All right, so this first bolded bullet point speaks to the organization as it related to the risk management department. What did you learn about the failures and the ways that the hospital integrated risk management into their division level operations?
So this points out that risk management was not included in the process.
And further down in that paragraph, it references before that bullet point, it says the JHatch functional org structure chart, was updated to reflect the relationship of the MEC. What is the MEC in this reference?
Medical Executive Committee.
All right. So
and they oversee the medical staff.
And so it was at this point, having the deficiencies been noted, it was the org chart was restructured so that risk management was properly reporting to or talking to the MEC medical staff, the president, the board. Is that right?
That's what it indicates, yes.
And then the next bullet point, if you'd read that to yourself about no evidence of risk management reports, and describe to the jury, please, what kind of failure that indicates.
This was very surprising. It indicates that over 15 months prior to the survey, that there was no demonstrated effort to track and trend what was going on in the hospital in terms of quality.
Oh my God.
I think Dr. Perno and Dr. Napolitano both talked about tracking and trending as the key function of the risk management committee, which is different than the risk management department. And if you're not collecting data and if you're not sharing data, it's impossible to do that. So the idea of tracking and trending is if you notice something that starts to go off course, you push it back on course before it drifts way off course. So without the tracking and trending, there really were no guardrails effectively.
If we could advance to page 72 of it's 3 more pages. Next page. And the top, that's perfect. Read that first bullet point to me, if you could.
Starting with according?
Yes, sir.
You want me to read it out loud?
No, I just want you to read it to yourself.
Okay.
And explain to the jury the significance of adverse medical incidents residing with the risk manager and not being elevated.
Right. So adverse medical incidents covers a variety of harms that occur in the hospital, impacting mostly patients. And so it looks like those harms or adverse medical incidents got to the risk manager, but again, they weren't shared. And they weren't shared up to leadership. Jackie Crane was over the risk management department until her departure. And there was no portal until after corrective action was put in for these to be shared at a system level. So, I mean, it's metaphorically, it's the equivalent of just being stuffed in a drawer.
And you mentioned there Ms. Crane, who was senior counsel.
She was.
And when these issues were finally discovered by the federal regulator, was she removed?
She exited at the time that Dr. Ellen exited.
Now, this document is quite detailed, and the jury will have at least 16 pages back there, so I'm not going to go through every specific deficiency. Let's move to 2819. 2819A. Excuse me.
I was ready.
All right, so here we have an email from Ms. Green, January 16th, even before the CMS letter was delivered on January 31st, correct?
That's correct. This is dated January 16, 2019.
And it's addressed primarily, or at least first, to Mr. Sowers, the interim CEO.
Correct.
All right, and then she attaches, let's go to page 2 of this, please. She attaches the hospital's anticipation of what's coming and how they're going to rectify the situation. So let's go to page 3. And we've seen these terms in, let's say, federal regulatory agency speak, but here they are in the hospital's words. So we're just looking at the focus area of governance and the 2 primary findings there. Would you speak to those? Let's start with over-reliance on department-level case review. Would you please explain what that means?
Right. So recall that the Department of Pediatrics had 15, and at this time, I believe they had actually 20 divisions reporting up to it. So the Department of Pediatrics, which is pediatric medicine, managed 15 to 20 different divisions, and then the Department of Pediatric Surgery managed all of the surgical subspecialties. And so they in this governance structure, they created parallel systems for quality assurance and performance improvement. And so again, they were kind of left to police themselves.
And the second one there, issues did not flow freely to the board. You've spoken about that a little bit earlier. Is there anything to add?
No, again, if the board is accountable. If something goes wrong, the board has its feet held to the fire. But as we've seen elsewhere, if the information is not flowing in and they're not able to pull the information up, they can't do their jobs.
And then we get to the second focus area, which is culture. And it references the fear of retribution with speaking up that you mentioned earlier.
Yes, sir.
How does hospital culture manifest at the patient level?
So,
Objection, Your Honor, beyond scope calls for speculation.
Overruled.
so culture starts at the top, and one of the elements of just culture, which is actually a formal program. One of the elements is that you really want to think about what's best for patients. And it acknowledges that mistakes can be made, and it tries to differentiate between I made a mistake or I knew it was wrong and I did it anyway. The focus on culture as the patient sees it, that's really the patient experience. Are my needs being met? Do I feel like I'm being listened to? Are people advocating for me? You know, Maya was 10 years old, celebrated her 11th birthday at the hospital.
Let me interrupt you for a question
Please.
before I get an objection.
Sure.
You mentioned an advocate. What is the concept of a patient advocate within a hospital?
Well,
Objection, Your Honor, beyond scope.
Overruled on that one.
a patient advocate is somebody who is keeping an eye on all the moving parts. You know, there's a lot of focus on what the doctors do, appropriately, but there's an awful lot of people that have to do their jobs well if that care is going to hit the target. And so an advocate is someone who is kind of watching all the inbound aircraft and making sure that they're aligned for what's best for the patient.
Is it true that a patient advocate would be someone that would be present with the child over the course of their admission?
Leading.
Not side by side. I'm sorry, Judge.
I'm going to sustain the leading.
Have you observed the different and had an opportunity to watch the testimony of the different witnesses that the defense presented here?
Many of them, yes, sir.
Did at any point you see someone who claimed to be the patient advocate for Maya Kowalski?
Objection, Your Honor. Relevance calls for conclusion, calls for argument.
Overruled.
Somewhat surprisingly, no. We heard a lot from members of the teams, the medical team, the social work team, the risk management team, and there was a lot of team management talked about in how Maya's care was delivered. But I don't recall hearing from anyone that
Nope.
was really playing guardian angel, somebody who was really looking out for Maya and her care.
If we could advance to page 5. And this is the last one we'll speak to in this hospital presentation. Disclosure and communication with families. And then it says inconsistent practice and documentation after adverse events. Would you please explain this concept in the context of hospital management and the importance of communication with families?
Objection calls for argument and for a narrative.
Overruled. You can answer.
Thank you. So I tell my doctors and my team, when I was in the role, I told my doctors and my teams, if you make a mistake, own it, just like I tell my kids. So disclosing, hey, we made a mistake, is considered an important first step in communication and regaining trust that can very easily be lost if a mistake is made or if outcome is not what everybody intended to get. So inconsistent practice means that there was no endorsed or encouraged best practice for all of the divisions and ultimately the departments to follow.
Through your observation of the testimony here, including that of Dr. Jennifer Katzenstein, has it come to your attention that Jack and Beata Kowalski attempted to communicate their concerns with the hospital?
Objection, Your Honor. Based on province of the jury's calling for editorial comment on the testimony.
Sustained.
We can take that down. Based upon your background training experience and to a reasonable management probability, do you believe that the deficiencies that we've discussed here caused or contributed to the patient experience and the harm done to Maya Kowalski?
Objection, foundation. Overruled.
Without question, the gaps in the function of the governing body, again, Dr. Sowers said it was a contributing factor in previous lapses. I have no reason to counter that opinion. It's undoubtedly true that they contributed.
All right, nothing further this time.
I cannot believe they spent this much time
Mr. Hunter, are you?
off of the witness.
It's not me.
Ah, back to Maya again. Hunter's not going to question him. Who's going to question him? Mr. Ruel?
Good afternoon, Judge.
Good afternoon, sir.
Oh, it is Hunter. It's not Shapiro? That's a real letdown.
You were provided a number of documents regarding various surveys, correct?
I saw several documents that involved surveys. Yes, sir.
Were you given a set of documents regarding a joint commission triennial survey from September of 2015?
I saw the summary of it. Yes, sir.
That resulted in the joint commission accrediting the hospital, did it not?
In 2015, yes, sir.
All right. And that accreditation was good for the following 3 years unless it was revoked, correct?
That's correct.
All right. And did you also see a survey? And incidentally, these surveys are fairly arduous events, are they not?
Typically, you've got 3, 4, maybe 5 surveyors on site for 3, 4, or 5 days. Yes, sir.
When you were at Brandon Regional Hospital, did you handle those?
I was absolutely involved in every day that they were on site.
Very searching review, correct?
They were stressful. Yes, sir.
All right. They went to all aspects of the hospital, correct?
They did.
All right. So when they did that at Johns Hopkins All Children's Hospital in September of 2015, they reaccredited the hospital, correct?
Yes, sir.
And then in 2016, they did a follow-up random review. You saw that, did you?
I don't, could you refresh my recollection on that, sir?
Sure. Wasn't there in March of 2016 a follow-up review of evidence of compliance with the accreditation they had been granted the year before in March of
Objectionable
2016?
for improper way to refresh recollection.
Right, if you're gonna refresh his recollection, why don't you show him the document?
Let me get that pulled up, Judge. Let me ask a couple questions first before I do that. Here you go.
Yeah, he really is going to try and say that the accreditation is looking forward 3 years and not backwards.
You were present during Ms. Green's deposition the other night, right?
I was there. Yes, sir.
And were you provided a copy of the review done by the Joint Commission in March of 2016?
Mr. Hunter, I can't say with certainty that I was. It was Parents' Weekend at my son's college, and I was up in Gainesville. So I played dad instead of expert witness this weekend. I can't tell you which documents off the top of my head, which documents I saw and which I did not. I certainly did not see but a small fraction of what was turned over.
Okay. Well, did you see a risk management survey that was done by ACA in February of 2017?
Again, I'd like to have my recollection refreshed. I don't recall which ones I've seen and which I didn't see.
Did you
Just-
see?
Just hand him the document if you.
Judge, I'm sorry that there's a stack of documents that would gag
Yeah,
three
just
billy
hand him
goats
the
and a maggot
document.
about this tall.
I don't understand what that means.
Well, it's a lot of documents. And I don't have at my fingertips the ability to grab that particular
Quit
document.
asking about it.
I had a
Do we need to take a few minutes so you can organize?
It would be very helpful, Your Honor.
Why don't we take 5 minutes?
Who would
Members of
do
the jury,
that?
do not discuss this case amongst yourselves. Do not do any investigation. You
Oh.
receive no information.
Do you see what just happened
All right.
there? Do you see what just happened there? So the judge is not going to let Hunter do the thing that attorneys do. Hold on, let me stop sharing this so that maybe my camera will fix itself. The judge is not going to allow Hunter to do what attorneys like to do, which is to say, well, did you see this document? And did you see that document? And then not produce the document. And the jury's not seeing these documents either. They're not in as evidence. So it's just, well, did you see this? Did you see that? And of course, the witness is like, well, there were like 30,000 documents. So I don't know if I saw that one. Why didn't you show it to me? Oh, what's he saying? Hold on. He's saying they're going to take 10 minutes. 10 minutes. All right, that's it. They're going to take 10 minutes. He just came back to ask the lawyers how much time they needed. But the judge is not going to allow Hunter to play that game of, well, did you see this? No, you didn't. Okay, moving on. Did you see this? No, I didn't see that. No. Well, then you don't really know what you're talking about, do you? The judge is like, no, go get the document. Show him the document. Of course he's playing games. Of course he's playing games. This is crazy. Why aren't they ready? Because Michelle, he never planned on showing the documents. None of these documents look any good for them. And they know it. They know it. I bet, let's take bets that when he comes back, he does not have documents he wants to introduce, and he's just going to say, I'm moving on to different questioning, Your Honor. I don't have that. I couldn't get them together in time. How much you want to bet? All right, we have 10 minutes. Oh, I know I wanted to show you. Somebody sent me this on Twitter, and oh my God. Check this out. This is really sad. So this is an email from Hunter to David Silverstein and Patty Condon, who are the DCF lawyers for DCF. This was on January 11th, 2017. So a few days after Beata had died. This is from Hunter to the DCF attorneys. David, Below are my thoughts regarding the stipulation. They're trying to get the case, the case is being dismissed, and so they need an order from the court, and that's what they're discussing, I believe. Basically, I've corrected the name of our institution to Johns Hopkins All Children's Hospital and made it clear in paragraph 4 that thus far placement in an appropriate institution for inpatient, look at this, placement in an appropriate institution for inpatient physical and occupational therapy, along with mental health treatment, has not been possible. I have also indicated that in the meeting with Doctors Major and Elliott, Dr. Katzenstein may be needed. So, after all that, the inpatient program that they all said they wanted for her is not possible. I put in language in paragraph 7 requiring that the father direct and facilitate the child's cooperation with mental health treatment. I would suggest that you put something similar in with respect to OT and PT. I also noted in paragraph 13 that the father should turn over to DCF for proper disposal, because they're really good at throwing shit in a dumpster, any and all ketamine and narcotics in the possession of the family or child. Yeah, right. Like turning those over to DCF, they're not going to get either used or sold. Anybody believe that? You've seen social workers on this channel and others. I put in language, let's see. I would recommend that you put somewhere in the stipulation that the father be directed to completely cooperate with the mental health counseling, PT and OT, encourage the child's cooperation, and in no event and under no circumstances disparage the healthcare professionals or the treatment in the presence of the child, taking away his First Amendment rights to speak and to have an opinion on the care that his daughter is getting. There might be a phrase that indicates that, should the father have concerns regarding the treatment, clinical course, or the child's response, that such issues be drawn to the attention of DCF and the case manager through counsel for further discussion and resolution, and if necessary, action by the court. So here's the stipulation. I do not know, however, if this was agreed to or signed. So we'll read it, but I don't know if this is the one that was adopted. We don't know. The parties, the State of Florida Department of Children and Families, the Safe Children Coalition, the father, Jack Kowalski, the guardian ad litem, the child, and their respective attorneys hereby stipulate and agree as follows. The department shall file an amended dependency petition with the following allegations. The child has complex medical and mental health issues for which assistance. Oh, what medical issues? What complex medical issues? Which ones? What complex medical issue does she have? And at this point, her mother is dead. So the child continues to have complex medical health issues, and her mother's nowhere around. So it ain't Munchausen. Yeah, Hunter was involved in removing Maya from her family from day one and in keeping her removed from her family. This man is a bad man. The court shall place the child in the father's custody under protective supervision by the department, under the conditions described below and after the services described below have been implemented. You know what that means? That means that DCF still would have a hold over him, and they could come and take her whenever they wanted to. The parties acknowledge that Johns Hopkins All Children's Hospital recommends that the child receive daily inpatient physical and occupational therapy and mental health treatment to address a conversion disorder. The parties understand that thus far, place in an appropriate institution in Florida has not been available. The parties acknowledge that JHatch will, provided conditions are agreeable to the court and parties, discharge the child to the father for outpatient physical and occupational therapy and mental health treatment under the conditions described below. The father shall meet with Dr. Alexis Major and Dr. Richard Elliott, as well as needed Dr. Jennifer Katzenstein, to discuss the child's discharge diagnosis and treatment recommendations. The child shall immediately undergo an evaluation at Rogers Behavioral Health, Tampa Bay. If the child is accepted for treatment by Rogers Behavioral Health in Tampa Bay, the father shall fully engage with the child's mental health treatment professionals and follow all recommendations of the child's mental health professionals, and shall direct and facilitate the child's cooperation. The father shall not discuss the child's diagnosis with the child unless approved by the child's mental health treatment professionals. If the child is not accepted by Rogers Behavioral Health, Tampa Bay, then the parties shall work together to determine a mental health provider who can treat conversion disorder. The father shall take the child for examination and treatment to either of the following pain management and rehabilitation physicians. Of course, what does she need pain management for if it's all in her head? Dr. Dennis A. Hart or James Chinarian, Pediatric Rehabilitation Medicine, Dr. Paul Kornberg. Kornberg's the one that works with Dr. or Nurse, what's her name? God, what was her name? Betty Rice? Something Rice. Is it Betty? The blonde. The father shall follow all recommendations above. The father shall take child for examination at any recommended treatment to the following pediatrician: Patricia Blanco or some other pediatrician. The father shall follow all recommendations of the above pediatrician. The father shall ensure that the child receives physical and occupational therapy daily, or Sarah, how dare they tell Jack how he can behave and speak? Because they're the jackbooted thug state. That's how. Do you not still see how much power that the state has over your life if they decide they want it? They can order you to do anything. They can order you to walk around in public with a sign around your neck that says, "I'm a child abuser." They can do whatever they want. And what are you going to do to stop them? Bonnie Rice. That's right, Bonnie. What are you going to do to them? If you don't have $100,000 to hire some lawyers and sue, you're going to do exactly what they tell you to do. And if you notice, Jack had to do exactly what they told him to do. How many years went by before he's been able to be in court? What has his life been like between then and now? Dealing with caseworkers and DCF. It's unspeakable, the kind of power that the state has over your life. It's unspeakable. It's disgusting. Our founders would roll in their graves if they knew what we were putting up with from agents of the state who mostly don't even have high school degrees. They get their GED and then they're handed power over your life. These are people with you want to talk about medium smart, they're low IQ. I showed you clips of social workers, the people who have this kind of power over your life. I don't think they could write a proper sentence. Court back. I don't think they could write a proper sentence. The jury's coming back in the room now. We're talking about people who I don't think can read the Declaration of Independence, let alone understand it. We're talking about people I don't think have ever read the Constitution and the amendments, let alone understand them and interpret them. Yet their entire job consists of making sure they don't violate your rights. They don't even know what they are. They don't even know what they I've listened to enough depositions
Please be
done by
seated,
Sean
everybody.
McMillan, and I know that they don't know what the Fourth Amendment
Members
is.
of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did not do any investigation and receive no information. Is that all correct?
Oh,
No
these
one approached you
cameramen.
about this case. Is that correct? And you didn't see any media coverage. Is that correct? Mr. Hunter?
Yes, Your Honor. May I approach witness?
You may.
Dr. Corcoran, I've got a accreditation report here from March of 2016. You ever seen that before?
I don't believe so.
Okay. So, you've never reviewed what I just showed?
I don't believe I've seen this particular report.
Yeah, I'm really approached for a moment.
Sure.
All right, they're going to approach. because now they're trying to introduce, Hunter's trying to introduce evidence that I don't think has gone through the proper channels. And of course, Court TV is still focusing on Maya's face, which is why I keep putting up the memes, because I'm not having that. I think it's totally outrageous that they're doing that. It's outrageous, and my camera's freezing again. Dang it! I'm going to take this opportunity to refresh StreamYard real quick. Oh wait, maybe not. They're coming back. All right, here they are.
So the jury's aware you were provided a number of documents, or you attended a deposition Friday night?
I did.
Okay. There are a number of documents that you got to see as a result of that, correct?
Yes, sir.
Okay. The one I just showed you, you said you'd never seen before.
I don't recognize it. It may have been introduced, but I don't recognize it.
Well, my question to you is, do you have any reason to question the proposition that in March and April of 2016, a joint commission survey occurred unannounced at All Children's Hospital and their accreditation was affirmed?
Objection, counsel testify.
Overruled. You can answer.
I'm sorry, can you repeat this question, please?
Yes, sir. Do you have any reason to question that in March of 2016, followed up in April of 2016, a joint commission survey took place at Johns Hopkins All Children's Hospital and that their accreditation was affirmed?
So I have no reason to question you. And that if accreditation was renewed in 2015, then unless there were a flagrant violation, accreditation would not really be on the table at that time.
Well, wouldn't there be occasional random follow-ups to accreditation inspections?
Short answer, no. Most of the time, Joint Commission returns to a facility in response to a complaint or awareness of some kind of a problem.
So you've never heard in your long experience of random surveys taking place after an accreditation in the preceding years?
Objection, argumentative.
Overruled.
There can be follow-up surveys. When the accreditation survey is done, then CMS actually audits the work of the Joint Commission and will come in and do, I'm blanking on the term for it, but they will basically come in and affirm that the Joint Commission survey is accurate.
Okay. The document I just showed you was a Joint Commission survey, correct?
I believe so, yes, sir.
And you have no reason to question that it affirmed the accreditation?
Well, I don't think that was in the time frame. Typically, CMS comes back in 45 days or less. So I don't think that's the kind of survey that I was referring to, sir.
All right. Well, let's go with this another way.
May I, if you'll show me the document, I'm happy to do a quick review of it.
Well, I'll be happy to show you this and the two subsequent follow-ups.
Boy, they just keep that camera right on Maya. It's so gross. The judge needs to tell them to stop it. I don't know why this courtroom is different than other courtrooms. Oops, I thought they were moved off of her. It shouldn't be any different.
Just the three, or is that it?
This is a different
Okay.
one.
Can you give me a minute to look at them?
Sure.
Okay.
Perhaps, Mr. Hunter, you could return to the lectern.
So he's standing by the witness. Was he standing by the witness? Intimidation.
So on the survey done March 7th, which was unannounced by the Joint Commission, they found elements of performance where there was insufficient compliance. Social work consult for a patient on suicidal precautions was not performed until approximately 9 hours after. There was another element of insufficient compliance that related to moderate utilization of moderate or deep sedation or anesthesia.
And were there, excuse me, were there indications of a follow-up that established compliance?
I'm looking for that in the next visit, sir. I just want to match up the EC. So this visit that was approximately a month later is a survey addressing different elements of participation, different standards.
And it indicated compliance.
This shows compliance. This still has some outstanding issues.
And there's a subsequent that shows that was placed in compliance, correct?
Piece it 1 second, sir. So this survey dated 4/22, which is the 45-day evidence of standards compliance, does show compliance with the anesthesia related fallout, but not the leadership one. And this one dated May 3, the 60-day visit, does show LD 040105 is now compliant. So from March until May, they had issues and they corrected them.
And that's fairly typical of Joint Commission surveys, is it not?
Yes, sir.
Happened in your hospital, didn't it?
Many times.
And incidentally, there's a number of ACA inspections of your hospital, correct?
ACA is a frequent visitor to most hospitals, sir.
Frequent visitor to Brandon Hospital, correct? For complaints and otherwise.
I will tell you, during my tenure, they were frequent but not overwhelming.
Now, isn't it also true, sir? Well, let me just ask it this way. You were given a report of an unannounced accreditation survey by the Joint Commission of Johns Hopkins All Children's Hospital in August of 2018?
Unannounced in August of 18, wasn't that when they had their re-accreditation visit?
Yes, sir. Yes,
And
sir.
there was a second visit
Yes, sir.
the same month?
Yes, sir.
I don't believe I saw that one.
Okay. But those visits resulted in reaccreditation, did they not?
Not the second visit. That's not a reaccreditation. They were reaccredited in August of 18,
Okay.
but that was their triennial review. Yes,
Okay.
sir.
So the point I'm making here is that in August of 2018, there was a triennial reaccreditation survey done by the
Right.
Joint Commission that resulted in reaccreditation, correct?
Right, and all of the violations were on the safer matrix in the lower, less frequent quadrant.
That's where you want them, right?
Amen.
So in August of 2018, the 3-year accreditation that was issued in September of 2015 was continued, correct?
Somewhat surprisingly, yes.
Well, editorial comment aside, it was continued, correct?
Well, again, given the presence of ACA joint CMS starting in April of that year, yes, they got away with a remarkably benign evaluation.
Okay.
And it was, in fact,
And it indicates
reaccredited.
effort on their part to do that, correct?
Okay.
Incidentally, were you provided information regarding a CMS survey of all children's in May of 2017?
Again, can you show me the document? so I
Sure,
can
I'm showing the
refresh?
witness trial exhibit 2823-001, marked by plaintiff.
Yes, this was a visit specific to the pharmacy.
Showed compliance, correct?
I believe there were no issues identified on that visit.
Okay. Now, let's talk for a minute, if we could, about some of the reports that council walked you through. Let me first have direct your attention to trial exhibit 2811. You can put that up for. I'm not sure we need to see the details of it, but
StreamYard is slow.
was there
so
any
go ahead.
indication
It's
in that report?
slow.
And you reviewed this, right?
I did
Okay.
this today.
Okay.
Yes, sir.
You testified about this a few minutes ago.
I did.
For council.
Yes, sir.
Okay, so were you aware of any joint commission survey of the hospital being done at the same time or around the same time as this particular report?
I'm struggling to answer clearly because there were so many surveys. Candidly, Mr. Hunter, keeping ACA from CMS is a challenge given the short timeline and my cursory review of just a part of the documents that you shared.
Well, let me show you what I'll represent to you as a joint commission correspondence from Mr. Sowers dated February 25th, 2019. Were you ever shown that?
Yes, this is a letter that documents the acceptance of the conditions of, the plan for corrective action from the IP. Is that correct?
I believe you'll see
From the
that-
IJ, sorry, the immediate jeopardy.
I believe you'll see that that indicates that there was a survey done by joint commission at or about that time that resulted in a finding of compliance.
Yes, the services at your hospital were found to be in substantial compliance.
That was a joint commission survey that occurred, correct?
And that was done 1 month after, or 23 days actually, after the IJ. And 23 days is kind of that magic window that if you're not in compliance by then, you are at risk for losing your funding.
I'm glad you brought that up. So the IJ was issued by CMS, correct?
Correct.
All right. This is the joint commission.
Right?
They're not the same thing.
They're not.
Okay. So the joint commission found that there was substantial compliance. And the CMS was in the process of following up on the IJ, correct?
So it gets even stickier because the CMS surveys are typically handled by ACA surveyors.
Okay. Well, whoever was doing that, they lifted the IJ at about this time, February 25th, did they not?
They lifted no. What they did at that time was that they accepted the corrective action plan. The IJ threat was still in place until I believe late May or mid-June of that year. And in fact, the hospital requested and was given 2 extensions to comply. And then ultimately had signed an agreement, a binding agreement with the federal government that it would accept having a consultant in the facility for the next 12 months who would oversee or direct the compliance. And in exchange, the federal government takes the threat of losing funding away.
But the IJ was lifted.
Again, they accepted the plan of correction.
Correct. And lifted the IJ as a result, correct?
No, sir, because again, they were still under threat of being removed from funding until late May or early June.
But at that point, the IJ was ultimately lifted, correct?
At the end of June, yes, I'm sorry. I thought you were asking about that February date.
All right. So we can agree the IJ was lifted.
With an asterisk because of these
And we
extraordinary.
can agree that there was substantial effort put forth at compliance.
Oh, absolutely.
All right.
The new team actually did well.
Okay.
They worked hard.
Well, let me come back to that in a minute. In this 2811, where is the reference to nursing service?
This survey was conducted in conjunction with a risk management survey.
That's all, just risk management.
From what you're showing me, yes, this is a risk management survey.
All right. Where is the reference to risk management activities in the fall of 2016?
There's nothing specifically mentioned about 2016 in this unannounced complaint investigation.
Now, there was talk about trial exhibit 2815. Let me ask you, get that up if you could, Clay. And you talked about 4 areas that it addressed. And this is the announcement of the IJ in January of 2019, correct?
January 31, 2019. Yes, sir.
Okay, and that's January of 2019 is about 2 years after Maya Kowalski was discharged, correct?
That's correct.
All right. Now, in this statement of the grounds and the findings that are based on the IJ, with the basis for the IJ, where is the reference to the nursing service?
It's not in this letter. It's in the CMS 2567.
By all means, do you have that handy?
No, sir.
Okay. Well, in this letter here, is there anything basing the action on the hospitalist service?
Medical staff,
Medical staff in general,
right?
no specification to the hospitalist service.
Not in this letter. Again, this is the overview, not the detail.
Okay, so the detail is in the 11119 form
2567.
2567 in the lower left-hand corner.
Yes, sir.
Okay. So you looked at all 100 and some odd pages of it?
I did not see the version with the corrective action plan. I looked at the original document, which was 49 pages.
Okay. And I may have that in my hand too. I just can't tell the weight of these things.
Fair enough.
But I was curious, in looking at this document, did you see any specific reference to the PICU intensivist service?
The intensivist physicians were not specifically mentioned. No, sir.
Nor were the hospitalists, correct?
To my knowledge, no, sir.
All right. And you didn't see any reference to the pain management service either, did you?
No, but again, the issues that were cited are the ones that support them and also oversee them.
They
Right?
oversee them, but we're talking about them themselves, the people.
Yeah, and it's
Not the structure
unusual.
of the people.
I understand your question now. It's unusual for specific physicians or specific medical groups to be identified in these kind of surveys.
And in that survey, did you see any reference to what was happening on the 7th floor, the medical surgical unit, in October of 2016?
Well, again, no, because the survey is not is not geared to follow specific physicians, physician groups, and their individual practices. That's a job that falls to the medical staff led by the MEC. And that's what was called out here. So more.
Well, there's specific examples given for most of these things. And so what I'm trying to find out is, did you see in this report, in the original report that put in place the IJ, or was the basis for what was put in place as the IJ? Did you see any reference to the events of October, November, and December of 2016?
Specific to those dates, no, sir.
And you saw no reference to the psychology service specifically, did you?
That's correct.
And you saw no reference to the psychiatry service, did you?
For those dates, no, sir, you're correct.
Now, there was reference to your discussion of trial exhibit 2817. A. Excuse me. See, she does it to me too. It sounded to me like you were saying that the problem, or one of the problems addressed
Can you
here
put that
was-
document up, sir?
Oh, sure. Can you put that up?
Did you just see any of the reports that we hid from the court? Mama Ames.
First of all,
Exactly.
it indicated they were working to improve the situation, right?
You guys, I'm sorry. I have to pause this. I've got to refresh StreamYard again because everything is freezing for me. I'll be right back. All right. Let's see if we can make this work better. We're only a couple seconds behind now. I just can't stand it. I can't use my screen. I can't put up the picture that I want to put up. I can't put up your comments that I want to put up. It's just so laggy. I can't stand it.
Yes.
Okay. And in some of the documents you made that we were referenced here, specifically 2821A, you weren't asked about that one.
I don't recognize it by number.
2821A in evidence. You can put that up. Well, let me finish. It's too quick for me. Let me just ask you first of all, before we leave 2817.
I don't feel
It
like
sounded
he's
to me
getting
like what you were
anywhere.
concerned about in this document was the extent to which risk management was not reporting upward.
That was one of the talking points that they developed for the interim CEO to address with the board.
And they were trying to
was sharing of information. Correct.
Okay. So information wasn't getting shared by risk management. Right?
That's the inference from their talking points.
All right. So let's go back, if we could, to what I was referring to a moment ago, 2821. This is a letter dated 10 February 2019 regarding the statement of deficiencies, right?
Yes, sir.
Okay. And this letter indicates, does it not,
I'm so bored.
that efforts to address what later became the basis
You're
for
not
the
convincing
IJ
anybody of anything.
had already begun by the time of the inspection, correct?
That's incorrect. This is February 10 of 2019. The survey was 10 days earlier. This is the response to it.
Maya's
Understood.
laughing.
This is a
Nope,
response
that's incorrect.
to the inspection report from January 11th to January 7th to
7
January
to
11th.
11.
And this was on time, submitted within 10 days, correct?
From the January 31 report back. Yes,
Right.
sir.
And this letter summarized efforts that were being made to address the IJ concerns, correct?
It does. And as I said, the new team actually worked really hard. It was too late to help Maya, but this was good work.
It was, the new team was already in place by the time of the inspection, correct?
They were assembling. I think Miss Green actually took her role 3 or 4 days before 12 inspectors, surveyors arrived. But yes, sir, they were assembling. They were mustering.
Well, the executive team was already in place and already addressing these concerns by the time the inspection team arrived, correct?
I can't speak to the entire team. They had 8 departures in leadership, so I don't know that all 8 spots were backfilled, but I do know that there was an interim CEO in place. Regarding the other 7 positions, I have no idea when they
And
were
you've shown
filled.
us his talking points and the efforts that were being made to address the situation, correct?
Following the survey, yes, sir. And he was also one of the, per Ms. Green, he was also one of the attendees at the visits to CMS in Atlanta and ACA in Tallahassee.
They have a moment, Your Honor.
You may.
A moment for what? This isn't slow and sleepy enough. We have to slow it down even more. Well, since we're a little bit behind, we
That's
can
all I
go a
have.
little.
Thank you.
Oh, that's all you have? Finally.
Mr. Whitney.
Joke's on you, Mr. Hunter. I could listen to Dr. Goodhair reading the whole hospital policy to me, no
Your
problem.
weekend plans are now in front of the jury. You went to the Florida football game on Saturday.
You didn't have to remind me, sir.
I thought the black uniforms were going to work, but no.
Oh, well, we lost.
All right.
That's all I'd like to say about it, sir.
Sure. And you spent Friday night with me and Mr. Hunter at a deposition of Miss Green.
I did.
And how long did that last?
We
Oh, yeah,
sat
tell
down at
us
about 4 o'clock. I
all
want to say we
about
left
it.
the building somewhere 7:30, 7:45.
Before that deposition, had you ever seen the first corrective action plan from Johns Hopkins Children's Hospital?
Not to my knowledge, no.
And just so that your diligence is not in question, first of all, we left with a stack of papers, did we not?
A box full, yes.
Your Honor, relevance to be else good.
Overruled.
We left with a box full of papers.
Yes, sir.
Knows
And
we want to
you did
know
not
what
spend the
happened.
weekend reviewing everything that was provided on Friday night, did you?
No, sir. As I said, I was a dad this weekend.
And then 2 more boxes were provided to us over the weekend.
That's what you told me, yes, sir.
So the fact that you haven't seen a particular survey is not a reflection of your diligence, is it?
I hope not.
I'm so tired.
Now let's talk about surveys. That's what they are, right? A
They are.
survey.
They are.
And these folks that come from whether it's the Joint Commission or CMS or ACA, they're in their hospital for what? A week?
They can be there. Typically, they run 3, 4, or 5 days. Now, a complaint survey can be in and out in a matter of hours or a day. But when they're full surveys, there are multiple days with multiple surveyors. And typically what they'll do is for an accreditation survey, for instance, they will bring an engineer to look at the heating and cooling, to look at all the mechanicals of the elevators. They'll bring nurses in to look at nursing things. They'll bring in pharmacists to look at pharmacy things.
The short answer is they're there for a brief period of time in any hospital during a survey.
It feels like forever, but they're typically there for 3, 4, or 5 days.
All right.
And with the CMS survey that was done January 7th through the 11th of 2019, my understanding is that there were 12 surveyors.
All right. In the intervening 3 years between accreditation or reaccreditation, the Joint Commission folks or the CMS folks or the ACA folks, they don't live at the hospital. They don't reside at the hospital. They're not there every day, right?
You try to keep them at bay.
The system, as it is reliant on self-reporting, is it not?
It's encouraged for sure.
It's reliant on the hospital that's being evaluated being an honest actor.
Correct. And there are some specific fallouts that require timely notice. For instance, an adverse event requires a code 15 filing if it's severe enough. And so that needs to be, Tallahassee needs to be notified ASAP.
And in this instance, was it discovered that Johns Hopkins Children's Hospital was not self-reporting adverse events in a timely fashion?
Check, Your Honor, relevance to relevance.
I'm going to sustain that one.
Understood. this was all the genesis of an eventual self-report by Johns Hopkins All Children's Hospital, right?
Objection, leading your honor. Overruled.
The survey that ultimately led to the IJ, which was backdated to 4 or 5 months earlier, did involve self-reporting.
What drove that self-reporting?
Objection, your honor. False speculation by the witness.
Overruled.
There were several issues at the hospital that were well documented by local press that actually ended up being a finalist for the Pulitzer Prize for investigative journalism.
Objection, Your Honor.
Holy
Please
shit!
Strike not responsive.
Holy shit!
The jury's going to disregard the comment about the Pulitzer Prize.
Sorry, Your Honor.
Approach, your honor.
No,
I'm done
they
with that line of
won't.
questioning.
No, they won't. Oh my God. Oh my God. The journalism
Having
was
observed
nominated
the
for a
trial here,
Pulitzer.
have you seen or heard any testimony from anyone with the title of vice president or above from the
Oh,
hospital
damn.
to explain that they had this all under control during 2016, 2017?
Objection, Your Honor. May we approach?
Sure.
Oh my God. Yeah, that cat's out of the bag. Oh shit. Oh shit. Oh shit. All right. So we have the journalism that was done outing this hospital was nominated for a Pulitzer Prize. Holy crap. Oh boy. Oh boy. Well, you cannot unring that bell. Am I right, MG Law? Am I right? Am I right? The jury already heard it. Too late. Too late. Holy crap. So, yeah. So, the takeaway from that, if you're on this jury, is that the reporting was so important and what the hospital did was so bad that the reporters involved in breaking the story were nominated for a freaking Pulitzer. Oh, man. Oh, man. Get the air sick bags because the defense
Sustained.
team needs them. That was brilliant. That was beautiful, Dr. Corcoran.
I think I'm going to leave it there for now, Dr. Corcoran. Thank you.
That was good enough.
Anything further, Mr. Hunter?
That was good.
No, your honor.
Members of the jury, do any of you have any questions?
Nope, the jury has questions. Ow. All right, guys, I know you're telling me that at page 204, there is the transcript of the deposition. But again, in order for us to really do a proper read through, I need help. I need friends. And I don't have any friends to do that with me this afternoon right now. I don't have any friends, apparently. No one wants to show up. I've sent out this stream to lots of people, but you see they're not here. They're working, they're doing other things. So if I can gather up some friends to do that with me, maybe tonight or tomorrow night, we will do that. But everybody's busy. I don't know what to tell you. Or I'm not very, I guess I'm just not very popular. I just don't have the friends to show up when I need them. No, but I would like to read that, but I can't read it by myself. I can't read it by myself. I can't do several different voices by myself. Sally, you could get in here. Absolutely, you could get in here and do it with me. Sally, if you want me to add you to the list, I'll add you to the list. We need some bodies in here to read through. Jeff's problem is that he's on a completely different time zone than me. So when it's nighttime here, it's daytime there, and he's working. And when it's daytime here, and it's nighttime there, he's streaming on his own channel. So it's tough. It's tough. I know Jeff would like to be here. It's just that our schedules are just completely on opposite. We're opposites. And MG Law apparently has to go to work, which, none of us are really all in favor of, but he does have a family to support. Should the
Members of the jury, I'm not going to ask the question that was posed, but Mr. Whitney will ask questions, and then Mr. Hunter will have an opportunity to follow up.
The 2019 immediate jeopardy finding and all of the corrective actions that were performed by Johns Hopkins Offshore Hospital. Is it a fair, well, first of all, there was a retrospective analysis that led to this. Is that right?
Objection, Your Honor, he's leading.
Overruled.
Right. So, yes, they look at what led to the problems. If you think about it as a firefighter shows up, puts out the fire, but looks at whether the electric panel has any issues, whether there's carpet in front of a portable heater. They look for the causes of what allowed the problems to show up.
And is it accurate summarization of your testimony to say that the issues that, as they're contained in that dense federal document, surfaced as early as 2015 within the hospital?
Yes.
Objection, leading, Your Honor, and also argumentative.
Overruled on both.
Yes, there were 4 or 5 pediatric cardiac surgery.
I'm going to remind you of the instruction.
Sorry. There were 4 or 5 PAs in the operating room who had concerns.
Objection, Your Honor.
Let's not.
Let me ask the question. Let me ask another question. Let me ask the question.
Okay.
Sorry. We're testing you. Were there self-reports at the employee level in the hospital dating back as early as 2015 of issues with patient care?
Objection to predicate foundation. Judge Beard, approach.
Oh, here we go again. Oh man, if I'm on the jury right now, I'm telling you right now, I am pissed off at the defense that they will not let this man answer my question. They will not let him. So the judge says, I can't ask the question you want asked, but I'm going to let Mr. Whitney guide him there. But they're not letting this happen. The defense isn't letting it happen, and the defense has to know that this is what the jury wanted to know. And if they keep getting in the way of that, me as a jury member, I'm just going to be like, well, fuck you. You didn't let me know what I wanted to know. And so I'm just going to put all the zeros on the check because I can, because it's my prerogative as a member of the jury. I'm allowed to decide that you guys are a bunch of dicks, much like Law and Crime, whose cameraman can't keep the camera on where the action is, and instead wants to just put the camera directly up Maya Kowalski's nose. Well, I'm not having it. We're not watching it, Law and Crime. We're going to just talk about what twat waffles you are. Because you are. Along with some cunt cakes and fuckwads and, all of that. The cunt cannolis, that you're all of that. Because you refuse to keep the camera where the action is. I'm disappointed in Judge Carroll for this. This was his prerogative to tell the camera crew, you are not allowed to put the camera on the plaintiffs when they are not called to the stand. This has been normal for the cases that we've seen recently, including the Johnny Depp case, including Maya, don't lean forward, honey. There we go. Including the Johnny Depp case. They were not allowed to do
Mr.
this.
Whitney?
Not this time.
Mr. Hunter, any other questions?
So they weren't allowed to get it out of it.
Members of the jury, any other questions from the jury? May this witness be excused.
Yes, Your Honor.
Yes, Your Honor.
Thank you, sir. Thank you for being here.
Thank you for your consideration of getting into the doctors.
Well, goodbye, Dr. Corcoran.
Plaintiffs, any further evidence in rebuttal?
I don't think they do have any other evidence on rebuttal. I think that's it.
So at the time is the plaintiff's resting.
We're resting in rebuttal.
What we're going to do, members of the jury, we're going to give you probably 10 or 15 minutes. I'm going to be talking jury instructions with you when we come back. It's just going to take a while. So just steel yourself that you're going to get to listen to me give a lot of instructions. So if you need to use the restroom or whatever, that's fine. Do not discuss this case amongst yourselves. Do not do the investigation and receive no information. Let's take 15 minutes.
All rise. Jurors exit.
Goodbye, Dr. McDreamy. Dr. Goodhair stole my heart. So polite. He killed it. Oh. All right, what are we going to argue about now?
Okay, the jury is out of our presence in a moment. We'll go on a break. I was going to have, Mr. Reyes, you're going to be the one that is putting these up as I speak, or is that going to be Mr. Cottrell?
Your decision, Your Honor.
I just need one of you to do it. And I just need, you want it in a PDF format, is that?
Yes, Your Honor.
Okay. So it will be re-emailed out to the lawyers in a PDF format. And so if the lawyers can get it to whoever is going to be putting it up on the public gallery boards, I'll also bring in the paper versions as well. Mr. Elegant gave us a couple of verdict form changes. I made those. I'm so sorry. Knock on wood. So let's take 15 minutes and then we'll come back and I'll start reading jury instructions, and then it's my intent to send the jury home after that.
I'm sorry, you say you'll have a paper copy for us?
Yes, they I think are now finished printing.
Okay.
So I will have them when we come back.
The plaintiffs renew their motion for the court to instruct the jury concerning the circumstances that unfolded this past weekend. As this has turned out, the defense has managed to pull a delay of key documents for 5 years into a methodology for getting exactly what they wanted in front of the
Mr.
jury.
Anderson, if there's something you want me to consider, put it in writing, give me something specific. Otherwise,
I will judge you.
Okay. I'll be back in a few minutes.
All rise. Scores in recess.
All right, let's get to the super chats. Miranda Lee, thanks for the super chat, says, for Dr. Goodhair doing the right thing and for the lovely Megan for having the courtesy and compassion to Mama Bear protect Maya. And the chat, y'all are the best. I agree. Looks like Maya's out of the courtroom, so we can take that down now. I'm just really tired of the cameramen and what they're doing to her. Chaos Coordinator, thanks for the super chat, says, Whitney to Mr. Goodhair looking over glasses, whispering, finish them. Mr. Goodhair to Whitney in response, nod with a smirk. Sarah Don, thanks for the super chat, says, thank you, Megan, for everything. I truly hope Maya gets billions, not millions now after this. Me too. Me too. And Sarah Don, thanks for the super sticker. I appreciate that. These people are unbelievable. Unbelievable. And I personally believe that the defense can't win this at this point. I think the jury is pissed off enough. But I do think that they're going to tie up this case in appeals, which is why settling might have been the right thing for the family to do, so that they could actually get their debts paid. Because the way that this is going to the way this is going to shake out is it's going to be in appeals court forever, for years, and they won't see a dime of any of it, no matter what it is. All right, let's go back over to this. We were reading the stipulation that we believe the Kowalskis were under after the case was dismissed. Where were we at? The father shall ensure that child receives physical therapy. Okay, we got that. The father shall obtain prior approval of the department. Oh, what did I just do? I didn't want to do that. The father shall obtain prior approval of the department for the physical and occupational therapy provider. The father shall not take the child for non-emergency examination and or treatment to any other physicians not listed above, unless directed to and recommended by the above named physicians. Oh, so she's not allowed to see Dr. Kirkpatrick anymore. Not allowed to go see Dr. Chopra. Can't see any of those people. If the child requires emergency medical treatment, the father shall immediately notify the case manager of the need for emergency medical treatment. Can you imagine? What if she doesn't answer her freaking phone? And then may seek emergency medical treatment for the child. The father shall immediately notify the case manager of any medical, mental health, or behavioral issues with the child. This is so gross. The father shall turn over to DCF for proper disposal any and all ketamine or narcotic medication in the possession of the family or child. The father shall not provide the child with ketamine or narcotic medication unless specifically recommended by the above named medical professionals. The child shall receive random toxicology tests. So they're drug testing her. The father shall cooperate with the case manager and maintain contact with the case manager. The father shall notify the case manager within 24 hours of any change in residence of the child. The father will comply with announced and unannounced home visits by the case manager. God. Oh, this is America, folks. This is America. Is my camera frozen again? Yeah, it looks like it is. Okay. Freaking sucks. I don't know if I can turn it off. I'm trying. Why is this like this? Why are you like this? Hold on. I'll be right back. And I'm back. I'm back. Okay, let's get back over to whatever the hell I was reading here. Glad to see you're all still here. Thanks for hanging in there while I had to do some things to make my computer work better. I don't know why the reboot lets it work for about an hour. All right, we were down here. Drug tests. Father will comply with announced and unannounced home visits. Father shall sign releases to allow the case manager to obtain any of the child's medical records, mental health, and educational records. Wow, what an invasion of privacy. Holy shit. The court shall maintain protective supervision by the department case management agency for at least 6 months. All right, so this was dated January 11th, 2017. Now, the next email we have is dated February 3rd of 2017. So 2 months later? No, 1 month later. Thanks, Dave. Here's Howard. I wanted to let you know, this is from David Silverstein, the lawyer at DCF. I wanted to let you know that the Kowalski dependency case has been dismissed and that I will not need any J-Hatch staff to testify at the dependency proceeding. Please let me know if you have any questions. I very much appreciate all the help you've given to me on this case. It's been great working with you. And Hunter replies, thanks, David. It was a pleasure to work with you folks. Here's hoping we have heard the last of these folks and their lawyers. If you hear anything we should know, or if we can be of assistance, please let us know. Well, that wasn't the last that Hunter had to hear of the Kowalskis and their lawyers now, was it? But isn't it interesting that they draw up this whole stipulation, you know, just invading this man's life in January 11th, all these rules that he has to do. And by February 3rd, they're dropping the whole thing. It was all garbage to begin with. None of it was real. And they know it. If it were real, would they have dropped it in a month? Less than a month. How many days is it between January 11th and February 3rd? How many days? Not many. They dropped the whole thing in less than a month. And the reason why they write these things, the reason why they write these orders, there's like sticking up all over the place. The reason they write these orders is to have the appearance of legitimacy that, oh yes, everything we did was absolutely necessary. And look we have to monitor this family because this child was in severe danger. And so we have to make her part of our, part of the state. She has to be under state custody and DCF monitoring and all this bullshit. It's just for the appearance of legitimacy. It isn't because it's actually legitimate. And then they quietly drop it a month later. It's disgusting. All right, so somebody else sent me something purporting to be an email from Hunter. Now, I cannot verify that this is actually an email of Hunter's. But I can read it to you and we can talk about it. Wait, where did it go? It was on Twitter. Well, I did see it. What the heck happened to it? All right, well, I don't see it right now. But it basically was showing that he was involved way back in the case, that he had a lot of involvement, including knowing about the pictures being taken, and that he was on the email chains, like he should have been a witness in this case. That was what it was basically saying. Like maybe he should have been a witness and not the attorney because he was so involved. Duncan says, how can a court order prohibit going to certain doctors without censure or action against those doctors? How is that legally sound? Well, it's not. And of course you could appeal, but I'm sure at that point, Jack's like, I just want to get out of this. Like what? I want my life back. I want my kid back. I'm just going to, at that point, you will do anything they say. Because they've already showed you who is boss. They've already shown you who's in charge. They can take your kid. And so what? You're appealing, you hire lawyers and you appeal this ruling, and then they take your kid while you do that, and it's years before you get her back? Yeah, you don't know how this works. The state has all the power, and you have none of it. And it doesn't matter how many lawyers that you hire. The state has all the power, and they should be feared. At this point, we are in a state in this country where if you don't fear the state, you don't know what you're doing. Fear the state, because they can put you in jail with no trial, just like the January 6th, protesters. A bunch of them been sitting there for 3 years with no trial, and they didn't waive speedy, but it doesn't matter because the state can do whatever it wants. Testicular trauma says, okay, just found an article. The hospital DCF tried to get an order of supervision on this family to continue involvement April 2nd. DCF asked to close the case, and it's granted. And I don't think I understand. The hospital tried to get the order of supervision, and DCF closed the case? What article? Why don't you give me the link? That would help. Can I go through the depo from Friday? Okay, I'll try, but it's a 300-page document. But I mean, how can I go through this, you guys? Seriously. Oh, wait, court might be back. Why am I behind? I was behind. Oh, it's not back. All right, hold on. I will pull up the 300-page doc. All right. Joby, thank you so much for the $50 Cash App. I sure appreciate that. Joby says, you rock on your coverage. #1 in my book. Thank you so much. I sure appreciate that. You've really been a big supporter of the show, and I appreciate that. That $50 is going straight to the new computer fund because that's got to happen soon. There's no video. There is a video of the deposition, but we don't have that. We don't have access to that. I don't know if we will have access to it at some point, if it will be released. It is a part of the record, so at some point it should be, I believe. I'm still looking for the motion. Hold on. Where is it? Motion for sanctions. There we go. All right, we need to go to page 204. How do we get there quickly? All right, there we go. All right, share. Welcome, HT, as to the Fox Den. Thanks for becoming a member. We sure appreciate you here. And let's see, Duncan Idaho says these people are not afraid enough. No, they're not. They're not afraid of us at all. We are the ones who have to be afraid of them because they have all the power. This situation is untenable. It cannot continue like this. It cannot continue. That agents of the state can just walk into your life and fuck it up with no rational basis, and there's nothing you can do about it unless you have hundreds of thousands of dollars to fight it in a lawsuit later. But the damage is done at that point. How can you look up these documents? I have no idea. People just keep sending them to me. I don't know where they're getting them. Probably the Sarasota County's docket is what I would guess. All right, videotape deposition of defendant's corporate representative, Angela Green. I don't think we ever saw her on the stand, so we don't know what Angela Green looks like, I don't think. They went from 4:21 p.m. to 7:43 p.m. Let's see. Here we go. All right. We don't care what the videographer says. They're just introducing themselves. Also present, Maya and Jack Kowalski. All right. Whitney begins. Good afternoon. Hello. Please state your name for the record. Angela Green. Ms. Green, your position with Johns Hopkins All Children's Hospital, what is that? Currently, I'm not employed by Johns Hopkins All Children's Hospital. I am the VP for Quality and Safety for the Johns Hopkins Health System. So, you're employed by Johns Hopkins Health System Corporation. Correct. And do you sit, and when I say sit, do you maintain your office in Baltimore or here in Tampa? I am primarily located in Florida. I have an office on campus at All Children's. I also have an office in Baltimore. Who do you report to? Alan Cachelia, in his position, the Senior Vice President for Quality and Safety for the Johns Hopkins Health System, and Carolyn Loudon and Associates, Director of the Armstrong Institute for Patient Safety and Quality. All right, blah, blah, blah. And the Armstrong Institute was born out of a patient safety issue or an adverse event. Would you agree with me there? Yes. And you said you're not currently employed by Johns Hopkins All Children's. Was there a time that you were? Yes. And when was that? I joined the All Children's team in September of 2017 as the Senior Director for Patient Safety and Quality. I was employed there through August of 2022. While I was there, I was promoted to the VP of Patient Safety and Quality and was in that role for when I transitioned to the current role. Duncan, Idaho, thanks for the super chat. Says, Megan, I think your coverage is the best because you can take a strong moral stance against evil. Uncivil is the closest I've seen to doing that, but it seems being a lawyer generally precludes this outspoken judgments of morality. I think what stops it is that lawyers see other lawyers, regardless of what side they're on, as doing their jobs. And they have a really hard time saying, oh, they're defending evil, because then that would mean that that's what they do. You know, and that's hard just to say. You know, I'm sure that that's hard. They believe that they are fulfilling a constitutional role, which they are. It's absolutely true that everyone deserves a defense. But there's nothing stopping those of us out here from saying, all right, they deserve a defense, but the defense is terrible. There is no defense. In some cases, there is no defense for what you did. And while our system allows a defense, and while they must have a defense, it doesn't mean that they're not really fucking guilty. Okay. All right. She used to work at Arkansas Children's Hospital. Blah blah blah. Well, and then they go through her education, which I really don't care about. So your position is that the immediate jeopardy that affected Johns Hopkins All Children's Hospital was first delivered to Johns Carolyn Loudon and Associates Inc. Oh no, sorry. No, that's a footer. All Children's Hospital was first delivered to Johns Hopkins All Children's Hospital on January of 2019. Do I understand that correctly? Correct. And so that we're clear, during the period of that time, January 2019, you still would have been in your position as the Senior Director of Patient Safety. Correct. And you remained in that position. I heard you got a promotion, but I didn't hear exactly when. So I was promoted to Interim VP of Quality and Safety sometime in January of 19. Oh, and then interviewed for the job that summer and was moved out of interim status in 2019. She probably has more vocal fry than this. So in the midst of dealing, and you might quibble with my phrasing there, of dealing with the immediate jeopardy, you were in the midst of a transition or a promotion. So the promotion to intern was January 3rd, right? And the survey that about the heart surgery program that resulted in the immediate jeopardy was January 7th through the 11th. Testicular trauma, thanks for the super chat, says OMG, donated to RA, who I like, but meant to donate to you with a point. So here goes, facepalm incoming. It's all right. He's got a great show over there. So so you had recently been promoted just before the immediate jeopardy, like within a week? Hunter, well, the notice or the inspection? Well, I was going to ask about that in a second, but let's just talk about this. Oh, they're back. Court's back.
You're fine. Somebody from the plaintiffs come. Somebody from the defense come.
I'm right here.
The judge wants them at his desk. Get up here.
That's how punchy we are.
He's all, someone come from the defense, from the plaintiff.
Now,
Let's go.
With respect to the dependency court order package, they're still being copied. I wasn't planning on reading them unless the parties wanted me to reread those instructions. I was just going to give it to them. I can do it today, or I can hand them those tomorrow. I am indifferent on the timing.
Did you need to give me this, Judge? It says jury.
No, you don't get the juries. Sorry about that.
Got it?
Your Honor, if there's time, I would like to have it read one last time.
I'm sorry?
If there is time, I would like to have the defense order read one last time.
You can take a couple minutes and look at it.
I'm trying to come up with a proposed order. And are we going to go over, yes, we are on the verdict form.
No,
Because I have a concern.
you're not reading the verdict form today, Judge.
No, the verdict form would be discussed tomorrow.
Okay.
I would go over it tomorrow after closing arguments. Because I think that's in the last instruction.
Mine was, I'm still on.
Yeah, on page 68 of 68 is where we would be going over the verdict form, which will occur tomorrow.
I just had an addition to paragraph 41 in light of the circumstances.
To the verdict form or to the jury instructions?
Oh, to the verdict form. The fraudulent billing.
Well,
Needs to include.
why don't we deal with that after we send the jury home today, if I'm not going to be reading the verdict form today?
Absolutely.
Judge, you included a pack, in the defense packet, there was one that's not double-sided. Was that for you?
Well, that's actually for you. Mr. Hunter suggested you might not want a double-sided copy. So,
I love you, baby.
Thank you.
so that's for you, Ms. Crowells.
Thank you.
So under dependency court order instruction, do you want me to hand it out today, tomorrow?
Our preference is tomorrow.
Tomorrow.
Let me guess, today? Okay. We have an agreement. I'm rolling with it tomorrow. Madam Court Reporter, you're welcome. I will have probably about 10 minutes of comments tomorrow morning before we bring in the jury. So I'm trying to figure out what time we need to start. If the jury is able to come at 8:30, if we start at 8:15, is that going to be enough? Or do we need more time for any last minute issues?
Yes. We're gonna have some time out today after the jury leaves, right, Judge?
Yes.
That sounds fine.
About last minute issued out.
I can't hear you, Mr. Hunter.
I'm sorry, Your Honor, I'm about last minute issued out.
Just in terms of timing, the court envisions that the plaintiff would put on their closing argument, the defense would do theirs, plaintiff would do their rebuttal, and hoping to get all that in before late lunch. Is that optimistically what the court schedule would be?
I would love to be able to do it. I'm probably going, and I'm just telling the court deputies this for the first time. My thought is that they will, in the morning, get the jurors lunch orders. And so they can have lunch ready to go, that we will just take mid-morning breaks and not take a lunch break. And as soon as we send the jury back, the lunch will be ready for the jury and they can just dive right in.
The only issue in that, Judge, is you're doing 12 orders.
I'm sorry?
Are you doing 12 orders?
Well, what we do is we take 12 orders, but we don't call in 12 orders. Yep. we are good stewards of the public's money. We don't order extra lunches when we don't have to.
That's harsh.
Mr. Altenburn, are you ready for me to proceed, or do you still need a few more minutes? Plaintiffs, are you ready for me to start reading?
I just have, if I could approach, I have this instruction to look over.
Can you pull up whatever he's going to hand you?
Or a version thereof.
Are you waiting for a response? Judge?
I'm waiting for a response from the defense.
Well, to a large degree, I think this is
Already been handled by what's gone on in the last couple hours. It's not really written like an instruction and talks in terms of exploitation and tells you should not consider any questions regarding the alleged failure of Dr. Corcoran to review certain documents informing his opinions, or an evaluation of Dr. Corcoran's opinions. Or that also was handled during the examination to explain when all this was done. This is basically things that the lawyers have already handled, and I don't see that it needs to be a special instruction, nor am I quite sure where it would be placed.
Here's my view. I don't think I'm going to give it at this point in time. I mean, certainly if the defense makes a point about this in the closing arguments, then I probably will have to give an instruction on it, but I suspect it's not going to be commented on in closing arguments.
Got a lot to cover in closing.
The testimony that was already adduced will suffice.
Thank you, Your Honor.
I understand the court's ruling.
There you go, Madam Clerk. Let's bring in the jury.
All rise, jurors entering.
Okay, everyone, please be seated. I'm calling one correct juror member, please. Okay, members of the jury, before I start to read, I want to confirm that while you were away, you did not discuss this case amongst yourselves, you did not do any investigation, and you received no information. Is that all correct? And no one approached you about this case. Is that correct? And you saw no media accounts about this case. Is that correct? Okay. Now, members of the jury, that 68-page package I just gave you are the jury instructions that are going to be applicable to this case. I am going to read those instructions to you at this point in time. It's going to take me a little bit of time. You are free to listen to me or to read along or both. If I'm doing this properly, I'm also going to publish it on your monitors as well. And it looks like Mr. Reyes is helping me out there. Thank you, Mr. Reyes. If I end up reading too quickly, just flag me down. If I mess up how I'm reading it, I'll probably just reread that little section. And every now and again, I'll take some water. Okay. And just to orient you, what we have done is on pages 2 and 3 of the jury instructions, we have listed out the claims and the issues and created a table of contents for you so that you will be able to more quickly find the specific instructions. And additionally, when we send back the evidence to you, we'll also have kind of like a table of contents of the evidence as well that you will have available to you. So without further ado, let's go to page 4 of 68. Members of the jury, you have now heard and received all of the evidence in this case. I am now going to tell you about the rules of law that you must use in reaching your verdict. You will recall at the beginning of the case, I gave you a short explanation of the claims in this case and told you that I would provide a complete written set of instructions before you deliberated to reach your verdict. These instructions are the complete set of instructions that you will use in the jury room. When I finish telling you about the rules of law, the attorneys will present their final arguments, and then you'll retire to decide your verdict. The final arguments will occur tomorrow. As a reminder, I previously instructed you on all relevant dependency court orders binding Johns Hopkins All Children's Hospital, and I will be separately including those instructions for your review and use during your deliberations, and I'll give those to you tomorrow. As a further reminder, I also previously instructed you that Johns Hopkins All Children's Hospital does not have any immunity from the claims presented to you in this trial. As you understand by now, Jack Kowalski is the plaintiff in this case in 3 separate capacities. First, he claims damages for his daughter, Maya Kowalski, because she is under the age of 18 and is a minor. Second, he asserts claims for his deceased wife, Beata Kowalski, Beata Kowalski's estate, and Beata Kowalski's legal survivors as the personal representative of her estate. Finally, he claims damages personally on his own behalf. In these instructions, when a claim is made for Maya Kowalski, the instructions will describe Maya Kowalski as the claimant, even though legally Jack Kowalski as her father is the plaintiff. When Jack Kowalski is making a claim in his capacity as the personal representative of the estate of Beata Kowalski, the instructions will describe the estate as the claimant. Finally, when the claim is for Mr. Kowalski personally, the instructions will describe Jack Kowalski as the claimant. In these instructions, there are instructions for, and it should say 7, not 9, I apologize, 7 separate claims. These instructions are given to you in writing to use in the jury room, and they include a table of contents so that you can find the instructions for a specific claim quicker during your deliberations. Although these claims have been tried together, each is separate from the other, and each party is entitled to have you separately consider each claim as it affects that party. Therefore, in your deliberations, you should consider the evidence as it relates to each claim separately, as you would had each claim been tried before you separately. During this trial, you have heard evidence about rules or policies created by Johns Hopkins All Children's Hospital for its employees and for visitors. You have also heard evidence about a document described as the Patient and Family Rights and Responsibilities, or as a Patient's Bill of Rights. The fact that an employee may have failed to comply with these requirements is not a violation of a law or a breach of a legal duty. It is only evidence that may be considered by you to determine whether Johns Hopkins All Children's Hospital breached one of the legal duties or standards of care that I explained to you in these instructions. Likewise, the fact that an employee may have complied with these requirements does not mean that Johns Hopkins All Children's Hospital cannot be found to have breached one of the legal duties or standards of care that I explained to you in these instructions. Again, that fact is only evidence that you may consider to determine whether Johns Hopkins All Children's Hospital did not breach one of the legal duties or standards of care that I explained to you in these instructions. During the trial, you have heard testimony about whether Mr. Kowalski was prohibited at times by the dependency court from authorizing a doctor to administer ketamine to Maya Kowalski. When the dependency court entered the order on January 13th, let me just read that again. When the dependency court entered the order on January 13th, 2017, which discharged Maya Kowalski from the hospital and placed her in the interim care of her father, the dependency court prohibited Mr. Kowalski from authorizing a doctor to administer ketamine to Maya Kowalski. On April 20th, 2017, the dependency court entered a final order releasing Maya Kowalski from shelter status. That order ended the lawsuit in the dependency court and all existing orders. During the trial, you have heard testimony that Maya Kowalski experienced stress relating to this current lawsuit. Emotional stress that parties to a lawsuit experience because of their involvement in the lawsuit is not an element of damages for any claim in this lawsuit. Claim 1, false imprisonment. The first claim in this case is brought by Maya Kowalski against Johns Hopkins All Children's Hospital. Maya Kowalski claims that Johns Hopkins All Children's Hospital intentionally restrained Maya Kowalski on 3 separate occasions under circumstances that were unreasonable and unwarranted and without legal authority, which caused her harm. First, Maya Kowalski claims that she was intentionally restrained between October 7 and October 13, 2016, because Johns Hopkins All Children's Hospital did not release her to her parents in this period before the court in the proceedings filed by the Department of Children and Families entered its shelter order. Second, Maya Kowalski claims she was intentionally restrained on or between October 18th and October 20th, 2016, when she was moved from her normal hospital room to another room containing video recording equipment, where she claims she was confined for approximately 48 hours. Third, Maya Kowalski claims she was intentionally restrained on January 6, 2017, when she was confined in a room where some of her clothing was removed against her will, and she was restrained while photographs were taken of her body. Johns Hopkins All Children's Hospital admits that it intentionally kept Maya Kowalski at the hospital between October 7 and October 13, 2016. It admits that it intentionally placed Maya Kowalski in another room on and between October 18th in October 20th, 2016, not 2026, 2016, to be video recording. It also admits that it took photographs of Maya Kowalski. As to each instance of claimed false imprisonment, Johns Hopkins All Children's Hospital denies that its acts were unreasonable, unwarranted under all the circumstances, or without legal authority. The parties must prove all claims and defenses by the greater weight of the evidence. I will now define the terms you will use in deciding this claim. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. False imprisonment means that Johns Hopkins All Children's Hospital restrained Maya Kowalski with the purpose of causing the restraint or acted with knowledge that Maya Kowalski's restraint would, to a substantial certainty, result from the acts of Johns Hopkins All Children's Hospital. To be restrained means that Maya Kowalski was held against her will and did not consent to the restraint. In other words, a person is restrained when she is not free or does not reasonably believe she is free to leave the place to which she has been confined. To be restrained, a person must be aware of the restraint. An act of restraint is without lawful authority if Johns Hopkins All Children's Hospital did not act under color or a claim of lawful authority for that specific act. An unlawful and intentional restraint is a legal cause of loss, injury, or damage if it directly and in natural and continuous sequence produces or contributes substantially to producing such loss, injury, or damage, so that it can reasonably be said that, but for the unlawful and intentional restraint, the loss, injury, or damage would not have occurred. In order to be regarded as a legal cause of loss, injury, or damage, an unlawful and intentional restraint need not be the only cause. An unlawful and intentional restraint may be a legal cause of injury, even though it operates in combination with the act of another, some natural cause or some other cause, if the unlawful and intentional restraint contributes substantially to producing such loss, injury, or damage. The issue for you to decide on Maya Kowalski's claim against Johns Hopkins All Children's Hospital are: A, whether Johns Hopkins All Children's Hospital, without legal authority, intentionally caused Maya Kowalski to be restrained against her will in a manner that was unreasonable and unwarranted under the circumstances, and if so, whether that restraint was a legal cause of loss, injury, or damage to Maya Kowalski. On the verdict form, you will be asked to make a decision concerning these issues for each of the 3 separate occasions claimed by Maya Kowalski. If the greater weight of the evidence does not support the claim of Maya Kowalski for any of the 3 occasions, your verdict should be for Johns Hopkins All Children's Hospital. However, if the greater weight of the evidence supports the claim by Maya Kowalski for one or more of these occasions, then your verdict should be for Maya Kowalski and against Johns Hopkins All Children's Hospital. If you find for Johns Hopkins All Children's Hospital, you will not consider the matter of damages. But if you find for Maya Kowalski, you should award Maya Kowalski an amount of money that the greater weight of the evidence shows will fairly and adequately compensate her for her loss, injury, or damage, as the greater weight of the evidence shows was caused by the occasions on which you find she was intentionally restrained. If you find for Maya Kowalski, you shall consider the following elements of damages for her. A, any bodily injury sustained by Maya Kowalski and any resulting pain and suffering mental anguish, inconvenience, or loss of capacity for the enjoyment of life experienced in the past. There is no exact standard for measuring such damage. The amount should be fair and just in the light of the evidence. And B, the reasonable value of medical and psychological treatment necessary or reasonably to be obtained by Maya Kowalski after she reaches the age of 18. If you find for Maya Kowalski but find that no loss, injury, or damage has been proven, then you should award Maya Kowalski nominal damages. Nominal damages are damages of an inconsequential amount which are awarded when a wrong has been done but no actual damage is proved. A parent is entitled to certain types of damage for a claim brought on behalf of a child. In this case, Jack Kowalski is the parent entitled to these damages. If you find for Maya Kowalski. If you find for her, you shall consider the following elements of damages for Jack Kowalski. A, the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably be obtained by Jack Kowalski for his child Maya Kowalski in the past or to be so obtained in the future until Maya Kowalski reaches the age of 18. If your verdict is for Johns Hopkins All Children's Hospital on each claimed occasion of false imprisonment, you will not decide the issue of punitive damages. If, however, you find for Maya Kowalski against Johns Hopkins All Children's Hospital on any of the claims of false imprisonment, then there is an additional claim in this case that you must decide. You must decide whether, in addition to compensatory damages, punitive damages are warranted as punishment to Johns Hopkins All Children's Hospital for the false imprisonment claims you have found for Maya Kowalski and as a deterrent to others. In this section, this additional claim for punitive damages involves only the claims for false imprisonment. The trial of punitive damages is divided into two parts. In this first part, you will decide whether the conduct of Johns Hopkins All Children's Hospital is such that punitive damages are warranted. If you decide that punitive damages are warranted, we will proceed to the second part of that issue after you have finished deliberating, during which the parties may present additional evidence and argument on the issue of punitive damages. I will then give you additional instructions, after which you will decide whether, in your discretion, punitive damages will be assessed, and if so, the amount. Punitive damages are warranted if you find by clear and convincing evidence that employees of Johns Hopkins All Children's Hospital involved in any false imprisonment were personally guilty of intentional misconduct or gross negligence, which was a substantial cause of loss, injury, or damage to Maya Kowalski, and that A, the officers, directors, or managers of Johns Hopkins All Children's Hospital actively and knowingly participated in such conduct, or B, the officers, directors, or managers of Johns Hopkins All Children's Hospital knowingly condoned, ratified, or consented to such conduct of Catherine Beatty or other employees of Johns Hopkins All Children's Hospital, or C, Johns Hopkins All Children's Hospital engaged in conduct that constituted gross negligence and that contributed to the loss, damage, or injury to Maya Kowalski. Under those circumstances, you may, in your discretion, award punitive damages against Johns Hopkins All Children's Hospital. If clear and convincing evidence does not show such conduct by employees of Johns Hopkins All Children's Hospital involved in the false imprisonments, punitive damages are not warranted against Johns Hopkins All Children's Hospital as to false imprisonment. On the verdict form, you will be asked to make this decision for each of the 3 occasions claimed as false imprisonments. Intentional misconduct means that the employees of Johns Hopkins All Children's Hospital involved in the false imprisonments had actual knowledge of the wrongfulness of their conduct and the high probability that injury or damage to Maya Kowalski would result, and despite that knowledge, intentionally pursued that course of conduct resulting in injury or damage to Maya Kowalski. Gross negligence means that the conduct of the employees of Johns Hopkins All Children's Hospital involved in the false imprisonments was so reckless or wanting in care that it constituted a conscious disregard or indifference to the life, safety, or rights of Maya Kowalski. Clear and convincing evidence differs from the greater weight of the evidence in that it is more compelling and persuasive. As I have already instructed you, greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. Clear and convincing evidence is evidence that is precise, explicit, lacking in confusion, and such weight that it produces a firm belief
No,
or
Rafe.
conviction without hesitation
The death
about the
penalty
matter
is not on the
and
table.
issue. A manager is more
Though we
than a
might wish
mid-level
that it were.
employee. It is someone who holds a position with the corporation which might result in the manager's acts being deemed the acts of the corporation. The second claim for your consideration is a claim of battery brought by Maya Kowalski against Johns Hopkins All Children's Hospital. Maya Kowalski claims that Catherine Beatty and a bedside nurse whose hands are shown in photographs and evidence, both of whom are employees of Johns Hopkins All Children's Hospital, committed battery by engaging in harmful or offensive personal contact upon Maya Kowalski with the intent to cause such contact. Maya Kowalski claims that Johns Hopkins All Children's Hospital is liable for battery for the acts of Catherine Beatty or bedside nurse during the time that Maya Kowalski was in the hospital. She claims that Miss Beatty committed battery by giving her unwanted touching, including hugging, patting, kissing, and placing her on her lap. She also claims that Miss Beatty or bedside nurse committed battery during the incident when Maya Kowalski claims she was intentionally restrained on January 6, 2017, and photographs were taken of her body. Johns Hopkins All Children's Hospital admits that it would be liable for any harmful or offensive contact with Maya Kowalski by Miss Beatty or the bedside nurse because their actions were done in the course and scope of employment with Johns Hopkins All Children's Hospital. Maya Kowalski must prove all claims by the greater weight of the evidence. I will now define some of the terms you will use in deciding this claim. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. Battery means a harmful or offensive physical contact upon another with the intent to cause such contact or the apprehension that such contact is imminent. It is not necessary that the contact cause physical injury.
Yeah, here's what I was saying
It
back
is
when we were
enough
discussing
that
this.
the actor intends
It
to
is
make the
battery.
contact and that the contact would be offensive to a reasonable person under
Yep.
like circumstances. A battery is a cause of loss, injury, or damage if it directly and in natural and continuous sequence produces or contributes substantially to producing such loss, injury, or damage, so that it can reasonably be said that, but for the harmful or offensive physical contact, the loss, injury, or damage would not have occurred. In order to be regarded as a legal cause of loss, injury, or damage, a battery need not be the only cause. A battery may be a legal cause of injury even though it operates in combination with the act of another, some natural cause, or some other cause if the battery contributes substantially to producing such loss, injury, or damage. The issue for you to decide on Maya Kowalski's claim against Johns Hopkins All Children's Hospital are whether Miss Beatty or bedside nurse committed a harmful or offensive contact upon the person of Maya Kowalski with the intent to make a contact that a reasonable person would find to be offensive under like circumstances. On the verdict form, you will be asked to decide this issue for each of the two batteries described. If the greater weight of the evidence does not support this claim of Maya Kowalski for either of the alleged batteries, your verdict should be for Johns Hopkins All Children's Hospital. However, if the greater weight of the evidence supports the claim by Maya Kowalski for one or both of the alleged batteries, then your verdict should be for Maya Kowalski and against Johns Hopkins All Children's Hospital. You will be asked on the verdict form to make a decision about the alleged battery on January 6th, 2017, separate from the other alleged battery. If you find for Johns Hopkins All Children's Hospital on both claim batteries, you will not consider the matter of damages. But if you find for Maya Kowalski against Johns Hopkins All Children's Hospital, you should award Maya Kowalski an amount of money that the greater weight of the evidence shows will fairly and adequately compensate her for the loss, injury, or damage, as the greater weight of the evidence shows was caused by the batteries committed by Catherine Beatty or bedside nurse. If you find for Maya Kowalski against Johns Hopkins All Children's Hospital, you shall consider the following elements of damages for her.
Is it just me, or is
A,
having these read aloud
any
make it
bodily
sound
injury
way
sustained by
worse?
Maya Kowalski and any resulting pain and suffering, disability, or physical impairment,
Sounds pretty bad.
mental anguish, inconvenience, or loss of capacity for the enjoyment of life experienced in the past or to be experienced in the future. There is no exact standard for measuring such damage. The amount should be fair and just in the light of the evidence. And B, the reasonable value or expense of psychological treatment necessarily or reasonably to be obtained by Maya Kowalski after she reaches the age of 18. If you find for Maya Kowalski, but find that no loss, injury, or damage has been proven, you should award Maya Kowalski nominal damages. Nominal damages are damages of an inconsequential amount, which
too,
are
Lucid.
awarded when a wrong has been done.
So far, I
but
haven't heard
no
anything where I
actual
was like,
damage
no,
is
they didn't
proved.
really do that.
Jack Kowalski is also entitled to
So
certain
far,
types of damage as a parent
guilty,
for this
guilty.
claim brought on behalf of Maya Kowalski. If you find for Maya Kowalski against Johns Hopkins All Children's Hospital, you shall consider the following element of damages for Jack Kowalski as Maya Kowalski's parent. A, the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child Maya Kowalski in the past or to be so obtained in the future until Maya Kowalski reaches the age of 18. Because the claim for the battery that allegedly occurred on January 6, 2017 occurred at the same time and place that Maya Kowalski claims she was intentionally restrained, your
Shame.
award of damages for this
Shame.
claim against Johns Hopkins Hospital
Shame.
should not duplicate an award that you make for the same
Shame.
loss, injury, or
Shame.
damage on
Shame.
the claim for the intentional restraint. If your verdict is for Johns Hopkins All Children's Hospital on the claim of battery on January 6, 2017, you will not decide the issue of punitive damages. If, however, you find for Maya Kowalski against Johns Hopkins All Children's Hospital on the claim of battery for the incident on January 6, 2017, then there is an additional claim in this case that you must decide. You must decide whether, in addition to compensatory, let me start that sentence again. I apologize.
He needs water.
You must decide whether, in addition to compensatory damages, punitive damages are warranted as punishment to Johns Hopkins All Children's Hospital for the battery claim you have found for Maya Kowalski and as a deterrent to others.
A deterrent.
This additional
That's
claim
huge.
for punitive damages involves only the claim of battery on January 6, 2017.
Send a message, jury.
It does
Send a
not
message.
apply to any of the later claims in this lawsuit. The trial of punitive damages is divided into two parts. In this first part, you will decide whether the conduct of Johns Hopkins All Children's Hospital is such that the punitive damages are warranted.
Oh, it's
If you
warranted.
decide that punitive damages are warranted, we will proceed to the second part of that issue after you have finished deliberating, during which the parties may present additional evidence and argument on the issue of punitive damages. I will then give you additional instructions, after which you will decide whether, in your discretion, punitive damages will be assessed, and if so, the amount. Punitive damages are warranted if you find by clear and convincing evidence that Catherine Beatty or the bedside nurse involved in the claim of battery on January 6, 2017, were personally guilty of intentional misconduct or gross negligence, which was a substantial cause of loss, injury, or damage to Maya Kowalski, and that A, the officers, directors, or managers of Johns Hopkins All Children's Hospital actively and knowingly participated in such conduct, or B, the officers, directors, or managers of Johns Hopkins All Children's Hospital knowingly condoned, ratified, or consented to such conduct of Catherine Beatty or other employees of Johns Hopkins All Children's Hospital, or C, Johns Hopkins All Children's Hospital engaged in conduct that constituted gross negligence.
Yeah, there
and
it
that
is.
contributed to the
That's the
loss,
one.
damages, or injury
C.
to Maya Kowalski.
C.
Under those
It's C.
circumstances,
The answer is
you
C.
may, in your discretion, award punitive damages against Johns Hopkins All Children's Hospital.
God, there's a lot of
If
punitive
clear and
damages
convincing evidence
opportunities here.
does not show such conduct by Catherine Beatty or bedside nurse, punitive damages are not warranted against Johns Hopkins All Children's Hospital. On the verdict form, you will be asked to make this decision as to the battery claimed for the January 6, 2017 incident. Intentional misconduct means that Miss Beatty or bedside nurse had actual knowledge of the wrongfulness of their conduct and the high probability that injury or damage to Maya Kowalski would result, and, despite that knowledge, intentionally pursued that course of conduct, resulting in injury or damage to Maya Kowalski. Gross negligence means that Miss Beatty's or bedside nurse's conduct was so reckless or wanting in care that it constituted a conscious disregard or indifference to the life, safety, or rights of Maya Kowalski. Clear and convincing evidence differs from the greater weight of the evidence in that it is more compelling and persuasive. As I have already instructed you, greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. Clear and convincing evidence is evidence that is precise, explicit, lacking in confusion, and of such weight that it produces a firm belief or conviction without hesitation about the matter in issue.
I feel I've been clearly convinced.
A manager is more than a mid-level employee. It is someone who holds a position with the corporation which might result in his or her acts being deemed the acts of the corporation.
Judge is going to the wall. Somebody needs to fill that gator cup up. He's running out.
The third claim for your consideration in this case is as follows. Maya Kowalski claims that Johns Hopkins All Children's Hospital was negligent in the medical treatment of her while she was a patient at Johns Hopkins All Children's Hospital, and that its negligent treatment caused her harm. Johns Hopkins All Children's Hospital denies the claim. Maya Kowalski must prove all claims by the greater weight of the evidence. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case.
I want to show the
Preliminary
jury
issue
this.
concerning Dr. Sally Smith, apparent agent.
I feel we should be able to submit some
Under
evidence.
Florida law, the Florida Department of Health is required to provide the services of a multidisciplinary child protection team in each of the zones of the Department of Children and Families. That team must be led by a medical director who is a doctor board certified in pediatrics and who has additional training in child abuse. The medical director of the child protection team for the zone serving Pinellas County in 2016 and 2017 was Dr. Sally Smith. In that capacity, Dr. Sally Smith was required to investigate reports of child abuse that were assigned to her child protection team. The hotline report concerning Maya Kowalski was assigned to her team.
Eventually.
The employees of Johns Hopkins All Children's Hospital were obligated to cooperate with the investigation by the child protection team. As the medical director of the child protection team, Dr. Sally Smith was required to be capable of providing certain additional services. Those services included medical diagnosis and evaluation services and medical evaluation related to abuse, abandonment, or neglect as defined by policy or rule of the Department of Health. A child protection team may also provide consultation with respect to a child who is alleged to be abused when requested by any other professional involved with a child. Johns Hopkins All Children's Hospitals doctors and healthcare providers, however, were not required to follow incorrect diagnoses or evaluations, and they had an independent duty to Maya Kowalski to exercise independent medical judgment. When Dr. Sally Smith provided these services in her role as the medical director of the child protection team, she was not providing those services as an agent of any hospital. Dr. Sally Smith's role as medical director of the child protection team did not extend to treating Maya Kowalski. The parties agree that Johns Hopkins All Children's Hospital is legally responsible for the medical negligence of its doctors who are its employees or agents. In addition to the negligence of doctors who are its agents or employees, Johns Hopkins All Children's Hospital can become legally responsible for the medical negligence of a doctor who is not an employee or agent of the hospital when the doctor is what the law describes as an apparent agent of the hospital. Doctors are not employees or agents of a hospital merely because they have staff privileges at the hospital. They can, however, be treated as apparent agents of the hospital if the proof establishes that they fall within this category. In this case, the parties agree that Dr. Sally Smith was not an employee of Johns Hopkins All Children's Hospital. There is, however, an issue for your resolution whether Dr. Sally Smith was an apparent agent of
Maya
Johns
must not be
Hopkins
in the
All
courtroom,
Children's
or
Hospital.
the camera would be on her.
Maya Kowalski claims
I'm
that
glad.
Dr. Sally Smith was an apparent agent of Johns Hopkins All Children's Hospital, and that Dr. Sally Smith also was negligent in her medical treatment of Maya Kowalski while acting within the scope of her apparent authority. Johns Hopkins All Children's Hospital denies that Dr. Sally Smith was its apparent agent. Dr. Sally Smith was an apparent agent if Johns Hopkins All Children's Hospital, by its words or conduct, caused or allowed Beata or Jack Kowalski or both to believe that Dr. Sally Smith was an agent of and had authority to act for
Yep, they did.
Johns Hopkins All Children's Hospital.
But they did that.
And if Beata Kowalski or Jack Kowalski relied upon that belief in
And they
dealing
did.
with Dr. Sally Smith as the agent of Johns Hopkins All Children's Hospital.
They did.
A person is responsible for the negligence of its apparent
Check.
agent at the time and place of the alleged negligence of the apparent agent if the apparent agent was acting within the scope of her apparent authority. If the greater weight of the
feel like
evidence
I need a
does
nap.
not support Maya Kowalski's claim that Dr. Sally Smith was an apparent agent of Johns Hopkins All Children's Hospital at the time and place of any medical negligence that Maya Kowalski claims that Dr. Smith
I'm
committed,
purple.
that's Dr. Sally
News.
Smith.
Oh,
Then
my
your
chair
verdict
goes all
on
the
the
way
claim
back. It's
of
so
Maya
good.
Kowalski
It has a
concerning
footrest
the
and
alleged
everything.
medical negligence of Johns Hopkins All Children's Hospital in this case cannot be based on claimed medical negligence by Dr. Sally Smith. If, however, the greater weight of the evidence supports Maya Kowalski's claim that Dr. Sally Smith was an apparent agent of Johns Hopkins All Children's Hospital at the time of any act of medical negligence, and that Dr. Sally Smith was acting within the scope of her apparent authority, then your verdict on the medical negligence claim against Johns Hopkins All Children's Hospital can be based on the medical negligence by Dr. Sally Smith. Remainder of medical negligence instructions. Now that I have explained this preliminary issue, I will now define additional terms you will use in deciding this claim of medical negligence. Negligence is the failure to use reasonable care. Reasonable care on the part of a doctor or hospital is that level of care, skill, and treatment which, in the light of all relevant surrounding circumstances, is recognized as acceptable and appropriate by similar and reasonably careful doctors or hospitals. Negligence on the part of a doctor or hospital is doing something that a reasonably careful doctor or hospital would not do under like circumstances, or failing to do something that a
Check.
reasonably careful doctor or hospital would do under like circumstances.
And check.
Negligence is a legal cause of loss, injury, or damage if it directly and in natural and continuous sequence produces or contributes substantially to producing such loss, injury, or damage, so that it can be reasonably said that, but for the negligence, the loss, injury, or damage would not have occurred. In order to be regarded as a legal cause of loss, injury, or damage, negligence need not be the only cause. Negligence may be a legal cause of loss, injury, or damage, even though it operates in combination with the act of another or some other cause, if the negligence contributes substantially to producing such loss, injury, or damage.
Where's my pillow? Here it
The
is.
issues that you must decide on Maya Kowalski's claim against Johns Hopkins All Children's Hospital are
It's
whether
cozy.
the Johns Hopkins All Children's Hospital was negligent through any of its employee doctors or through any apparent agent doctor in the medical care and treatment of Maya Kowalski, and if so, whether that negligence was a legal cause of loss, injury, or damage to Maya Kowalski. If the greater weight of the evidence does not support Maya Kowalski's claim, then your verdict should be for Johns Hopkins All Children's Hospital on this claim. However, if the greater weight of the evidence supports the claim of Maya Kowalski, then your verdict should be for Maya Kowalski and against Johns Hopkins All Children's Hospital on this claim.
Instead of squats, we're doing naps.
If you
Now
find
shut up and get
for
comfy
Johns
under a
Hopkins
blanket.
All Children's Hospital, you will not consider the matter of damages. But if you find for Maya Kowalski, you should award her an amount of money that the greater weight of the evidence shows will fairly and adequately compensate her for the loss, injury, or damage, as the greater weight of the evidence shows was caused by the conduct complained of. If you find for Maya Kowalski, you shall consider the following elements of damages. A, any bodily injury sustained by Maya Kowalski and any
You can
resulting
find this
pain and
chair
suffering, disability,
my
or physical
Amazon
impairment,
list.
mental
I'm an
anguish,
Amazon
inconvenience, or loss of
influencer, you
capacity
know.
for the enjoyment of life,
This chair is on my Amazon
experienced in
list.
the past or to be
You can
experienced in the
find it
future.
in the description
There
on
is
my
no
link
exact
tree.
standard for measuring
It's
such
a great
damage. The
chair.
amount should be fair and just in the light of the evidence. B, the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably to be obtained by Maya Kowalski. And C, any loss of ability to earn money in the future by Maya Kowalski. If you find that Johns Hopkins All Children's Hospital caused a bodily injury and that the injury resulted in an aggravation of an existing disease or physical defect, you should attempt to decide what portion of Maya Kowalski's condition resulted from the aggravation. If you can make that determination, then you should award only those damages resulting from the aggravation. However, if you cannot make that determination, or if it cannot be said that the condition would have existed apart from the injury, then you should award damages for the entire condition suffered by Maya Kowalski. The fourth claim for your consideration in this case is brought by Jack Kowalski against Johns Hopkins All Children's Hospital. He claims that Johns Hopkins All
Mathersizing.
Children's Hospital fraudulently billed the Kowalskis and their health insurers,
And so
falsely
they did.
claiming that the
Check.
hospital was treating Maya Kowalski for CRPS.
Check.
He claims this fraudulent information caused him harm.
Check.
Johns Hopkins All Children's Hospital denies this claim.
course they do.
Mr. Kowalski let me start again. Mr. Kowalski must prove all claims and defenses by the greater weight of the evidence. I will now define the terms you will use in deciding this case. And members of the jury, where it says must prove all claims and defenses, it just should say must prove all claims by the greater weight of the evidence. So please strike out and defenses. Mr. Kowalski must prove
Oh,
all
now we're
claims
editing
by
on
the
the
greater
fly.
weight of the evidence.
This is like when you're in
I will
school
now
and the
define
teacher is like,
terms you will
Go to
use in
question
deciding this
7 and
case.
strike out the last part.
my pillow's right here. This chair comes with
It's a lot of talking for me.
it comes with a lumbar pillow, but I use it as a neck pillow because it's perfect. It fits
Greater
right in
weight
that
of the
spot.
evidence means the more persuasive and convincing force and effect of the entire evidence in the case. A material fact is one that is of such importance that Mr. Kowalski or his insurance company would have acted or would have refrained from acting but for the false statement about it. Misrepresentation of a material fact is a legal cause of loss, injury, or damage if it directly and in natural and continuous sequence produces or contributes substantially
Yes,
to
it's on
producing
the Amazon
such
page.
loss or damage, so
The
that
pillow
it can
comes with it.
reasonably be said that, but for the misrepresentation, the loss, injury, or damage would not have occurred. In order to be regarded as a legal cause of loss, injury, or damage, a misrepresentation of a material fact need not be the only cause. Misrepresentation of a material fact may be a legal cause of loss, injury, or damage, even though it operates in combination with some other cause, if the misrepresentation contributes substantially to producing
I could get
such
into a
loss,
pillow
injury,
float
or
stream.
damage. The issues for you to decide on the claim for fraudulent billing are: A, whether Johns Hopkins All Children's Hospital made a false statement concerning a material fact in or in regard to its billing. B, whether Johns Hopkins All Children's Hospital knew the statement was false when it made it, or made the statement knowing it did not know whether it was true or false. C, whether Johns Hopkins All Children's Hospital intended that another would rely on the false statement. D, whether Mr. Kowalski or his insurance company relied on the false statement. And E, whether the reliance on the false statement was a legal cause of loss, injury, or damage to Mr. Kowalski. If the greater weight of the evidence does not support the claim of Mr. Kowalski, your verdict should be for Johns Hopkins All Children's Hospital on this claim. However, if the greater weight of the evidence supports the claim, then your verdict should be for Mr. Kowalski and against Johns Hopkins All Children's Hospital on this claim. If you find for Johns Hopkins All Children's Hospital, you will not consider the matter of damages. But if you find for
But
Mr.
that's not
Kowalski,
gonna
you
happen.
should award them an amount of money that the greater weight of the evidence shows will fairly and adequately compensate them for any monetary loss or damage sustained by them and caused by the fraud. You shall consider the following elements of damage. A, any deductibles or copays incurred by the plaintiffs as a result of Maya Kowalski's sheltering at Johns Hopkins All Children's Hospital, or increases in their cost of insurance coverage in the past or in the future, including increased premiums, copays, and higher deductibles, and reimbursement for the difficulty of finding insurance in the future. The fifth claim for your consideration in this case is brought by the estate of Beata Kowalski against Johns Hopkins All Children's Hospital. The estate claims that during the time that Maya Kowalski was a patient at the hospital, Johns Hopkins All Children's Hospital acted extremely and Let me read the sentence again. The estate claims that during the time that Maya Kowalski was a patient at the hospital, Johns Hopkins All Children's Hospital acted extremely and outrageously, causing Beata Kowalski severe emotional distress. In this claim, the estate claims that the extreme and outrageous conduct of Johns Hopkins All Children's Hospital caused Beata Kowalski to suffer severe emotional distress prior to her death. Through this claim, the estate now seeks to recover for that harm. Johns Hopkins All Children's Hospital denies this claim. The estate must prove its claim by the greater weight of the evidence. I will now define some of the terms you will use in deciding this claim.
One Googleplex seems fair.
Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. Extreme and outrageous conduct is behavior which,
check,
under the circumstances, goes beyond all possible bounds of decency,
check,
and is regarded as shocking,
check,
atrocious,
check,
and utterly intolerable
check,
in a civilized community.
check.
Emotional distress is severe when it is of such intensity or duration that no ordinary person should be expected to endure it.
Check.
Extreme and outrageous conduct is a legal cause of severe emotional distress if it directly and in natural and continuous sequence produces or contributes substantially to producing such severe emotional distress, so that it can reasonably be said that, but for the extreme and outrageous conduct, the severe emotional distress would not have occurred.
Check.
In order to be regarded as a legal cause of severe emotional distress, extreme and outrageous conduct need not be the only cause. Extreme and outrageous conduct must be a legal cause of severe emotional distress, even though the act of another or some other cause also contributes to the distress. The issue for you to decide on the estates, and that should read fifth claim.
Locals has some good memes.
The issues for you to decide on the estate's fifth claim are: 1, whether Johns Hopkins All Children's Hospital, through its agents and employees, engaged in extreme and outrageous conduct during the time that Maya Kowalski was a patient at the hospital and acted with the intent either to cause Beata Kowalski severe emotional distress or with reckless disregard of the high probability of causing Beata Kowalski severe emotional distress. And if so, 2, whether that extreme and outrageous conduct was a legal cause of severe emotional distress to Beata Kowalski. If the greater weight of the evidence does not support the estate's claim, your verdict should be for Johns Hopkins All Children's Hospital. However, if the greater weight of the evidence supports the estate's claim, your verdict should be for the estate and against Johns Hopkins All Children's Hospital. If your verdict is for Johns Hopkins All Children's Hospital, you will not consider the matter of damages. But if the greater weight of the evidence supports the estate's claim, you should determine and write on the verdict form in dollars the total amount of loss, injury, or damage which the greater weight of the evidence shows will fairly and adequately compensate the estate for the loss, injury, or damage occurring prior to the death of Beata Kowalski on January 8th, 2017. If you find for the estate, you shall consider the following elements. A, any resulting pain and suffering, mental anguish, experienced by Beata, let me read again. If you find for the estate, you shall consider the following elements. Any resulting pain and suffering or mental anguish experienced by Beata Kowalski prior to her death on January 7th, 2017. There is no exact standard for measuring such damage. The amount should be fair and just in the light of the evidence.
I'm
Now,
so
members of the
lazy
jury,
right now.
I noticed that we, in one case, said that Beata Kowalski died on January 7th and another time on January 8th. I think the evidence was it was in that time frame. I apologize, I was not consistent, but the intent here is the damages before her death. Okay. Whether it's on January 7th.
I
the
think
evening of
jury
January
deliberation
7th
is
or
going
the
to be at
morning of the
least
8th.
6 hours, maybe more. I know you guys are asking
Moving
what's the
on to claim
over-under.
6.
I'm going with 6 to 10.
The sixth claim for your consideration in this case is a claim brought by the estate of Beata Kowalski.
Simply because the jury
estate
instructions
claims that
are
Johns Hopkins
so
All Children's Hospital
intense.
acted extremely and outrageously during the time that Maya Kowalski was a patient at the hospital, and that this conduct is a legal cause of Beata Kowalski's death by suicide. Johns Hopkins All Children's Hospital denies this claim. If you decide on the verdict form for the survivor claim, the fifth claim, that the estate did not prove its claim. Actually, can I see the attorneys for a second on this?
Uh-oh. I can't do a new poll. I'm snuggling in my cozy nap chair. I've turned my streaming chair into a nap chair with my footrest up and my blankie. It's nap time. Fuck squats. We're napping. We're cozy. We're having a blanket fort day. Get your blanket forts out. Come on now. Put your feet up. Get your blanket forts out. I can't believe that we are conferencing over the jury instructions right now. Why are we doing that? I thought these were done. Oh my God, what page are we on? What day is this? What state am I in? What year is it? Who's the president? This trial has broken me. I want butter with my nap. Silent PS says, I want butter with my nap. Thank God for giant monitors. I can see your comments all the way from here. Because Mr. Fox bought me a giant monitor. Get out your sleeping mats. While I roll out the TV cart. I want a blanket fort to stretch across this world. I know I've got people from Australia and the UK and Canada. We can make a blanket fort across the world. This is just something. We have to get through these jury instructions. This is going to take a while. So my advice to you is to get cozy, get under a blankie, put your chair in recline. If you're at work, maybe you can sneak under your desk for a few minutes. Like George Costanza. No one will know. Just shut your door, get under your desk, put your jacket over you, and just take a little snooze while we do this. Oh yeah, daylight savings. Of course, we fell back, so we gained an hour, which was nice. I liked waking up and it being an hour later. Do they need blankets in Florida? Well, yeah, because people crank up their air conditioning to such an ungodly level that it's cold inside those houses. So get your blanket out. Get your blankies. It's blankie nap time.
Juror who passed me the note.
Uh-oh.
Are we able to finish the reading of the instructions? Probably another 30 minutes. Okay.
What does the juror need to do in the next 30 minutes?
I'm going to restart.
Does someone on the
at
jury need to
beginning
poop?
of page 46 because I don't exactly know where I was. The sixth claim for your consideration in this case is a claim brought by the estate of Beata Kowalski. The estate claims that Johns Hopkins All Children's Hospital acted extremely and outrageously during the time that Maya Kowalski was a patient at the hospital, and that this conduct is a legal cause of Beata Kowalski's death by suicide. Johns Hopkins All Children's Hospital denies this claim. If you decide on the verdict form for the survivor claim, which is the fifth claim, that the estate did not prove its claim that Johns Hopkins All Children's Hospital acted extremely and outrageously, causing Beata Kowalski severe emotional distress, then you must also decide in favor of Johns Hopkins All Children's Hospital on this sixth claim. However, if you decide on the verdict form for the survivor claim, which is the fifth claim, and that the estate did prove its claim that Johns Hopkins All Children's Hospital acted extremely and outrageously, causing Beata Kowalski severe emotional distress, then you must also decide the issues in this sixth claim. The estate must prove its claims by the greater weight of the evidence. I will now define some of the terms you will use in deciding this claim. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. Extreme and outrageous conduct is behavior which, under the circumstances, goes beyond all possible bounds of decency and is regarded as shocking, atrocious, and utterly intolerable in a civilized community. Emotional distress is severe when it is of such intensity or duration that no ordinary person should be expected to endure it. I apologize. Was I at the greater weight instruction? Okay, I apologize, members of the jury. The issue for you to decide on the estate's wrongful death claim are: 1, whether Johns Hopkins All Children's Hospital, through its employees or agents, engaged in extreme and outrageous conduct during the time that Maya Kowalski was a patient at the hospital, and acted with the intent either to cause Beata Kowalski severe emotional distress or with reckless disregard of the high probability of causing Beata Kowalski severe emotional distress, and if so, whether that extreme and outrageous conduct was a legal cause of Beata Kowalski's death by suicide. Johns Hopkins All Children's Hospital did not need to specifically intend for the conduct of its agents and employees to cause Beata Kowalski to die by suicide. However, the agents and employees of Johns Hopkins All Children's Hospital needed to engage in extreme and outrageous conduct with the intent to cause Beata Kowalski severe emotional distress, or with reckless disregard of the high probability of causing Beata Kowalski severe emotional distress, sufficient to be a legal cause of her death by suicide. To be a legal cause of Beata Kowalski's death by suicide, the extreme and outrageous conduct must either: 1, create in Beata Kowalski an uncontrollable impulse to commit suicide, or 2, be a substantial factor in bringing about the suicide.
I don't understand. I thought they got rid of
Uncontrollable
this.
impulse means a mental state that prevented Beata
Isn't this what he
Kowalski
did the
for
directed verdict on
appreciating
earlier?
the nature of the act of suicide
I'm
or
confused.
controlling her conduct. In order to be regarded as a legal cause of death by suicide, Extreme and outrageous conduct need not be the only cause. Extreme and outrageous conduct may be a legal cause of severe emotional distress, even though it operates in combination with the act of another or some other cause, if the extreme and outrageous conduct contributes substantially to producing such severe emotional distress. If the greater weight of the evidence does not support the estate's claim, your verdict should be for Johns Hopkins All Children's Hospital.
Not
However,
gonna happen.
if the greater weight of the evidence supports the estate's claim, then your verdict should be for the estate and against Johns Hopkins All Children's Hospital.
Yeah, I thought they excluded
If your
the
verdict
suicide.
is for Johns Hopkins
I
All
guess I
Children's Hospital,
misunderstood.
you will not consider the matter of damages.
Oh God,
But
I can't sit
if the
up.
greater weight of the evidence supports the estate's
that?
claim,
What just
you
fell?
should determine and write on the verdict form in dollars the total amount of loss, injury, or damage which the greater weight of the evidence shows the estate of beyond.
All right, hold on. I think what happened here is, and we'll catch up in a second. What is that noise? Weird. It's like a mouse under my desk. Okay, this could turn into a whole other stream. The heck is that noise? What is that noise? Oh, it was you? All right, no. Out. And close the door. I love you. Oh, all right, just a second. I think it was the intentional infliction of emotional distress that they threw out. Intentional infliction. So whatever this is not that.
Kowalski and her survivor sustained as a result of her injury and death, including any damages that the estate and the survivors are reasonably certain to occur or experience in the future. Elements of damage for the estate. In determining the damages recoverable on behalf of the estate of Beata Kowalski, you shall
wanted
consider
pie.
the following elements. The estate's loss of net accumulations. Net accumulations is the part of Beata Kowalski's net income from salary after taxes, including pension benefits, which Beata Kowalski, after paying her personal expenses and monies for the support of her survivors, would have left as part of her estate if she had lived
They
her normal
changed
life expectancy.
irresistible to uncontrollable because they thought it would
Elements of damage
be
for
easier for
surviving
the jury to
spouse
understand.
and
Do you
children.
guys remember that?
In determining any damages to be awarded the estate for the benefit of Beata Kowalski's surviving spouse and children, you shall consider certain additional elements of damage for which there is no exact standard for fixing the compensation to be awarded. Any such award should be fair and just in the light of the evidence regarding the following elements. A, damages of surviving spouse. Jack Kowalski's loss of Beata Kowalski's companionship and protection and his mental pain and suffering as a result of Beata Kowalski's death. In determining the duration of the losses, you may consider the life expectancy of Jack Kowalski together with the other evidence in the case. B, damages by surviving children. The loss by Kyle Kowalski and Maya Kowalski of parental companionship, instruction, and guidance, and their mental pain and suffering as a result of Beata Kowalski's death. In determining the duration of those losses, you may consider the life expectancy of each of the surviving children together with other evidence in the case. C, loss, support, and services. The survivors, Jack Kowalski, Maya Kowalski, and Kyle Kowalski's loss by reason of Beata Kowalski's injury and death of Beata Kowalski's support and services from the date of injury to the date of death.
I'm jealous of
In
the
determining the
parakeets under
duration of any
blanket.
future loss, you may consider the joint
sounds
life
fun.
expectancy of the survivors and Beata Kowalski in the period of minority ending at age 25 of Maya Kowalski and Kyle Kowalski. And D, medical and funeral expenses. The medical and funeral expenses resulting from Beata Kowalski's death paid by Jack Kowalski. In evaluating past and future loss of support and services, you shall consider the survivor's relationship to Beata Kowalski, the amount of Beata Kowalski's probable net.
I would not be surprised if the jurors are taking notes on their jury instructions as they're going, because they each have a copy and they're following along. So I bet they're ticking off boxes just like we are. Check, check.
Income available for distribution to the survivor and the replacement value of Beata Kowalski's services to the survivors. Support includes contributions in kind as well as sums of money. Services means tasks regularly performed by Beata Kowalski for a survivor that will be a necessary expense to the survivor because of Beata Kowalski's death. Any damages that you find were sustained by Beata Kowalski's estate and by Jack Kowalski, Maya Kowalski, and Kyle Kowalski shall be separately stated in your verdict. Mortality tables. In determining how long Beata Kowalski would have lived had she lived out her normal life, you may consider her life expectancy at the time of her death. The mortality tables received in evidence may be considered in determining how long she may have been expected to live. Mortality tables are not binding on you, but may be considered together with other evidence in the case bearing on her health, age, and physical condition before her death in determining the probable length of her life. In determining the duration of any future loss sustained by Jack Kowalski, Maya Kowalski, and Kyle Kowalski by reason of the death of Beata Kowalski, you may consider the joint life expectancy of Jack Kowalski, Maya Kowalski, and Kyle Kowalski, and Beata Kowalski. The joint life expectancy is that period of time when both the decedent and a survivor would have remained alive. The mortality tables received in evidence may be considered together with the other evidence in the case in determining how long each may have been expected to live. Any amount of damages which you allow for the estate's loss of net accumulations should be reduced to its present money value, and only the present money value of these future economic damages
Don't
should be
forget to
included
visit the merch
in
store.
your verdict. The present money value of future economic damages is the sum of money needed now, which, together with what that sum will earn in the future, will compensate for these losses as they are actually experienced in future years. The seventh claim for your consideration in this case is brought by Maya Kowalski against Johns Hopkins All Children's Hospital. Maya Kowalski claims that Johns Hopkins All Children's Hospital acted extremely and outrageously during the time that she was a patient at Johns Hopkins All Children's Hospital. Johns Hopkins All Children's Hospital denies this claim. Maya Kowalski must prove her claim by the greater weight of the evidence. I will now define some of the terms you will use in deciding this claim. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. Extreme and outrageous conduct is behavior which, under the circumstances, goes beyond all possible bounds of decency and is regarded as shocking, atrocious, and utterly intolerable in a civilized community. Emotional distress is severe when it is of such intensity or duration that no ordinary person should be expected to endure it. Extreme and outrageous conduct is a legal cause of severe emotional distress if it directly and in natural and continuous sequence produces or contributes substantially to producing such severe emotional distress, so that it can reasonably be said that, but for the extreme and outrageous conduct, the severe emotional distress would not have occurred. In order to be regarded as a legal cause of severe emotional distress, extreme and outrageous conduct need not be the only cause. Extreme and outrageous conduct may be a legal cause of severe emotional distress, even though the act of another or some other cause also contributes to the distress. The issues for you to decide on Maya Kowalski's claims are: A, whether Johns Hopkins All Children's Hospital engaged in extreme and outrageous conduct and acted with the intent either to cause severe emotional distress or with reckless disregard of the high probability of causing severe emotional distress to Maya Kowalski, and
Check.
if so, whether the extreme and outrageous conduct was a legal cause of severe emotional distress to Maya Kowalski. If the greater weight of the evidence does not support Maya Kowalski's claim, your verdict should be for Johns Hopkins All Children's Hospital. However, if the greater weight of the evidence supports Maya Kowalski's claim, then your verdict should be for Maya Kowalski and against Johns Hopkins All Children's Hospital. If your verdict is for Johns Hopkins All Children's Hospital, you will not consider the matter of damages. But if the greater weight of the evidence supports Maya Kowalski's claim, you should determine and write on the verdict form in dollars the total amount of loss, injury, or damage which the greater weight of the evidence shows will fairly and adequately compensate Maya Kowalski for the loss, injury, or damage caused by the extreme and outrageous conduct. If you find for Maya Kowalski, you shall consider the following elements. A, any emotional distress sustained by Maya Kowalski and any resulting bodily injury, disability, or physical impairment, mental anguish, inconvenience, or loss of capacity for the enjoyment of life experienced in the past or to be experienced in the future. There is no exact standard for measuring such damage. The amount should be fair and just in the light of the evidence. B, the reasonable value of medical care and treatment necessarily or reasonably obtained by Maya Kowalski in the past or to be obtained in the future. C, any loss of ability to earn money sustained in the future. Aggravation or activation of disease or defect. If you find that Johns Hopkins All Children's Hospital caused a bodily injury and that the injury resulted in an aggravation of an existing disease or physical defect, you should attempt to decide what portion of Maya Kowalski's conditions resulted from the aggravation. If you can make that determination, you should award only those damages resulting from the aggravation. However, if you cannot make that determination, or if it cannot be said that the condition would have existed apart from the injury, then you should award damages for the entire condition suffered by Maya Kowalski. In deciding this case, it is your duty as jurors to decide the issues, and only those issues that I submit for your determination. You must come to an agreement about what your answers will be. Your agreed upon answers to my questions are called your jury verdict. The evidence in this case consists of the sworn testimony of the witnesses, all exhibits received in evidence, and all the facts that were admitted or agreed to by the parties. In reaching your verdict, you must think about and weigh the testimony in any documents, photographs, or other material that has been received in evidence. You may also consider any facts that were admitted or agreed to by the lawyers. Your job is to determine what the facts are. You may use reason and common sense to reach conclusions. You may draw reasonable inferences from the evidence, but you should not guess about things that were not covered here, and you must always apply the law as I have explained it to you. Let me speak briefly about witnesses. In evaluating the believability of any witnesses and the weight you will give the testimony of any witnesses, you may properly consider the demeanor of the witnesses while testifying, the frankness or lack of frankness of the witness, the intelligence of the witness, any interest the witness may have in the outcome of the case, the means and opportunity the witness had to know the facts about which the witness testified, the ability of the witness to remember the matters about which the witness testified, the ability of the witness to remember the matters about which the witness testified, and the reasonableness of the testimony of the witness, considered in the light of all the evidence in the case and in the light of your own experience and common sense. You have heard opinion testimony on certain technical subjects from persons referred to as expert witnesses. You may accept such opinion testimony, reject it, or give it the weight you think it deserves, considering the knowledge, skill, experience, training, or education of the witness, the reasons given by the witness for the opinion expressed, and the other evidence in the case. It is entirely proper for a lawyer to talk to a witness about the testimony the witness would give if called to the courtroom. The witness should not be discredited just because the witness talked with a lawyer about his or her testimony. In your deliberations, you will consider and decide several distinct claims. Although these claims have been tried together, each is separate from the others, and each party is entitled to have you separately consider each claim as it affects that party. Therefore, in your deliberations, you should consider the evidence as it relates to each claim separately, as you would had each claim been tried separately. Although these claims are separate claims, it is possible that separate claims may result in overlapping damages. Your verdict should not award damages twice for the same loss, injury, or damage, even if they result from different claims. Your award of monetary damages for each claim, if any, must not duplicate the same damage awarded in the other claims. That is the law you must follow in deciding this case. Tomorrow morning, the attorneys for the parties will present their final arguments to you. And when they are through tomorrow, I will have a few final instructions about your deliberations. Now, we're going to pause it right there. And that's going to be all of the instructions I am going to read. Can I see the attorneys for a moment up here, please?
Why is he pausing? What now? What now? We're not done. We're still not done? Oh, God. What page are we on? What page of jury instructions are we on? Has everybody fallen asleep yet? In your naps and in your, what am I saying? In your jammies, under your blankies? Are you having a nap yet? Have you fallen asleep? Oh, God. What do we need? Shopkin stat. There are addicts in the chat. Like this? Here you go. Here's some Shopkins for you. John Shopkins All Prisoners Hospital. Brought to you by Hasbro and Pfizer. Oh, God. You're eating pie? That's what I've been eating for days. Pie. I bought like 3 pies at the farmer's market because it was the last day that it was going to be open. And so like I cleaned them out of pies. And so my kids and I have been eating nothing but pie for the last 2 days. I just sent Hangry Fox downstairs to get some pie. You know, I think pie is fine. Pie is good. It's pie season, dang it. So one of you in the chat has some parakeets under your blankie that are nibbling your toes. And I can't be the only one who feels like that would be really fun. I want parakeets nibbling on my toes under my blankie. That's such a weird thing. It's so weird, but I totally know that happens. We used to have parakeets when I was a kid. Oh, they're so cute when they nibble on your fingers, though, and on your toes. They're just adorable. Oh, man. Gross.
Okay. Members of the jury, in a moment, I'm going to let you retire to the deliberations room, but you are not to begin to deliberate anything because we're going to have additional arguments tomorrow and some further jury instructions.
What?
You're not going to go home just yet, but I am going to be sending you back into the jury deliberation.
What additional arguments?
Do not discuss this case amongst yourselves. Do not do the investigation and receive no information.
What is
Now,
he
I'm going to send
talking about?
11 of you. I'm going to keep juror number 181.
Oh,
out
here we go.
with us.
We're
Okay,
going to
so
do the
if
jury.
the 11 of you can go back. Into
He's
the
going to
jury
question the
deliberation
juror. Oh my God, he's going to question the juror. They've got to be so freaking, freaked out right now that all the jury has to go. out and they're keeping juror number 1. Oh, this is so terrible. Additional arguments? What additional arguments? I thought we were done with additional arguments. How could they have additional arguments
Please be
tomorrow?
seated.
Well, here
The
we go.
only juror that remains with us is juror number 181.
I may
All
have to
11
sit up
other
for this.
jurors are not with us. I did receive your note and I have discussed it with the attorneys. I'm sorry that you're experiencing the issue that you put in your note. I don't want to say what it is. What I'm going to do
He's going to let him
is I'm
go.
going to discharge you from your further service of jury duty. I already have a juror note for you. There's a whole bunch of things I would like to say that I don't have time to go into, so I'm just going to kind of give you the short statements here. Number 1, I have already entered a court order prohibiting the disclosure of the names of the jurors until after the trial is over. You know the names of the jurors. So I'm telling you, until the trial is over and everything's done, you cannot let anyone know the name, identity, where they work. Do you understand that? Okay. You're going to be free of all other instructions. And so in a moment, I'll tell you what that means. But the bottom line is you're going to be free to talk about whatever you want. You're going to be free to look at whatever you want. You're going to be free not to talk about whatever you want. That's going to be totally up to you. But one of the most important things I need you to remember is until this is all over, you cannot say anything about the names of the other jurors. Unfortunately, because I'm going to be discharging you, I cannot have you say goodbye to the others. And I feel very sorry that I'm going to have to do that to you. What I will do is if you leave your telephone number with the court deputy, and if you are comfortable with it, when this is all over, I will give your telephone number to the other jurors. And then they can contact you and and then I'll ask them to give me their numbers so that you all can communicate back and forth. But that's not going to happen until after this is all over. So it's totally up to you if you want to leave your telephone number for us to give to the other jurors. And again, I apologize that you're not going to get to talk or say goodbye to everybody else. You have given us over 9 weeks of your time and attention. You took copious notes. You asked lots of questions. You did everything we asked you to do as a citizen of the state of Florida. And I cannot tell you how much I appreciate it. I know you have a job and I know your employer has given up your skills while you were with us. And so on behalf of all the lawyers,
Just because it's
in this
number
case, and on
181,
behalf
we
of the
don't know
court,
what number
I want to
seat he
say
is.
thank you. I do
They could
have
be
a
juror number
certificate.
1. We
I
don't
didn't know
know.
this was going to happen, so I don't have the certificate ready, but I will send that to you as well. Also, if you leave us your cell phone number, when we have a verdict, my assistant will call you. If you want to come on down to watch, you can do that. If you want to sign online to the Zoom or tap into any of the number of feeds that
We
are
don't know which
being
one.
broadcast, you will be able to do that. So
We don't know what number
with that,
jury
I'm going to go
juror
ahead and
this
give you the
is.
formal discharge instruction.
This is the one that had
And
some
I'm
kind
going
of
to
issue come
file
up.
this note, although
Maybe
Madam
somebody's
Clerk,
sick, maybe
he put
somebody's
his
in the
name on it,
hospital,
so the name has to remain
but
protected.
we don't know which juror
On
this
behalf,
is.
and juror 181,
181
on
isn't their
behalf of the parties,
position.
lawyers, and the people of the state of Florida, I wish to thank you for your time and consideration of this case. And I also wish to advise you of some very special privileges enjoyed by jurors. No juror, that would include you, can be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that the jury's deliberations, discussions, and votes should remain their private affair so long as you wish. And I know you didn't deliberate, and I know you haven't been discussing the case, but I'm just reading you the instruction. Therefore, the law gives you a unique privilege not to speak about the jury's work. The lawyers and their representatives are not permitted to approach you. They are not permitted to initiate any communication with you about the trial. However, you are free, if you wish to speak with any of the lawyers or anyone else about this trial, you may do that. Can't tell anybody the names of the other jurors until this is all over. So you have the right to refuse to speak with anyone, and you can also talk. It's going to be totally up to you. Please understand that a request may come from those who are simply curious, or those who may seek to find fault with you. And it's going to be up to you to determine
You may
whether
discuss Hare
to
Island.
preserve your privacy as a juror. So, do you have anything in the back room? So you do not need to go back in there? Okay, so what I'm going to ask the sheriff's office to do is to take him out that door and
Yeah,
take him
it's a man.
directly to his vehicle, and let me know when he is gone so we can then let the other jurors go, because I don't want there to be any possibility of them overlapping. So,
Why can't he just say goodbye?
What I'm going to do is,
I mean, they're already have
and
been
I'm going to
have
ask
told
the
each
TV
other
folks
they're
as
not
he
allowed
goes
to
through this other
talk
door. Let's make sure we do not capture
about the
his
case.
face. When thank you very much for yours. I hope the medical issue resolves
Medical
in a
issue.
quick fashion for you.
Somebody's in
Okay,
the hospital.
thank you.
Somebody went to the hospital.
All right.
I don't know why they can't just let him say goodbye, though. What are they risking if he says goodbye?
Okay, everyone can please be seated. Sorry, I didn't mean to do that. I just have to wait for another deputy to come so I can bring back the other 11. Why don't you bring them in?
Oh boy. And now he has to tell the other 11 that one of them is gone, and they're going to be very upset by this because they weren't allowed to say goodbye. I really don't understand that. I mean, they already don't speak to each other about the case. So would it be so terrible to let him go in the back room and say goodbye to everyone? Are they not allowed to know that he has a medical emergency and he's got to go? This is very strange to me. What are they worried about? What is the judge worried about that this person might say or do? It seems weird to me. Really weird. Yeah, the jury's going to be sick about it. They're going to be really upset. I mean, if they were worried about him saying something about the case, you just put the
everyone, please be
bailiff on
seated.
him. You put the bailiff right
Members of the
next
jury,
to
I
him to
want to
say
confirm while
goodbye.
you're away, you did not discuss this case amongst yourselves. You did not do any investigation, and you did not receive any information about this case. Is that correct?
And they're
And
all
no one's
totally
approached you about this case. Is that correct?
wondering where is their
And
other
has
jury
anyone seen
member.
any media coverage about this case? No. Okay. You will see that one of your number is no longer with us. He was suffering a medical issue. We will proceed with 11. Okay. I need him to get to his car because I can't have him have any contact with you. I've told him a couple of things. Number one, that he is not allowed to disclose your identity or where you work until after this is all over. Okay, so don't worry about that. He understands that issue. I also said that if he wants to leave his telephone number, I would be happy to share it with you after this is all over. And if you wish to leave your telephone number so I can share with him, I'm happy to do that. It's just, I told him he is not, and even if he has one or more of your cell phone numbers he is not allowed to contact you until this is all over, and he understands that. But if for whatever reason he does attempt to contact you, you cannot have any contact. I apologize that you haven't had a chance to say goodbye, but that's just the way I need to run it this way.
Why though?
So as soon as
What
I
are you worried
discharged him,
about?
he can't cross your path.
What?
So
Why?
that is the reason why I've done it the way I've done it. Now, I'll also say a couple more things. Tomorrow you're going to be deliberating, and I have told you we're going to take your cell phone and any sort of like smartwatch or anything like that away from you. A lot of times what juries find is when we get to this stage, things happen rather quickly.
I guess it could be
And
COVID.
then all of a sudden it's over and everybody's gone. If you all wish to share amongst yourselves your cell phone numbers and whatnot, it's up to you. I don't care. It's up to you if you want to do that. It's a good idea to do it today as opposed to tomorrow.
Callie, thanks for the
Just
Cash
if
App.
you're going to do that, get it out of the way. And so when you come tomorrow, we're focused on the closing arguments and then the beginning of deliberations. Now, let's talk about the time.
Kelly
for
wants to know,
tomorrow.
did
I asked
Anderson
you
say
before we went
jurors
to
will have a
lunch
financial
if we can start
chart?
earlier. I saw there might have been
I
some.
thought I heard something like that, but I'm
So
not
I
sure.
don't know. Do you want to start earlier, 30 minutes early, 15 minutes earlier, or the regular time? Early. So be here to start at 8:30. Is that comfortable for everybody? I mean, is it going to cause a problem for anybody? Now, a couple other things.
Ooh, locals. S. Nelson sent a tip on locals that said they're also likely to conclude that he was kicked off because he asked the defense too many questions.
I'm going to
Maybe. Although he
when you
did
come
say
in
it was a medical
tomorrow,
issue,
we're
didn't
going
he?
to ask for your lunch order from wherever we're going to get the lunch. I don't know where that is. So we'll get that done right out of the way. Just make sure on your lunch order you put your juror number, not your name, but your juror number on the order, because I don't want your names going to wherever we're going to go to lunch. So we all remember our juror numbers. Okay. Timing for tomorrow evening. I'm gonna kind of let that be the jury's determination within reason. I mean, I'm not gonna stay until 1 o'clock at night. If you come and decide at some point you still want more time to deliberate, that's fine. If you want to leave at whatever time, so long as you put in a full day tomorrow, that's fine. If you want to go into the evening somewhat, that's fine. That's going to be up to the jury. I know is it Wednesday, we've got to stop early. So, we'll stop at whatever time we need to stop on Wednesday. So have we heard if we're clear at this point? Okay. So juror 181 is now gone. Again, I apologize for the way all that went down, but it's the way I need to do it to make sure, one, that we don't have any sort of issue now that we're 9 weeks into this trial.
With the Dick defense, because they'll
hate to
come
have an
after me
issue
for something.
arise that caused us to start this whole thing over. So I'm just being overly protective of doing this properly. Do not discuss this case amongst yourselves. Do not do any of it. Is there anything else I need to instruct the jury before I let them go for the day? Okay, we will see you at 8:30 tomorrow. Do not discuss this case. Do not do any investigation. Receive no information.
All rise. Jurors exit.
All right, so the jury is being dismissed for the day? Is that what he said? All right, so we still have to get through the jury disqualification motion, I think. No, he's not finished with the instructions. He did not finish reading them. I know, I'm feeling anxious too. No, the chair is on the Amazon link. The Amazon
sorry?
link, not LinkedIn.
Well, we still have a juror disqualification motion. We've got apparently a couple of issues. with
Check the
jury
links in
instructions.
the description. You'll find the Amazon one. Linktree. Go to
take 5 to 10 minutes and we'll
It
address
couldn't have
all of
been
those
jury
issues
one.
when we
Couldn't have
come
been
back.
juror one because he
Okay.
said we still have the disqualification to go over.
All rise. Close and recess.
All right, how many minutes did he say? Hold on, I missed that.
When we'll take 5 to 10 minutes and we'll address all of those issues when we come back.
Okay. He said Linktree, not LinkedIn. No. Go to Linktree and you'll find the Amazon link there that goes to the chair. Oh my God, this is too difficult. This is too difficult. Let me see if I can just find the link for you. Hold on. Oh, Slidey Pie, thanks for the $2 Rumble rants. And here's another $2 from my poor pot to yours. Aw, thank you. Appreciate that. I'm trying to get the link. How do I get the link? Where's the Amazon link? There it is. Mrs. K. Griff for the win. There it is. I don't know if you can copy this and click on it. You should be able to click on it if you're on Amazon. I mean, YouTube. But yeah, my link tree is linktree/Megan Fox Writer. That has all my links there that are relevant. But yes, the Amazon one has my chair. In fact, I could go and show it to you. Couldn't I? I could. Let's see. I did a lot of research before I went and got this chair. And it was back when my neck was killing me. Let's see. Here's the Amazon one. My neck was killing me and I needed a new chair, like a good chair. Here we go. See? And Amazon told me I could be a Amazon influencer or whatever, which means that I can put links in here of stuff that I like. So I have some cooking stuff. I have my yoga swing, and here's my chair. And my heating pad and ice things for my neck. See, here's the chair. And it comes in all different colors. Well, or it used to. It looks like it now just comes in black or blue. There was like a green color. This is the one I have. Oh wait, hold on. There we go. This is the one that I have. It now looks like it just comes in black and in blue. Don't make fun of me for the yoga swing. The yoga swing is great for stretching. It is exactly for what it's for. It is not another kind of swing, I swear. It's a great thing. And you can do all sorts of great stretches that help with, it helped me with my neck pain, etc. Yeah, I do like the heating pad because it has a neck thing that wraps around your neck. So yeah, you can go check out my favorite stuff on Amazon. Amazon gives me a little bit of a kickback, not much, if you order from my Amazon links. So you got to go to that. You got to go to the right link though, that takes you to my store, which looks like this. It looks like this. See? And I have some other stuff in here too. Let's see. I have cooking stuff, my favorite spatula, my cast iron wok that I love, the Dutch oven that I like. So I just put a lot of Instant Pot that I like. I put a lot of the stuff that I use. Milk steamer for coffee. The yoga swing is great. Seriously. Oh, the TikTok leggings are in here too. Oh, I should add more stuff because there's more stuff that I like in, on Amazon for sure. It is a yoga swing. Have you not seen the yoga swing and what this does and what you can do? Have you not seen this thing? The yoga swing is amazing. It's amazeballs. This thing is so great. Let's see. Let me see if I can share this tab. Here we go. All right. Let's see if we can. Isn't there like a video? This thing is awesome. I don't do any of these things though. I hang upside down though. The hanging upside down part is really, really good. And you can just get in it like a regular swing, like a hammock. Do I sell signed copies of my books anywhere? Well, I have a bunch of copies of my books right here that I can sign and send to you. If you would like to purchase a signed copy of my books, of either one of my books, you can always email me here and we'll work something out. So, how long until court comes back? There is a video here. I'll show you what I like to do on the yoga swing. Hold on. Yoga swing upside down. There. Yep. This is it. Pretty much this is it.
In my living room, silk, we'll find one edge and then it'll
Yeah,
shake. So
we don't need to
I'm
watch
just
this
checking
entire
here
thing.
how much excess fabric is creeping up the back. If there's too much, you can take your hands to the back edge of your silk. Use your heels to scoot that booty back. Kick your legs free. Our fabric should land like where a belt would at our back body. Let's now free those thighs. Reach your arms up to grab your ribbons. Slowly tip back as you split legs wide. And wrap your ankles in front. Make a diamond shape with your legs. You
This
can
is so
curl
good
out
for
the
your
toes,
back.
but you don't need to if the heels stay connected. Soften your hands down to the floor and
Yep.
totally release through the shoulders. Let's take a few deep breaths.
No, this is great. This thing is fantastic.
If it feels good, interlace your hands behind you.
I
for
usually
a little
swing back and forth upside down for a while.
Now, when you're ready to release, find the fabric by your knees, unhook your heels.
Except I have
slowly
handles.
retip to seated.
So I can
I
just
like to
grab the
stretch the
handles
fabric over
and
the thighs
flip
and
over
nestle
or
the
sit back
shoulders
up.
in to land in a little child's pose.
Oh yeah.
And wrap.
This is a great thing. Totally release. Oh, the backbreaker. No, it helps to release the pressure. When you're upright all day long, everything's being compressed. It's like a decompression being upside down. It's fantastic. I love it. There's a reason why, what do they call it? The traction. It's like traction, but upside, but hanging. It works. It does. It works. I swear. It's great. Anyway, if you want to try it, they're not very much money on Amazon. You can go to my link and you can check it out. I think they're like $60, maybe $45 to $60 is what I paid. You guys are funny. This looks like something Ricada might endorse. That's funny. All right, where am I going? I have to back out of all these windows. Too many windows. Too many windows. All right, let's go back over to we were reading the deposition from Friday. Let's get back over there. All right, so you were notified of the immediate jeopardy. Wait a minute. Whoa, sorry. Mr. Whitney. Well, I was going to ask about that in a second, but let's just talk about the notice. What was the date of the notice? That we were notified of the immediate jeopardy? Yes, ma'am. January 31st, 2019. On January 31st, all right. And you were promoted, I'm sorry, I lost the date, but let's say within 3 or 4 weeks prior. Yes. All right. So sorry to belabor that point. Now, ma'am, have you had an opportunity to review our request for documents that was filed yesterday evening and plaintiff's notice of taking video deposition duces tecum? Yes. And you've had an opportunity to review Schedule A I saw Schedule A this afternoon. By chance, have you had an opportunity to review either hearing or the court discuss what his expectations were for production of documents? Did I hear that in the court? No. Or did you observe the video? Or no. A transcript? No. All right. Do you understand that the direction from the court was that Johns Hopkins All Children's Hospital was to produce anything having to do with the run up to the finding or classification of ongoing immediate jeopardy as described in the CMS report of January 11th, 2019? Yes. And you understand that the court further directed that anything even with a scintilla of odor related to the Joint Commission and or CMS indicated a classification or rate of immediate jeopardy going back as far as 2012 was to be produced to us. Yes. Oh, they're back. He's back.
Let's go over a few things before I forget. The plaintiffs used 50 minutes today. So in rebuttal, they consumed a total of 2 hours. The defense consumed 35 minutes. So in rebuttal, they consumed 55 minutes. So I think that concludes those time clocks. Now, you all were referencing that there might be some issue with the jury instructions.
More issues with the jury instructions. Is he kidding?
Very minor, Your Honor. On the false imprisonment in the first.
Can you give me a page number?
Yes, I can. Page 13.
Page 13.
No,
A
Cynthia.
and B on
He
page
dismissed a
13A
different juror for a
only
medical reason.
includes in the past, and I think it should say, and in the future. Or whatever language is acceptable, but I think that was unintentionally dropped out.
Wasn't this a question I sent around this weekend?
I wasn't paying attention. to
You
the
know,
questions.
I think it might have been, but I sort of counted on Mr. Elegant to catch it. I didn't double check it, but I'm not going to object to this.
Okay, so we need to add or in the future.
Yes.
What I'll do is I'll have the jurors open up their package and then I'll tell them to add those words in.
And I had a couple little things as well.
Okay. What page are you on?
Page 19, at the bottom, where it starts off with all children's, John Hopkins All Children's Hospital admits that it would be liable. For some reason, the standard sentence that would precede that, which is that John Hopkins All Children's Hospital denies these claims, got left off that one.
Whoops. I'm sure they
So
know that they
it would
deny all the
be
claims.
Johns Hopkins All Children's Hospital denies these claims and then go into Johns Hopkins All Children's Hospital admits.
Yes,
Any objection?
because it was missed of course and scope.
No objection.
Okay.
And then on page 41,
Mr. Elegant, were you trying to?
No, when you finish with the instructions that we need to do a jury verdict form change to match the change we just made. It's wrong there too. On false imprisonment. So we'll come back to that.
oh, on the damages.
Yes.
On page 41, when we agreed to drop the fraudulent billing down to Mr. Kowalski, I still had a them in line 3 and a them in line 5. And then in subpart A, it was the plaintiffs rather than him, and Mr. Kowalski.
Okay, so
Why is it frozen? Am I frozen too? Gosh dang it.
This is weird. God. Sorry, guys.
Of charges for medical services you determine were unnecessary and or not performed.
Two things. It wasn't pled. If it'd been there, the expert that we brought all the way down from Baltimore would have talked about this. The impact on him for these things is in the copay for him personally, because Aetna's not really complaining about any of this. So I don't think that's necessary. And I'm not quite sure how they would, I'm not sure what the evidence is that allows them to figure out how to calculate this.
So that was your second reason.
I think, yeah, that might have been 3 reasons out of 2.
Any response?
Yes, Your Honor. The evidence came in without objection. We put the billing in. We talked about the CRPS not being performed as it should be and not being treated. And there's also a reasonable inference from the evidence that none of the CRPS billing should be charged against them. Will the jury agree? I doubt it. But we believe with the evidence in the record right now, there should be at least language to that effect if they choose to believe that the Kowalskis were overbilled. And the pleadings collapse into the proof of trial, and we have in the billing records, we have in the coding, so they know which ones are which, and we have in the testimony about the CRPS not being the real diagnosis, and of course, Dr. Katzenstein giving 5 hours over the course of 97 days.
I'm not inclined to add that proposed little c to page 41.
Thank you, Your Honor.
Now, as far as the verdict form, I need to fix the question and add something to the line along the lines of in the future.
Yes, Your Honor. Let me,
So that means all of the verdict forms that we circulated to you all, we need to shred those, and I'll give you clean ones in the morning.
I think the problem is in question 8. The two false imprisonment ones, question 8 and question 13.
I think I flagged this issue over the weekend.
I was thinking you took this out of one of these instructions when we went through it, and was there proof for these things? But that's just my memory.
Well, we're talking about pain and suffering here going into the future. I think there's proof on that. Mr. Alburn, I think what you're thinking about is that some of these, it doesn't capture, okay.
The list.
Number 12, expenses incurred in the future after she reaches 18. And I think, yeah, and then 14 is obtained in the future until she reaches.
This is what I'd ask Mr. Elliott and Mr. Altenburn to do. Get together, send me the specific language you want me to add, then I'll add it into the file. Just make sure it's specifically wherever you need it. If there's ultimately an objection to the language, send me each party's proposed language, but I don't think this is a controversial issue.
I agree. Mr. Elliott, I probably don't need to be in the courtroom for the next 4 or 5 minutes. I can walk out in the hall. If you want to call me, we can settle this.
Okay. I don't know what's being argued next.
Well, you might need to be here. That's true.
I think the next issue we're going to deal with is juror disqualification. That, in my mind, is what we're going.
Finally.
So, Mr. Elliott, why don't we just talk about it once that's finished?
Okay.
Thanks.
Anything else on the verdict form or jury instructions, or can I pivot at this point?
Pivot. Pivot.
Defense.
No, Your Honor.
We have before us a motion for juror disqualification of juror number 1. That was filed by defense. I've read the motion. I've read the response. I'm happy to accept further argument. Hopefully it won't overlap too much what was started.
No, I'll be brief, Judge. I appreciate, I know that you read the materials that have been provided to you. I do want to emphasize a couple of things and comment if I can.
Sure.
I would say that I understand this is a very rare motion to bring. I've been practicing for almost 40 years, almost 200 trials, and never had to bring this kind of motion before. So I appreciate the gravity of it. I appreciate the unusualness of it, but we do believe that it's merited in this case.
Oh, bullshit.
As you know, you're vested with the discretion in determining whether a juror has engaged in misconduct. And by misconduct, in this case, we don't mean that he has listened to news or done that things. But what we're talking about is that a juror that we believe has violated the instruction to not form any definite or fixed opinions about the merits of the case until all the evidence is in and arguments.
So you're
of
a mind
attorneys and
reader.
instructed on the law. We believe that deciding a case before hearing all the evidence is the antithetical to a fair trial. And I know that Your Honor has we've pointed out some of the jury questions from this particular juror, but there are a couple I just want to emphasize. I don't have a page number, but this juror particularly in one of his questions,
She doesn't even know.
started with you and this juror are not psychiatrists, we are humans and have feelings, etc. But goes on to say, is it possible that Maya's waning abilities could all or in part be contributed to what J Hatch was causing? The limiting of family interactions and the stress and trauma
Yeah.
Maya's testified to.
Yeah,
Document
and
statements to Maya about her mother's status, told to Maya by hospital staff, Miss Beatty.
double finger guns
Could all
coming.
this possibly have affected Maya's participation in your therapy sessions? To me, that, to the defense, that is a clear indication that this juror has already determined
No,
what the
he's
evidence is
determining
on
he
those
doesn't like your
issues.
witnesses. Denied. That is not
So
misconduct.
which one in your motion are you referring to? What little letter? 2A, B, C?
Oh, I don't know, Judge. I'd have to go back.
You don't know your
and
own motion?
connect that.
That's a
and I
mistake,
can do
Ms.
that
Crewell.
fast.
Denied.
The tenor of the questions that we've addressed in our motion, and the specific questions that we reference clearly, in our view, show that this juror has
She doesn't believe this at all.
predetermined
She doesn't even know what she's arguing right now. What are you looking for, ma'am?
the evidence.
What?
The
Shuffle, shuffle, shuffle. Not prepared to argue my motion. I'm not prepared to argue my motion. I'm just going to stand here and waste everybody's time.
just want to point out that in addition to those,
This motion is
Oh.
so damn weak.
this one
We got nothing.
specifically, Judge, and I'm sorry, I don't know if it's A, B, or C, but
Mm.
the question specifically states, will the jury be able to observe Sally Smith as a live witness or by Zoom during these proceedings? And goes on to say, are we able to be told, as there appears to be probable cause of improper actions by of Sally
Appears to
Smith
be.
in her side role at J Hatch,
Appears
as
to
was
be.
she written up or coached, is Sally Smith still performing duties at J Hatch?
Appears
to me,
to
that
be.
is a prime example
Appears
of the
to be.
concerns that we have with respect to this juror, since he's already determined that there's probable cause that
He
Sally
said there
Smith,
appears to be,
did harm and did wrong.
which does not mean there's
Um,
probable cause. It means there appears to be.
To further
There
Use
might
the
be.
word may.
the word may,
Did you read that may be probable cause?
I don't think.
Judge, turn your mic on.
Well,
Appears to
again,
be.
Judge, though, it's
Appears.
determination by this juror,
Elaine John
his
appears.
hostility towards the defense witnesses.
Yeah, well, he doesn't like your
his,
witnesses. They kind of suck. Have you seen your witnesses?
Advising that
Lady.
he happens to be of the same
Have you seen your witnesses?
ethnic background, and maybe we just thought she was pushy because
Have you seen your
because of
witnesses
that.
though?
um,
They were really
the-
unlikable. It's not a crime for a juror not to like your
the
witnesses.
fact that he considered one of the nurses a breath of fresh air because she's the first person to say anything nice about Maya.
They liked
All
that one of your
these, when you put
witnesses.
them
That was a
all
good
together,
thing.
Judge, are a pattern and
What?
an indication and evidence that this
No.
juror has already decided the case without any deliberation with his other fellow jurors, without any instruction on the law.
She doesn't even
Suggestions that the
sound like she
witnesses
believes this.
overreacted, indicating his view of the CRPS. I mean,
Come on, Whitney, get
the
up and
hostile
argue the other
questioning of this
side.
report. Are you attesting to this juror that you were the only one on the call? I mean, the whole tenor of all of these questions that we pointed out in our motion indicate that this juror has made up his mind. And it wasn't even, I mean, it was from pretty much after the Kowalskis testified. And from that point forward, I think the evidence shows he turned a deaf ear to the rest of the testimony. And
No,
that his questions indicate that.
he was
We
listening
think under
quite
the
well.
law That
He
there's
just didn't like
sufficient
your
grounds here.
he doesn't
for
like
this
your
court
case.
to, in fact, change his status from being one of the jurors to one of the alternates. And that would be the appropriate to handle it. We think the Allberger case supports that. We don't think it's necessary to interview the juror. We think that when you look at Allberger, that the appellate court will support that you as a trial judge were here and could judge this matter as the trial judge. The Washington v. State case that the plaintiffs cite to, which is first DCA,
That
the tenor
case
of those
is totally
questions were not the
against you.
same judge.
Yes,
the
they
judge
were.
seemed just to be irritated because they were asking a lot of questions, but it wasn't that the questions were hostile or indicated that the
The
juror
judge
had
already
made
told
up
you that
his or
his
her
questions
mind.
weren't hostile.
So
You
we
keep
believe
using
that
this word.
is the appropriate.
No one else agrees with you.
Motion to bring, and it should be granted.
Now, my reading of the Allberger, and that's Alberger versus Harbison, Harvison, 342 Southern 2nd, 537. There wasn't a discussion as to what the jurors' questions were. My recollection of that case was the trial judge had already determined, as a matter of fact, that the juror could not be unbiased and fair.
There's no detail in the, agree, there's no detail in the actual case as to what it was. It just said that the appellee's counsel voices objections on the grounds that the nature and manner of the juror's questions, and it was apparent the juror had shown bias and lack of objectivity. And then a juror was substituted over objection, that the juror was substituted. And we think that that is the case we have here, Judge. I mean, when you look at the totality of these questions and the hostility of these questions, as we've
The
detailed in our
judge
motion,
never agreed
and I
with
could
you,
point out some
even when
others,
you
but
were
I think the
saying
court has
that
read
when they
the-
were asking the questions.
read the questions, certainly during trial, the court read the questions. There were times during this trial when we at the bench pointed out, Judge, that seems to be a question where this juror has already made up his mind.
Let me ask you this. I mean, everyone knew that this juror was former law enforcement. I mean, we knew
Oh,
that
this was
from
the
day
former
one,
cop.
given his jury questionnaire. And isn't it something that law enforcement officers do, is they confront people with conflicts?
Yes,
and-
they
and
do.
Stories and evidence and
Yep.
see how they react? Isn't
Yep.
that just how a person digests information? And it's just,
You
we knew
sat
he was
him.
former law enforcement, and therefore we could kind of expect that he was gonna
You sat him.
ask tough questions, sharp cross-examination type questions.
Well, Judge, I don't think these are tough cross-examination questions. I think these are questions that show a bias. They
Garbage.
aren't objective questions. They are bias questions. When you talk about probable cause, when you talk about confronting a witness with, hey, wait a minute, maybe the reason Maya's having these issues is because of the fact that you separated her and you did this and you did that. Those aren't
You sat him.
tough cross-examination questions. Those are questions that indicate a bias and that he's already determined that those facts are true.
There's no, you
Anything
can't
else, Ms.
determine
Rose,
that.
you want to say?
Anything else?
Chance to respond to the
Anything else
Sure.
before you get
Who from
this?
the plaintiff is going to make the argument?
Whitney.
I will, Judge.
Nope.
It's,
Anderson.
Interesting perspective, because I went back and looked at my notes from the first 2 weeks, and I had a big question mark next to Juror 1 as to whether he was dead set against our position based on the questions that he asked. He didn't say he had the same ethnic background. He said Nordic and a certain blunt way, I believe was his question. So he was not trying to identify himself, because she's from Poland, and I think he's talking about Sweden. And the breath of fresh air, he just
Don't
said,
interrupt
period. He wasn't
him.
addressing that, and we don't know from that. What we're doing here is trying to go back and do another voir dire
And
or
read his
redo voir
mind.
dire. This this juror, like the court said, is probing every bit of this evidence and every one of these witnesses. And thank goodness there are jurors like that out there. So just because he has asked these type of questions does not disqualify him. If anything, he seems like a pretty contemplative
juror, as do all of ours. So that having been said,
Yeah, your
we
written
don't
response was
want
better, Anderson.
an appellate issue, any more of the appellate issues than the,
Well, let me just stop you right
go ahead.
Ms. Crowells is suggesting that juror number one status be changed from on the jury to being an alternate. So effectively not disqualify him, just shuffle the chairs.
I don't think this is a good idea.
At the end of the day, do you
Don't
agree
give them
doing that because you're concerned about it for whatever reason? Do you agree to do that or not? Because, if you're going to agree to do that, we'll walk a certain path. If you're not agreeing to do that, we'll walk a different path. Do you need a moment with Mr. Elegant and your team to decide that? Because when it's all said and done, if you're in agreement with Ms. Crowells on changing his chair from being on the jury to an alternate.
Well, my one question, I want to confirm who takes his place, obviously, which I think is juror number 5.
Whoever was the next.
My notes have.
We're not looking to shuffle the alternates, so whoever is the.
That's what I'm trying to figure out.
My notes have, and Madam Clerk, tell me if I'm wrong, that our jurors are jurors 1, 19, our jurors are 1, 17, 19, 93, 97, and 98. The first alternate is juror number 106, the retired electrician.
Yes.
Yes, Your Honor.
That's our understanding as well, Judge.
So that's the first alternate. Do you all need 5 minutes?
Yes, Judge. We realize what we're trading out, I guess. And we understand the position of the defense is they just want to trade spots.
Well, we just want to, it's not unusual in a trial to sometimes make somebody that was a juror an alternate if they fell asleep during trial, if they had issues. So that's our position.
I'm just wondering if there's an agreement obviating a ruling or is a need for a ruling. And I just 5 minutes, let's keep this to 5 minutes because
less than that, I just want to.
Do you want me to just sit here and?
Yeah, it's going to get appealed anyway.
Well, if you need to call Mr. Elegant, you can step outside.
They should
and
just
call him.
keep him. But I hate to say that I think I'm going to be
I'll just
right.
sit here and look pretty.
I said the judge was going to remove him. A bunch of other people said that wouldn't happen. But the way this is going, he's getting removed. He's getting kicked down to alternative status, which I think is really unfair to the juror. I think he's been paying very close attention. He's been asking good questions of both sides. I didn't see, and why in the world did Anderson not argue his motion the way it was written? That wasn't a very good argument. It wasn't a very strong argument. And they must not care about this that much. Yeah, I also thought that the judge was going to remove him because it's just easier than to pick a fight. But I think that Anderson should have made the argument that he made in his motion that says this sets a bad precedent. It sets a very bad precedent for jurors who want to be a part of the process and they're told they can ask questions and then they do ask questions and it gets held against them and they can be kicked out and 9 weeks of their life can be, down the drain. Yeah, it really stinks because and Will Call Magic says it really stinks because he's doing what they asked him to do and now they want to get rid of him one way or another for doing what they asked him to do. And if you're in one of these states and you are going to be on a jury where you're allowed to have questions, I guess remember this and remember to try and keep your questions as unspicy as possible. But it does keep the jurors from doing their jobs. It does. It absolutely does. It keeps them from doing their jobs because you're not allowed to ask a question that is skeptical of one side or the other. Oh my gosh, you can guarantee that if I ever end up on a jury and it's a criminal case, And my questions would be super skeptical of the state, because the state has the burden of proof. And if the state has the burden of proof, well, then they need to prove it to me. Yeah. Pause clause, as I learned from this trial, not to ask questions. Yeah, they can't kick you off if you haven't asked any questions. Terrible. It is. It does seem very wrong. And she didn't even argue her case she didn't argue her motion very well at all. But to the same argument, neither did Anderson. I do think that this is terrible. I think this is a terrible thing. Holly S., thanks for the super chat. Love you from Texas. Love you back. Testicular trauma. Thanks for the super chat. Says Hunter sent hospital advice terms for a supervision order anticipating her return to dad. They both wanted control. Independent psych favored Maya. DCF closed file April 17th, i.e. no protection concerns. All right. So if the DCF file was closed totally by April, then that means they only kept her under their supervision from January, February, March, April, 3 months. I told you it's all garbage. Kelly R., thanks to the super chat, says the lawyers should not be allowed to know what juror asked what question. And it'll be hard to keep that from them because they see who's handing in papers, you know? And I guess they have to know in case something like this comes up. On a scale of give it a whirl up to zealous advocacy, how hard did you argue?
I think I better stay with number one. I don't
So
think we
you
have
were
a quorum.
opposing.
You should
the-
oppose.
Yeah,
Yes.
I need to oppose that.
You should.
I have very mixed feelings, but first, I think it's the
Oppose.
right thing to do to keep him on there under the law and our system of choosing jurors.
They chose
I
him.
don't see anything in his questions. I see him probing things deeply. And I think like I said, when we started out, I wasn't sure which side he's on, and I'm still not sure based on some of his questions.
Oh, look at Shapiro laughing at him.
I think the point should be he shouldn't be on anybody's side at this point, Judge. That's the point.
They all
By
form
now?
opinions at some point.
Come
get through
on.
it, and they're all cheering for one side or
It's
the
the
other,
end of
and
the
then they switch
case.
sides depending on the evidence. That's the nature of jury trials.
How deeply are we probing?
So I need your final answer, Mr. Anderson, so we can.
The final
Get
answer
this thing
is he
going.
doesn't want
You're a lot
to
of help.
remove.
Someone has to make a decision for the plaintiffs. So
He said, I don't want him
you
removed.
you are there. If not, I'll call Miss Lawrence. She can give me the final answer. Where did you?
Ms. Lawrence is durable.
We're not doing that, Mr. Whitney.
He just told you, Judge, he wants to keep number one.
No, I changed my mind. I'll go with number 5.
What?
So I'll agree with you.
Ms. Lawrence, is this your final answer?
It's not number 5, it's 106.
Yeah, 106.
Well, hang on then.
It's the one he announced. The
I'm sorry,
God.
106,
Anderson.
perspective 106.
You're changing
And
your
He's
mind?
counting 1, 2, 3, 4, 5.
Yeah,
Yeah,
yes.
That's
really
why Whitney
sitting.
meant.
What?
Yeah.
All depends on how you count.
All right, so are we
Keep
concluding?
juror number one. Make the
Ms. Lawrence,
judge make
is that
the
your final
ruling.
answer?
What?
Yeah, I'm.
Okay.
What are you
I
doing?
think I'm gonna go with that.
Okay,
Okay.
so what we're gonna do,
Oh,
with the
yes.
agreement of the parties, and this is the
For
agreement of
fuck's
the
sake,
parties,
Anderson.
is juror number 106 will move into the status of being on the jury, and juror number 1 will move into the status of being an alternate.
Why in the
Which
hell didn't he
alternate
just
is he
make
just
the
gonna swap
judge
with?
rule?
Is it gonna matter after tomorrow?
Probably not, but
If someone has another medical emergency, we'll address it then, but.
Why
you know,
just
let's
give in
just
is
pray
right.
No one has another
Why?
medical emergency. How about that?
I hear you.
Let's
You know
not
what,
go about,
You know who I didn't check with through this whole thing? My client.
Oh no.
that would be important.
Yeah, that would be important. Oh my God, Anderson.
Well, let's let Mr. Anderson talk to Mr.
Keep
Kowalski.
number one. God damn it, you're right. It's
Then
worth
can we
the
move to
fight.
exhibits, Judge, unless you
Well,
have.
let's
Worth
give
the fight
Mr.
for the
Altenberg
juror.
a moment.
It's worth
Yeah,
the fight
I'm
for his
ready.
client. There's no reasonable reason for them to remove
Judge,
juror
Ms.
number
Altmer and I
one.
weren't able to talk, but I did send him a
Well,
text.
I'm gonna go with my client. I have to switch positions because my client feels more comfortable with juror number one. So I'm
All
gonna switch
right.
positions based on my client's.
Make the
input.
judge rule.
181 packet.
Yeah, this is
Okay,
terrible.
so
Terrible.
your
Yeah,
final
he's
answer, and just so
defiant.
I'm clear,
Number
the
one.
plaintiffs are objecting
Oh my God.
to
I can't take it. Yes, they're
objecting to the switch and wants, if I were to deny the change, your client wants the appellate issue issued.
To such as it is, I don't think there's much of one, but.
Okay. So the final answer is you're objecting.
I'm objecting.
Okay. Anything further, Ms. Crowells?
Judge, I think we've laid out the bias that we believe this jury has shown. I think that the appropriate ruling for the court is to grant the motion. I think under the case law, it's warranted. No, I have nothing further.
Court has before it the motion to disqualify juror number one for a question of bias. This is a very peculiar type of motion, and since normally when we see question of juror misconduct,
Peculiar,
it's
as in
they've
bullshit.
violated some sort of instruction of the court, like don't go to the accident scene, and they go to the accident scene, or something along those lines. The court has given instructions which the defense says that this juror has violated. For instance, instruction 202.2, you must avoid forming any final opinions. Keep an open mind. Actually, keep open mind is from 201.2. In this particular case, the evidence that the defense points to has to do with juror questions, and the court will, I think, without a doubt, everyone will agree that juror number one asked a substantial amount of questions. Now, to be fair, other jurors and alternates, although they don't know they're alternates, also asked a substantial number of questions. For instance, juror number 181, whom had the medical issue today, also asked a copious amount of questions. What we know about juror number one is he's a former law enforcement officer. We've known that since day one. That's on his juror questionnaire. Everyone's known that. And certainly he survived the individual questioning, then the group questioning that we had for all of the jurors. During the course
Anderson's breathing
of this
heavy in the
trial, I mean,
microphone.
obviously, I said juror number one has been asking a lot of questions, and I don't know, maybe 3 or 4 weeks ago, the defense started referencing their concern about this particular juror. And
Was it that long ago?
certainly, I've been paying attention both before, but acutely aware of each and every question that comes from juror number one. The case law that's been cited to the court from the case for the defendants is the Allberger case, and the best case, if you will, from the plaintiffs the Washington v. State case, which is 955 Southern 2nd, 1165. Judge Padovano, writing for the first DCA, talks about witnesses who ask probing cross-examination questions. And
If he's
how
going
that
with
is
Washington,
not
juror stays.
necessarily any indication that the juror has violated an order or instruction of the court. You know, the court's instructions, you can't form any final opinion. You have to keep an open mind. 9 weeks into this trial, I can tell you without any sort of certainty that juror number 1 has been testing the evidence in this case. Every single witness. Well, I don't think he asked a question today, but I think he asked a question on almost every single witness that wasn't by deposition. And the witness, even after the defense 3 or 4 weeks ago started pointing out what they were contending to be prejudgment, this juror continues to ask probing questions.
That's his job.
If he had already made up his mind, why would he
He
ask
wouldn't
so many
ask.
questions?
Yes, he wouldn't
If
ask.
he had a final or fixed opinion, why would he
He would
continue
not.
to do this? Now, yes, he put a lot of prefaces into it, but I would say that his prefaces talk about context. And we have to remember that the jurors ask their questions after all of the lawyers, and perhaps this is bad on me, but I did not constrain the lawyers to a strict direct, cross, and redirect. I let them go for recross and redirect and recross
Yeah, he
until the
did.
lawyers were finished with their
He
questions.
did,
That's
and
just
I hated
'cause
that.
I view this as a let's find the truth, and so I didn't want artificial boundaries on cross-examination and
It
redirect
was too long,
to
though.
to limit us. So the point is, sometimes it might be an hour and a half, 2 hours or so, or if we've taken lunch, even longer before the jurors were able to ask their question. And if they use, let's talk about this subject, and without providing context to the question, he might have written it down 2 hours before. So this juror was providing context. I have not seen anything in my mind that would remotely come to me to get to the conclusion that he has prejudged anything in this case.
Nope.
On the contrary, I am warmed by the fact that he has, in his mind, gone through, or what I believe to be his mind, based on the questions that he's asked, my observation. I mean, the guy sits, 5 yards from me. I've been watching him for more than 2 months. I mean, he's the closest juror to my physical vantage point and location. And I've been watching the guy. And I have no, not only do I not have a doubt, I don't have a reasonable doubt, but I have no doubt that this guy has not come up with any final or fixed opinion. And when I reviewed the motion, the only thing that gave me any hint of an issue was the reference to the shared cultural sense of Beata Kowalski and this witness. And I went back and looked at the actual question that was
and they
asked.
misrepresented
I don't see
it to
anything
you?
in here where this witness suggests even remotely that he is going to vote for.
They misrepresented it to you in
the
their
Kowalskis
motion.
because of that, or vote against the Kowalskis for that. To me, it's just
The dick
context.
defense,
He was
man.
providing a situation of how he was framing the question. And then I go back to, this is a person with law enforcement background, and he's, in my mind, taking what is sharply conflicting evidence that both sides have skillfully and artfully put forward to this jury, and he's trying to make sense of it. Now, there was a reference in the motion to, is he communicating? Obviously, there's no communication in the jury room every single
Juror
week,
number
even
one
if
is
it's
his
for 2
favorite.
minutes. I ask if they've been talking
He's like,
with each
I can't
other,
quit juror
and
juror
the
number
answer
one.
is no. So I have no concern that there's any hint of deliberations or discussions amongst the jurors back into the deliberation rooms outside of the court's presence. So I don't see that as the case. So the only evidence here is his demeanor in front of me, plus the questions that he's asked. And I don't even get to the point of whether I need to discuss whether I need to have a conversation with him, because I'm not even close to the question of whether I have a reasonable doubt as to whether he can be fair and impartial, whether he has violated any court instructions. And I've seen no evidence that he has violated any court instruction. On the contrary, I think he's been doing exactly what
you
we've
asked him
the
to
jury
do.
which
Yes.
is if they are so inclined to ask questions, and he's using his skill and expertise as a former law enforcement officer to do that. And that doesn't mean asking sharp questions, as Judge Padovano points out in the Washington case. That doesn't mean that the juror has come up with any sort of final or fixed or violated any instruction in the court. So I don't think I need to say anything more on that. So I'm going to deny the motion to remove juror number one from the juror. Juror number one will remain on the juror. The alternate number 106, the retired electrician, will remain.
Man, Anderson almost screwed that up by giving in.
Okay, what's next?
Judge, we have some exhibit specific issues.
Denied.
Given the number of exhibits, so not that many. But we were back and forth on the weekend on some of it is the language.
Are we talking about the neutral statement in the
Yes,
Excel
yes,
spreadsheet?
yes.
Okay.
Oh my God. Oh my
um,
God. Yes. Allie, thank you for catching that. Wait. The law enforcement officer called the cops interview and interrogation because he knows what he's talking about. He knows an interrogation when he hears one.
Exhibit 2165, Judge, is the access log, and that's fine. But then for 2165A, which is just one page of it, they want to put Johns Hopkins All Children's Hospital access log. I'm fine with that. Access, Dr. Sally Smith, that she accessed it that day. I'm saying you don't get to put why you put the access log in. It should be just Johns Hopkins All Children's access log 10/8/16.
You know, Ms. Lawrence, you're going to be making this argument. Just to forewarn you, you're going to come up and you're making this argument. You're an attorney. You get to make the argument.
Judge, so that's the issue.
Ms. Lawrence.
They want to say why they put it in, that Dr. Sally Smith accessed it that day. I'm saying just the date of the access log gets put.
Is he seriously calling her up to make this argument?
Is that we're talking about?
It'll be her first argument in front of a judge
I
ever.
don't know. Clay, can you put up? It's your-
So Mr. Cottrell's computer just crashed. So Mr. Reyes, can you help us out real quick?
He's got a computer issue like I do.
I don't know. That's what I lip read over there. Am I correct?
Yeah, it's restarting.
Oh God, the
Sure.
judge lip reads.
It's defense exhibit
Better watch out, everybody.
2165A.
What was
Okay,
that?
Miss. Well, let's bring up the exhibit so I know what we're talking about.
I can't believe Anderson almost gave in to
So,
that.
Judge,
Which page of this?
That is just one page. It's 2165A. They put in the whole access log as 2165. They put this in as A. It's the access log from a particular date. I thought it was 10/7.
Miss Lawrence is the new attorney who
And we
just
just say
passed
the
the
date
bar
should
on
be on there.
Anderson's
They want to
team.
put that this is the date that Sally Smith accessed the log. They want to put her name.
Well, do I see Sally Smith's name on here?
I think it's on there somewhere, Judge. My objection is that we've been neutral on all the other
Well, I see
things.
Matthew Higgins.
Yeah, there's other people. That's correct, Judge.
Right, but what I'm saying is, I'm not seeing Sally Smith, so is this the right page?
Oh, it should be. It's 2165A. That's what they.
What's the internal page number?
There's 234 pages, Your Honor.
Which page
Oh,
are you on?
sorry, my fault. My fault, Judge. 71.
71.
Okay, Ms. Lawrence, your argument.
Oh my God,
It's
she's
a
gonna get to
factual
do it.
issue. It doesn't say that Sally Smith is an apparent agent. Everything else has been redacted, right? On the
Other
rest of-
pages,
on the
yes.
other pages. This is to orient the jury to see Sally Smith's name.
Anything else, Ms. Carls?
No, Judge.
I mean, the whole point is to help the jury find things, so I'm going to agree with Ms. Lawrence's argument. We can leave in.
Ms.
Sally
Lawrence
Smith.
wins her very first
So
argument
what
in front of
exactly
the
are the
judge.
wording? So I have 10-8-16, and then you just want to put Dr. Sally Smith, access the log? I mean, Judge, that's,
I have a feeling that that's why he wanted Miss Lawrence to make this argument, because he knew he was going to deny it.
what is the exact wording you would like?
I think however Kelly has it on there is fine.
Well, I don't have that because I changed it. Just put Dr. Sally Smith? Is that acceptable?
It's, you already said it was access log hyphen Dr. Sally Smith.
It says John Hopkins All Children's Hospital Access Log dash 10-8-2016. And then we can add Dr. Sally Smith.
Yes.
If that's what you would like.
That works for me.
Okay. The other one is, so Judge, to aid the jury, we
So,
broke
Judge,
down
Judge.
the hospital
way she says
admissions
it.
with neutral indexes. It's just what they're called, right? So we did it for the joint exhibit for the hospital. And then we did it also for Lori and Tampa General Hospital records. Their objection is that it's not done for all of the records and it gives emphasis to these records. My response was break out what you want. If you want other records broken out so there's an index so juries can find the discharge summary, or they can find consult notes or whatever, feel free to do that. They said we don't have time. So their objection is that on 3032, we broke out, and I'm happy to show that, Your Honor.
Yes, please.
The
If I
judge.
could-
Yeah, please show me.
So you can see on 3032, for an example, we broke out
That was really cute of him to let.
simply giving an index to the jury
Oh,
where to
oh, my
find the
ears.
particular title of those documents with no description or anything. We also did it for 3047. Their objection is that somehow gives emphasis to those records. We were just trying to aid the jury. They don't object to the joint exhibits that were done, which were the Johns Hopkins records.
Ms. Lawrence.
As long as we're free to specify everything else, so we're okay with it, but it's gonna get pretty convoluted if we start.
When you say specify.
Yeah, I don't know
everything
what that
If
means.
we're parsing out every other exhibit.
No, just the hospital records.
Within these two hospital, or are you talking about other
All of
locations?
them, Eagle Springs.
Well,
Shot again.
Judge, again,
It's gonna take a while.
let's be clear.
Well,
These are massive hospital records, and all we did was put an index where to find whatever the document was titled.
I am, here's, anything else, Ms. Lawrence?
No,
Here's where I'm at. I am fine with what the defense has done for Lurie's and
Tampa
Tampa General. If the plaintiffs wish to do something similar before we come in tomorrow morning and it gets incorporated into the list, knock yourselves out, but do not make it argumentative. Do it very generically, blandly, like the Ms. Croyles.
Yeah, Judge,
stated.
I would suggest it needs to be limited to records that are, 500, 600 pages, the hospital records. If they're going to start breaking out every index for the Eagle Wings, I mean, that's going to make this 300 pages long for one. And we're going to have to go back and do that. I mean, I don't understand their objection to the hospital record being done.
Are what is the
Yeah, what is
scope
it?
of the
Yeah. documents
that are in evidence that you're contemplating having some sort of breakout in?
Dr. Gannon.
Whoops, I was muted like a boomer. Okay. I was saying, Tara, thank you for the Venmo, the $10 Venmo. She says, can we call the defense Gotchagate? Because that's all that they have done. They have had a lot of gotcha moments, or at least that they thought they had. but weren't. But thank you for the Venmo.
Eagles wings, Shauna Duncan.
How many pages are there each one? Are we talking more than 50 pages, more than 100 pages?
Judge, that's a completely different category. These are hospital records that are like, how are you going to break out Dr. Kirkpatrick's with some neutral thing? Office visit of, they're going to detail every office visit. I mean, we'll take it back. We were just trying to aid the jury when they go to these records. Where's the console? Because they have hard copies. They can't search them.
I think we're going to give them a flash drive, I thought.
But that's going to search this. It's not going to search the records.
Correct. So, which is why I am fine with adding the detail that the defense proposes. And I'm also fine if the detail, if the plaintiffs wish to do this.
All right,
make sure
guys.
it's in
I think we have heard all of the exciting stuff that I care about today, that I can stay here with you. And this is it. My time is up. I've got to go. I have mom stuff to do. I have laundry to do. I've got dinner to make. And it is past 5 o'clock. I have been here for 8.5 hours and I just can't do it anymore. So if you guys want to go over to, Recovery Addict is still going. So I will redirect you over there for when we are finished here. I just want to let you know what's going on coming up. We will be back here tomorrow. I will be back here tomorrow for sure. And we will be doing, let's see, where's Recovery Addict? We will be doing more live coverage tomorrow. I will try and be going early like I was this morning as well. So we get most of it live, okay? Wednesday at 1 o'clock, Robert Barnes is going to be here with me to discuss the Wauwatosa lawsuit and the settlement that we've come to in that case. Spoiler alert, Wauwatosa did not get anything out of it. But we're going to be talking about that case and and reading the public apology that they had to send me, the school board of Wauwatosa. So that's Wednesday. Thursday, Friday, still don't know we don't know how long when the jury is going to be deliberating or how long. But let's just remember to show up back here tomorrow. Why don't you guys go check out Recovery Addict and watch the rest of this if you're interested. His chat is always great, and so is his coverage. Just remember, you have to behave yourselves over there. It's not us. You gotta easy on the name calling. You can come back and do that here tomorrow. All right, guys, take care. Love ya. Can't wait to see you again tomorrow. Have a great day. Remember, follow me on meganfox.locals.com.
I was lost, my world is near its end. I almost felt my head is full of a million choices. I am alive, I'm not here to pretend. I love my friends, my heart is filled with a million voices. Oh, this road has many choices. Oh, and my heart, million voices. Come next to me, my friend, embrace the sky. I'm not afraid to fly. It's not the time to say goodbye. I don't wanna say goodbye. me, my friend, embrace the sky. I'm not afraid to fly. It's not the time to say goodbye.